Okay, people, we'll start. So we'll start with the marathon. So how is your preparation going? All good. Happy. So we are doing marathon for group 1, paper 3, part 2. Starting here. It's paper 3. What is paper 3? Setting of business and industrial and labor laws. So we'll be doing that part, which is industrial and labor laws. So why this subject? Why this particular subject? Why this concept of labor laws? Two-sided. One, you are a KMB, you are part of the management, you are part of the employer. Flip side, you are an employee. So both sides, this chapter holds an important weightage. So to start with the concept, labor laws. Labor laws is one easiest paper. They ask straightforward questions where you can write and score well. This can be one momentum paper which you can use as a tool to clear your exam. Now, why labor laws are important? Why labor laws are important, and how I am planning to do this marathon. So marathon is usually something two. There can be different crowd. One, people are here to learn. There can be people who are here to learn, just to learn. There will be some people who are here to revise. Okay. There will be some people who are here to get themselves motivated. Or at times, there will be some people who feels that I'm not alone in this journey. Marathons are meant for that. There will be people who are working and doing parallelly, they'll be preparing for CS. Similarly, there will be housewives taking care of kids and doing a marathon just to brush up or just to feel that they are also in the track. Okay, there's someone who's there to guide them. Okay, so let's go with the marathon. Marathon, especially why labor laws? Labor laws is one easy paper. And this being my first marathon for CS Executive, let me know if there's something which I can do to make it better. Now people, labor laws, we have many chapters. Each chapter is important. Every chapter has the same way it's important. So to start a labor law, I'm not focusing on lengthy chapters. I'm focusing on small chapters. The same way I do the thing in the normal class, where you finish small chapters, you gain a confidence before you go to a step into a bigger chapter. So gaining confidence is very important, and I believe instrument material is the best. So revision also we are going with the instrument material. Okay, to make sure that with instrument material, selective reading you can clear. Okay, now let's see why this law is important. Why marathons, especially for a labor law, is important. So labor law may be boring to read, do it as self-studying mode, but to a marathon, if you've done something, it will brush up your existing knowledge or even get your clarity on, oh, this is the right way to approach the paper. Okay. So now, why labor laws are important? Why do you think labor laws are important? Point number one, India, after independence or before independence, like before independence, there were some colonial rules. There, after independence, we had constitution, then various interpretations, various case laws through which the labor force has been governed. Now, why labor force has to be governed? India being a developing country with a highly populated thing, highly populated, unemployment rates are on a peak. We need labor force to do business. At the same time, since the labor force is more, employers might exploit us. So someone should be there to protect us. So labor law is something which will be with you from the day one you start your office till you retire. Okay, it's not the employer, it's not your colleagues, it's not your friends or family. It's just the labor law which is going to be with you hand in hand, accompany you towards to the entire journey. So why labor law? Because these laws are added in the our study material as well as in the history of India because of various struggles, various labor strikes, various fights over justice, various problems, various occupational hazards, various dangerous like Bhopal tragedies. Because of this, labor force in India should be properly governed. If not, who will tell you? Who will? What if they say you have to work on a Sunday? Who's there to regulate that Sunday is off? Who says you need not work overtime? Who says if you are being terminated, you should get a compensation? Who's there to get you? So, since in the country where unemployment is at peak and employers are designing everything, what if it is hurting the sentiments of usual human beings? So labor laws are designed in such a manner that it will help people understand their rights. So as I told you in the regular class, labor law is not just written in ink. It's written on various sacrifices, sweat, or even blood of people behind such efforts, which are like always highlighted in the pages of history. So let's start something called as labor law. So what I'm planning is, let's start with the study material, very small chapters, then we'll go to the big chapters. Okay. Now people, to understand labor laws, we should know why labor laws and how labor laws have been framed. So our constitution, which is the fundamental rule or book of the land, they says, let's design three things. One, a legislature, an executive, and a judiciary. Legislature, the lawmaking power, is being distributed under various lists. One, union list, state list, and concurrent list. So union list is something where central can make laws, state list where state government can make laws, concurrent list where both people can make laws. Now, why it is important to have that in concurrent list? Say for example, India is a place where we see unity in diversity. Now, you don't see Assam worker and Kerala worker the same form, the same way they are working. It can be different. Even though they are within India, there can be difference with respect to sunrise time, sunset time also. So India, the law should be made in the central level as a skeleton, just a skeleton. So this is skeleton and been handed over to different state governments so that they can add muscles, flesh, as the case may be, depends on their state. So being an item in concurrent list, it's central government who draft the same, given to state governments to add flesh according to their particular region. Okay, so now constitution gives you power under concurrent list for central government and state government to make laws regarding this particular labor one. Then when we go to first chapter, we'll have that chapter where they say constitution and labor laws, where they explain what are the different provisions of constitution to do with your labor part. First part, starting with the preamble, it talks about what is the necessity of having a labor law because government is focusing on a socio-economic growth. Second, say there are fundamental rights like equality, prohibitions, discriminations, etc. So those things will help you to understand that labor force should be properly covered. Labor should be protected. Similarly, there are directive principles of state policy. What are directive principles of state policy? It's given as a direction in the constitution, which will help the country, the state. State means the country. State means the country to make laws in such a manner that everything is properly done. So one of the main principles of directive principle state policies, state should be looking forward to create a society which is like socially good, ethically, morally good. So in order to have that, there should be a blend of employers and employees in such a manner that that our labor force are not being exploited, ensuring them a proper, healthy, safety working environment. So different laws are here. Let's start with different laws. Then we'll go to the constitution and its impact. Then we'll see what is a new labor law, new reforms coming. Because why new labor law code is coming? Because what about a Swiggy driver? What about an Uber person? We don't know how to, because these laws are very old. You see the Factories Act 1948, very old. How do you expect a human being to interpret those in the current scenario of 2024 or 25, as the case may be? So to come into that modern world, we need a labor code. That's last part of our journey of this marathon. Now let's focus on our chapters. We'll start with the smallest chapter, small to the biggest. That will be our motto. We'll start with Equal Remuneration Act. So people online, all good? We are starting with Equal Remuneration Act. People, when you are reading from study material, ensure that it's a selective reading. Make sure it's productive. Do a proper selective reading, because I want the institute material to be read before you go for exams. Direct questions from institute material, nothing more to worry. Okay. So Equal Remuneration Act. Okay. People, selective reading, see 2 pages, we're done with this chapter. Okay. People, study material also, you have 2 section numbers, very important 2 section number, that's all. 2 sections are very important for this chapter. Now people, why Equal Remuneration Act? So as I told you, Constitution has given powers under its preamble, fundamental rights as well as directive principle of state policy that government should try, or state should try to ensure that you have a proper way of regulating the labor in the country. So different laws have been framed. One of the laws is Equal Remuneration Act. So Equal remuneration is not a fundamental right. It's coming under directive principle state policy, where they say this 39D of the Constitution of India, which mandates that men and women should receive equal pay for equal work. Meaning, under our Constitution, this part, which one, directive principle state policy, where Constitution is asking a state to frame rules which will be like, whenever you are paying a payment to both men and women, it should be equally. So that is not a fundamental right. It is actually a directive principles of state policy item. So in your chapter, you will have that item. You have to focus on only 3 points under this chapter. So they can ask you how Equal Remuneration Act has been governed, or what is the role of an employer with respect to Equal Remuneration Act. So in order to know Equal Remuneration Act, we should know why Equal Remuneration Act has been enacted. Why Equal Remuneration Act? It's because in India, still at some places, we don't pay equally to men and women. Okay. So people, men and women should be paid equally, unless otherwise stated. Why unless otherwise stated, we'll discuss. So men and women should be paid equally. Now, under company law, why do you think there's a role of independent directors? There can be women directors as well. Why women directors? It's you people say it's woman empowerment. I say it's woman who is going to. My mom take care of the family. She can better take care of the company as well. That's the logic. Now people, under companies law also, they have stated that independent directors, women directors, sitting fees should not be paid at an amount lesser than the normal directors, meaning they are ensuring an equality kind of thing. Similarly, for a work, you should be paying equally to both men and women. So now the question comes, sir, how do you think you have to pay them equally? So now law says, I'm not saying pay them equally. I'm saying pay them equally when it's same work or work of similar nature. So only one definition which you have to understand from the study material. People have a study material in hand. Same work of similar nature means a work in respect of which 3 points. So to have whenever a question has been asked from this chapter, small chapters also they can ask, you have to write an intro on what is same work or work of similar nature. I'm not asking you to mug up the concept, to give an introduction to the topic. Then come to the provisions. Okay, people, very important to underline when you write the exam. Underlining is very important. Make sure you are having a clean answer. Try to write for all the 8 questions, 40 marks, easy questions. Now, so means same work or work of similar nature means work in respect of which skill, effort and responsibility, 3 points. Skill, effort and responsibility required are same when performed under similar working conditions. Okay. Now, that's a point. All of that. You have to understand the concept as it is. They say the point is regarding Equal Remuneration Act. Okay, sir, Equal Remuneration Act. Now, the point is same work or work of similar nature, means a work in respect of which skill, effort and responsibility to be undertaken by men and women under the similar working condition, under the same room temperature. You people are working, same skill required, CS with 3 years experience, then skill, response, everything same. You should not be having a difference when you make a payment with respect to them. That's the purpose of this law. Online, good. Okay, people. So one more point added here: act to have overriding effect. Okay, so my first note, I'm yet to check whether this note is good. First time I'm seeing my note. I prepared, but I haven't cross-checked. Yesterday night I prepared everything. So act to have overriding effect, meaning notwithstanding anything inconsistent there, meaning nothing da. Say for example, there is some other law in the country talking about equal remuneration, this, that, can be paid less, can be paid more. Law is telling you, hey, the constitution has given me something under concur list, based on which we have drafted a law called as Equal Remuneration Act. Notwithstanding any other point covered under any other law in India for the time being, I will have a overriding effect. So I'm very powerful. So now, how is this power being affected? 2 points. 2. Okay. People, 2 points to understand. Actually, 3 points. 3 points to understand. 1, 2 and 3. This chapter is regarding what is the duty of an employer. Employer, person who is giving the work. What is the duty of an employer with respect to Equal Remuneration Act? Okay. First point. Employer shall pay to any worker employed by him in the establishment or employment remuneration, whether payable in cash or kind, at rate less favorable than those at which remuneration is paid by him to the workers of the opposite sex. Meaning, you are paying to a male the same way you have to pay to a female worker. You have to, employer shall pay to a worker employed by him in an establishment of employment remuneration, whether payable in cash or kind. At times you can pay in cash, or like a wheat, sugar, etc. you can give, so like a subsidized thing, like a food, like cash value of food concessions you can give. Those things whenever you are giving, you should not be at a rate less than favorable to the thing paid to an opposite sex. First point. Okay. Second point. Okay, sir. Now, for my men, I am paying 100 rupees. For female, I am paying 80 rupees. Oh, law is saying me to pay equally. Okay. Let's keep it as 80 for male. Law says no da. Second point, very crucial point. For this purpose da. the employer shall not reduce the rate of remuneration of any worker. So 2 points hidden there. One, you should pay equally for the opposite sex as well. Second point, for this purpose of complaints, don't be an overconfident person. Come reduce this to under kind of thing. Don't do. Keep the women workers at par, not the male here to compensate your law. Done na? Now, next point, discrimination not to be made while recruiting. Third point under this chapter, another obligation of employer. Employer, while recruitment for the same work or work of similar nature, or in any condition of service subsequent to recruitment such as promotion, transfer, etc. Meaning, at the time of recruitment or even training or promotion, there also you should make a discrimination against women, except where employment of women in such work is prohibited or restricted under law. People, you should not make a discrimination with respect to hiring people as well as recruiting, promoting, training also. Okay, except when employment of such thing is prohibited. Say for example under Factories Act, if you see, women and child are not allowed, prohibited to work under cotton openers. Correct? So in a cotton industry there is a restriction under Factories Act, meaning that is allowed. Now you cannot come and say, sir, I'm a woman. Why did you do that? Why are you discriminating us? Some other law is saying that yes, there can be discrimination. Here is it, they are saying some other law says you can't have that women there. You can have a discrimination there. Otherwise, no. Similarly, section shall not affect any priority of reservation of scheduled caste. Like under your constitution, government has been given power that you shall not have a discrimination with respect to race, sex, caste, etc. But for uplifting these people, like a socially, economically weaker class, you may have reservations for SC, ST. That should not be called as a discrimination, because you cannot have a law which is overriding constitution. Done na? You can have not below the rank of labor officers to decide on the subject matter with respect to this law. Okay. Now one more point is been added, which is maintaining a register. You have to maintain a register for this thing. Registers are also important. So when they ask a question regarding what are the obligations of employers, one question, give an introduction on same work of similar nature, intro. Okay. Then come straight to 4 points. What are the 4 points? 1. Employer shall not have a discrimination with respect to payment to the opposite sex. Second point, for the purpose of this complaints, he cannot reduce the wages. He cannot have a discrimination with respect to recruitment or promotion, training, etc. He should maintain a register. 4 points put together, 1 question, solid. We are done with this chapter. People online, one chapter sorted the okay marathon but effective. Good people online. Okay. No. One chapter sorted the. Now let's see. Loading time of study material is taking time. That's why I'm taking from this note. But read from study material, people. Very important. Okay. Now, people. So laws are made with respect to equal remuneration. But now let's see another law where you people told me, no, sir, AC is so chilling. People, you told us, no? You people, hey girls, you told me, no, AC is very chilling. Why? Romba kulirda? Chilling. Okay, now, people come close to me. I'm very hot. Come close to me. I'm very hot. You know, I'm very hot. Come close. Okay. Now what will you do? Okay, sir, I will come close. No, you will get offended. Now, sir, whether laws are really there to protect us from such kind of stupid dialogues? Stupid dialogues. It's just a remark. Yes, welcome to prevention of sexual harassment at workplace. Okay, chapter number 20. One important law. Okay. 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 Now, people, to start with your sexual harassment act, you should know that. Again, I'm touching articles. Article 14, equality. 15. What is 15? 15. Constitution of India. 15. Discriminations. 21. What is 21? Right to live. Right to life. So 3 articles. We will be discussing this in detail under your first chapter, which is 14th chapter. So they say you have a right of equality. You have a right not to get discriminated. You should have a life to freedom to live with dignity, respect. So our workforce in this year, where our women empowerment are going in such a manner that people are coming to work. But do you think they are safe? There should be a law to safeguard them. This happened because of one case law to remember under this chapter, which is Vishaga versus State of Rajasthan. Okay. So Vishaga versus State of Rajasthan is one instance where Vishaga is not the victim. Vishaga is just a association of people who filed a case. So what happened is there was one child marriage happening in a place. Okay. The officer in charge, she rejected. She filed that. She was like, she started fighting against that. People did a rape against her, who was trying to stop a child marriage. So that became a landmark thing. Because of that, law had to give a definition of what is sexual harassment and why sexual harassment at workplace is very important. Now, why sexual harassment at workplace is very important law? Because sexual harassment at the workplace can happen verbally. It can be through a Zoom meeting in the modern era. So we have Sexual Harassment Act to curtail all these things. Now, a sexually inappropriate remark can be emotionally hurting her sentiments. Her productivity can change. Her family life can be affected. Why? In an employment, she'll be expecting a promotion coming. Now, if I file a case against my employer, that's going to have a negative impact in my growth. One side, negatively it can affect. So, people usually don't go for a complaint. But in this modern era, since this law has been drafted, enacted, which has been coming into full swing, people started filing a case. Meaning, 2 scenarios. One, number of cases in India has increased drastically. Or flip side, you can interpret that people are having the faith on this particular law. 2-sided. Now let's see what is this law. This law is to have what is sexual harassment. So 2 things you should be knowing what is sexual harassment. You should be knowing sexual harassment at where? Workplace. So the law is regarding sexual harassment at workplace. Prohibition. So you should be knowing sexual harassment, how it should be prohibited in a workplace. Now, you have to understand, first point, what is sexual harassment? Very important. Physical contact and advances. It can be physical contact and advances. Okay. Demand or request for sexual favors. Sexually colored remarks. Commenting on someone's dress, lipstick can also come under this category. Showing pornography can be another risky factor as an employer. Any other unwelcome physical, verbal or non-verbal contact of sexual nature, like come close, you'll feel hot. AC chill, sir, can you just turn off the AC? No, you come close, I'm very hot. No. These things can attack the emotions. So people say, let's have something called as sexual harassment. Let's define something called sexual harassment, which includes, meaning it's a very extensive definition. It can be brought under the light without these limited. It can be many points, many things, as and when the country is growing, the particular labor force is working, more labor is coming, more kind of work from home kind of thing is happening. We should be able to accommodate all those things. We are having an inclusive definition where they talk about everything put together. So first point which you have to remember under this chapter is knowing what is sexual harassment. It includes physical contact and advances, demand and request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal or non-verbal conduct of sexual nature. Okay. Why this rule? To tell everyone that physical contact is not essential. It can be verbal also. Okay. 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 People, there can be forms of workplace sexual harassment. Okay. Study material has this point. 2 points. One, quid pro quo, meaning something in return. Your consideration, contract activity consider something in return. Meaning, I will like, hey, remember, if you do these sexual favors, you'll get promotion. Oh, super. Quid pro quo. Or, hey, you know I'm the boss. You are in the immense pressure. You have a family to work. If you don't do a sexual favor, your working environment can go bad. So it can be negative or it can be positive also. Promotion kind of thing offering or a negativity can be there. So both things will be emotionally damaging the health, mental health of a employee. Now people, though we talk about sexual harassment at workplace, the law is talking about sexual harassment of women at workplace. Men, you people are to be aware. It's not about interpreting things. You should be knowing what will constitute offense under the law. This law is to protect the women in the country. Okay. Now people, you should be knowing 2 definitions. One, aggrieved woman as well as a respondent. Not there. Respondent is in a study material. Aggrieved woman versus respondent. People, your issue is between your study material. You will have a respondent. Respondent means person against whom the issue has been filed. Yes, aggrieved woman is nothing who is like frustrated with such instance. Such instance who got frustrated. The person is called aggrieved woman. Now, to cover everyone, we thought let's have 2 definitions. Aggrieved woman, 2 parts. One, people, there will be people who are working in an office, exploited. Let's call them aggrieved women. Similarly, there will be some people who are working in as a housemaid. Now, what if the employer over there or the owner of the house is doing something, exploiting her? Now, aggrieved woman under the law is been categorized into 2. One, in relation to a workplace, a woman of any age. Why da? Any age. People, it can be child less than 4 years, or see, there will be some museums where they exhibit the dress, not the dress, but the dress of the victim, just to prove that age is not a bar. That dress will have the dress where they were wearing. It can be a child with a Cerelac box, or it can be a party, a grandma with a sticker, because in our country it's not safe. That's why they are saying of any age, whether employer or not. Why whether employer or not? Because what if there's a customer coming in to the place, or you people are undergoing training, you are not an employee there, you go for a client place. What if something happens to you? So whether or not, whether you are employed or not, who alleges, meaning who claims to have been subjected to any kind of sexual harassment by the respondent. One place. One part. Second part, in relation to a dwelling place or a house. Woman of any age who is employed in such dwelling place of the or a house. Any woman who is working in that dwelling place. Okay, huh? Okay. Okay, employee, employer, blah blah blah. Now people, employee can include co-worker, contract worker, professional trainees, etc. Apprentice also. So people, it can be anyone working in the with the employer who can be an aggrieved person, aggrieved woman. Okay. Now people, let's see. Okay. Let's see workplace. Workplace. One of the important concept to be remembered is workplace, because the act talks about prevention of sexual harassment at workplace. So the first question, can it be what is sexual harassment? We're done. Second point, who's an employee? Who's an aggrieved person? The employee we have seen. Now third point, what could be the workplace? Okay. So workplace can be any department, organization, undertaking, establishment, enterprise, institution, office, branch, blah 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 blah. It can be anything. Okay, sir. It can be hospitals or nursing houses. It can be a sports institute, stadium, sports complex. It can be any place visited by the employee arising out of during the course of employment, including transportation. People, important. Including transportation, meaning you are coming to office in your vehicle. I don't care. You are coming to office in the two-wheeler cab provided by the employer, meaning the transportation in which one of your co-passenger or the driver has done something. You can also still file a case against them because it can be transportation. So interpretation should be like this: you are traveling in a public bus, don't consider it as a sexual harassment. It should be related to your work, a dwelling place or house. Okay. Okay. Now people, now one more question they can ask you is one more case law. So under this chapter we have to remember two case laws. One, Vishaga versus state of Rajasthan. Good. Now one more people, we have seen workplace. So when someone is asking you workplace definition, they don't ask workplace definition. They can ask a complex scenario regarding workplace. Say for example, today's modern version requires like work from home. Okay. Now in order to have that, previously it was, we never thought in this 2013, we never thought of 2019 work from home. This is 2013 Act. Work from home is 2019 after COVID-19. Now we thought we'll have more points to be added. So one issue came under Saurabh Kumar Malik versus Comptroller and Auditor General of India. You have the case law. People understand this case was regarding what is the extension of this particular workplace. Extension of workplace. Workplace we have seen how much it can be broadened, how much it can be zoomed in. Okay. Now High Court observed that the following factors should be bearing whether it is workplace or not. It happened because there was a sexual harassment happened where the which plus the it's not given official mess. People, one, it happened in the official mess, not at the workplace but a mess, sexual harassment. Now people were like whether I should cover that also in this law. Okay. Yes, they said you have to remember these 3 points extra. So whenever a question is been asked on workplace under sexual harassment, whether the workplace under sexual harassment is limited or will they have a wider scope, such kind of broader question can be asked, right? Sexual harassment at workplace has a wider definition after Saurabh Kumar Malik versus Comptroller and Auditor General of India. Okay. Now they said what was outcome? Official mess is also included in the definition of workplace. Now to know whether a workplace is connected or whether this particular place is connected to a workplace depends on 3 factors. 1, proximity from place of work, whether it's near to your workplace, proximity. So 3 words da. Whether the place is under the control of my employer, my manager, or such place no residence has been an extension or contiguous part of working place. Third point, whether such is extension or contiguous part. 2 ways you can interpret, whether it's related to your factory or psychologically interpret. Extension, you're going home, work from home. In a mail, there's a sexual remark, or in a Zoom meeting, there's a sexual remark. It's connected to your work. It's an extension of your work. These things can be covered. So interpret accordingly. Start interpreting accordingly. It can be 3 factors extra to give that proper answering to that question. Okay. To the question, the simple, write few points. School, college, nursery, everything is covered. But it's not limited because of this particular case law. Saurav Kumar case law. Right? Saurav Kumar Malik. Okay. Now write these 3 points. What, sir? 1. Proximity from work, control over the management of that thing, and the residence has some extension or contiguous part of our working place. If that be the case, even a place which is not even straight away connected to a workplace can also come under the definition of workplace. Okay. Now people, this law, okay, this law talks about 2 factors, 2 people. 1, there can be 2 kind of sectors in this field. 1, a proper organized sector or an unorganized sector. Okay, organized sector, unorganized. Act applies to the act applies to, people say it's introduction. In introduction they say 10 or more. But I tell you, it's not 10 or more. It applies to anyone. If it's 1 also, it's covered. But why 10? Why 10 or more? And why the point of 10 is important? 10 or more. And I say it's applicable for irrespective of number of employees. Now, why this law is important? Say for example, your number of members is less than 10 or more than 10. Still applies. So then why 10 is important? Now comes, in order to give power or to know why such 10 is important, you should know 2 requirements of this act for an employer. 1, to have an internal complaints committee. People, you should have an internal complaints committee. Okay. Now 10 people, each office or branch or organization employing 10 or more employees, you should have an internal complaints committee to hear the parties decide on the subject matter. So if there is a sexual remark against an employee, first instance he can approach something called as internal complaints committee, provided the number of members are, the employer should have constituted an internal complaints committee if number of people working in the organization is less than 10 or more. It's internal complaints committee. So it should be 10, then there should be a internal complaints committee. Okay people. Now people, who will be covered? So the question can, from next part of this question chapter can be, what is internal complaints committee and what is its composition? Okay. So there are few points to remember. The next question might be about the internal complaints committee. Sardi, happy? All good? Maida. Okay. Okay, people. Law talks about having an internal complaints committee. They say whenever you have 10 or more people working, 10 or more people, 10 or request employees. They never said it's 10 or more women workers. Correct? Interpretation. So it's 10 or more. So if it's 10 or more people, you should have a committee within yourself, so that whenever complaints come, let's settle it amicably, peacefully, without going straight away go to police. Come here. If I say police, now tomorrow there's an issue happening. Suddenly they will go for a strike. Employer will lose revenue. Employees will lose revenue. Let's have an adjudication or some kind of dispute resolution happening within the organization. So whenever you are having 10 or more people in your employment, the employer should mandatorily have something called as internal complaints committee. Okay, sir. He should have a presiding officer. Oh, sir, presiding officer, president. Who is the president officer? It's a senior level amongst the employees. It should be a okay. So usually the presiding officer shall be senior most. It should be a woman from your group. Sir, what if my building is not having? Then you have some other branch. There you have a senior. Ask her to come. So what if I am not having there also? Some other establishment also you can bring in. That's called presiding officer. So then you should have members, not less than 2 members, preferably having knowledge of social work or legal knowledge. Okay. Now people, one more external member, some non-governmental or some association committed for the good thing of women. So that's how your constitution should be. It should be minimum of how many people now? 4 people, and at least half of the total members shall be women, shall be nominated by women, shall be women. So people, remember your internal complaints committee should have a presiding officer who is a senior level employee of your organization, then 2 members with some legal social backup, then external member who is coming out. You people can also be a company secretary in practice. Women usually can be that external member, provided that half should be, at the end of the day, half should be women. Then now people online, good, thumbs up, all good with me? Okay. People, next point, one more point to add. If you remember, the tenure of office shall not be more than 3 years. 3 years varaikku you can sit in that office. The tenure of the entire internal complaints committee is 3 years. Okay. So people, external members, you have to pay fees. Why would they come? So either you have to pay fees to the external members. Others are within your organization, you need not pay. External members, you have to pay fees. Now, there can be a vacancy, or you have to step out of the organization when you are contravening the provisions of section 16. He's been convicted, like he itself is a party, then you have to go out, found guilty of any disciplinary proceedings, or he has abused his position. If that be the case, law will ask him to vacate. All these people should vacate when you are contravening the provisions of the law, when you are convicted for an offense under this thing, or you are found under a disciplinary thing, or you have abused your position as a complaints committee member. Okay, good. Now people, sir, now Sarthi has a doubt. Sir, you are telling me that less than 10, no committee. Hey, more than 10 only it will be there. Now law says, if you are having more than 10, you should have internal complaints within. What if it's a less than 10 or an unorganized sector? Let's have something within the state, within the district, within the government's purview, something called as local complaints committee. So don't worry people, you are working under an employer. The total workforce in the employment is 7. Sir, I got a sexual harassment report. Whether there is an internal complaints committee? No. Whether you can approach somewhere? Yes, there is something called as a local complaints committee. Okay. Okay. People, very important point. Unorganized sector. Point number 1. So you are working in unorganized sector or less than 10 employees. Point number 2. 1, 2. Or third crucial point, people. People, I have 25 people. I have internal complaints committee also. But the person against whom I have an issue is the employer himself. Now if I go, the case won't come into the your light. They'll make sure that the case has been dismissed kind of thing. So law says 3 points you should have you have an access to local complaints committee. When, point number 1, you are under unorganized sector, number of workers are less than 10, or the complaint itself is against the employer. Huh? Dwelling, yeah, correct. Yeah, good. Dwelling place also is covered here. Okay. Now, people. No. Employer means the owner. You are filing a case against the managing director, like the management team. So if you go with them, it's not going to be good. No, but ICC who is making a payment? Except that external member, others are being governed by the team within you people only. No. What if they are favoring the employer? Okay. Now, appropriate government. People remember, appropriate government can be state government, central government. Depends on how you can make laws. May notify a district magistrate or a district magistrate. Okay. As a district officer for every district to access. Okay. So, the law is empowering district magistrate or additional district magistrate as a district officer for this thing. District office has been taken. Okay. Every district officer shall consider a district concern committee known as local committee. Meaning, local committee should be for every district. Thereafter, you should have this person. No, district officer can designate, like ask one person for every block, every taluk, every tahsil, every tribal area, etc. So I come under a corporation, district, but I have different villages, panchayat, etc. Let's assign different peoples to these people so that he will get access. Because under Indian complaints, it was only my company. In a local complaints committee, it's 100 companies, 300 companies, 4,000 employees within the local limits. Correct? So to have a better grip on the issues, I should have sub people or sub units under me. So I can delegate my powers to different people for different taluks, etc. Okay. Now people, remember, composition. Remember your internal complaints committee, it was presiding officer. Here it's chairperson. One slight point. Should be an eminent woman in the world of, in the field of social work and committed to cause of women. Meaning, you are there, the presiding officer was the senior most employee of the organization. Here, someone should have the in the field of social work and committee, like some kind of commitment to the cause of a woman. Such kind of person should be your chairperson. Then, okay. Second person. Who is the current? Ex officio means current. Social welfare or women of child development in the district. This person should also be your party. So first person shall be an eminent woman in the field of social work committed to the cause of women. Second point, there should be social welfare or women or child development officer, current person, to be a part of your committee. The three, you have two people. Two extra people should be there. One member nominated from the block, taluka or tahsil, like your panchayat person maybe. She is capable, you have her. Or one person should be like a scheduled caste, scheduled tribe. So these people will form your local committee. So local committee should have people like this. One chairperson who is a woman of subject expertise, having commitment towards the social cause kind of thing. Then there should be the current welfare or women child development officer. Ex officio is current position, not the ex officio, not the past person. Then one member from your block, taluka, etc. One person representing the SC ST caste kind of thing. For those people also. Okay. Huh? Two members, one point is two members. No, that two members is people. Correct? Total 4 le. Total 4. Adile 2 one is this 2 members, one is Taluk Panchayat and all, one is SCST. That's 4.
From Talika should be there, sir. 2 members into one from NGO and another one from legal background or from SCST.
Okay, correct. Legal background or SCST. So you mean to say there are one more person?
No,
4.
one chairperson. Second one member from Talika.
Huh.
2 members Kandika Irukonu.
Huh.
Two members at least from NGO.
Okay.
அது ஷுவரா இருக்கணும். நெக்ஸ்ட் ரெண்டு வந்துட்டு ஆப்ஷன் கொடுத்திருக்காங்க. At least one woman from legal background or at least one woman from SCST.
Okay, still. Then 5 should be there, no?
ஆனா இது வந்துட்டு anyone.
Correct. That's why I say 4. It should be any person. NGO. That 2 people among the members, and one shall be part of SCST or legal backup.
That not should be different, right? Either it should be men. One of them should be women. At least one.
One of them should be women. Need not be, but you should have. Remember, you should have that half male. You should be having women. That's all. That's a general provision where you do. But remember, it can be male also. No, need also every members need not be male, female. Okay. People now, there need to be paid people. No, there should be grants and audit coming from government. Government will give a grant for people who are working, because Indian Complaints Committee madri illa. It's different. This is different. No, this is a very different scheme where government is putting. So government should pay them. So there should be grant and audit coming from government. Now, people okay? Now people complained. Okay. People within 3 months of the incident, within 3 months, or if it's a repeated one from the last incident within 3 months, the aggrieved woman should make a complaint in writing. If she is not capable, she can approach the employer, like Indian Complaints Committee. They will support her. Or because of her health, because of the mental shock, she is not able to file the complaint. Her legal heirs or her relatives, nominees also can even file a case. But it should be a written complaint. Now, written complaint should contain description of each incident. It should have date, timing, location, everything. Now, if you are having a complaint without having the name of the party, date, time, then you will reject the complaint. Should have the proper information regarding the complaint. Okay. You should have the.
Extend the limit, right?
They can the doctrine of sufficient cost can be added, where they can extend the time framework. Okay. Good. Now people. So why this Indiana Complaints Committee or local committee? If we go with a proper adjudication, it will take time. Cases in India, courts in India are totally held up. It will take time. Now let's go with the amicable settlement in a conciliation form. Conciliation means nothing. Out of court settlement, ADR, alternate dispute resolution, conciliation. Now conciliation means you are trying to come in with a settlement. You are coming with a settlement. Your climax is settlement. You are going to settle the issue. So, first point, the Indian Complaints Committee or local committee, as the case may be, before initiating an inquiry, meaning before going the normal inquiry, fight, problems, adjudication, they can request. It's not their power. It's like they can, hey, can we settle the matter, provided that the settlement cannot be monetary, meaning you can settle but not like okay, I'll settle the problem provided the employer gives me 1 lakh rupees. No. So there should not be any monetary compensation for, monetary kind of thing for your settlement. Then what is settlement? It can be apology letter, it can be a sorry, it can be I will go out from the organization, or I will make you sit in some other office, I'll go out, anything which is up to them. These people are okay, go with that. But don't let a monetary terms come under your conciliation outcome. Conciliation outcome. Now, where the settlement, where the board parties have settled, the internal complaints committee or local committee, as the case may be, shall take the record of the settlement arrived and forward it to the employer in case of internal complaints committee or district officer, as the case may be. So settlement happens when there is a out person coming who will settle. He will sit and this. If the settlement is successful, mediation is successful, he can give the forward the result of the mediation, the conciliation, to the employer in case of internal complaints committee, or it can be your district officer, as the case may be. Okay. Then they will give the copies of the settlement to agreed woman and the respondent. Okay. Now, once the settlement is done, why do you want to further inquire? Don't do a further inquiry if the settlement is done. If you are done with the settlement, if you are amicably settled, you said okay, in the in this time I will be okay. It's okay. It's not a serious offense. I'm okay. If that be the case, you have mentally recovered from the shock after seeing the apology letter. Yes, fine. Let's not dig further in the issues. Let's not go for a further inquiry. Let's stop it right away. Fair idea? Now. Okay. Inquiry into complaint. Now people, if the respondent is an employee, proceed to make an inquiry into the complaint in accordance with the process. Okay. People, usually, when your settlement is not favoring, they didn't end with the settlement, or the gravity of the issues was so horrible, what they can do a formal inquiry. They can do a formal inquiry. So formal inquiry and the provisions thereto shall be based on the service rules of the employer. So employer will have so if the issue is settled amicably, let it go. If not, let's have an inquiry happening. Let's go with a legal thing. So let's see what is given under our service rules regarding how to approach such kind of issues. Let's have a service rule. Let's see. Thereafter, you will see the service rules and you will see the inquiry adjudication procedures as per the law. Now, but in case of a local committee, if they feel that the issue is very like a burning issue, then they should forward the complaint to the police within a period of 7 days from the registering the case. Like they just do a formal inquiry, but if you see the seriousness is very big, try to file it with the nearest police station. Okay, it's like a rape kind of thing. It cannot be done through a conciliation mediation. Straight away, do it like a legal adjudication process. Go file a case under with the police station. Okay. Now, second point, or when he failed to comply with the settlement. One scenario is like the gravity of the issue. Second scenario can be he has agreed for the settlement, apology letter, but he failed to give me a apology letter. This also can amount to starting an inquiry under the law, or this can take only after giving an opportunity of being heard to the people. Give an opportunity of being heard before you initiate a inquiry. Okay, people? Okay. Now, under this point, they will have the same power of civil courts. Okay. So, complaint can be a big question, or inquiry into complaint can also be a question. Complaint or inquiry into complaint can also be a question. Okay. People, what are the probable quick actions with respect to your inquiry. What they can do? They can transfer the agreed woman to another workplace. Like, in order to not to have a there's an internal complaints there's a problem happening, there's an inquiry happening. What if these people come face to face? So they said, okay, let's transfer to a different place, or let's grant her a few days of leave, not exceeding 3 months. 3 months you go home, Dama. I'll pay you. You go home. Let this issue be settled. If you come, there's a burning issue. You just take a leave, or any kind of relief. It's okay, da. I'll give you some compensation. Just be there, or work from home. I'll pay money. You work from home. Any kind of grant, which she's okay with. Okay. Okay. Now, people. Last section they asked like this. Sir, what if they are making a malicious false evidence? So malicious complaint and false evidence. So people, 2 points. If the person, the agreed woman, or any other person making a complaint has produced a forged document or a misleading document or a fake complaint, then they can take action. The point is taking action. They can take action. So point to remember that, take action. When the agreed woman or any other person makes a complaint, fake complaint, by using a forged document, meaning fake document, or like misleading documents, CCTV camera tampered, or fake WhatsApp chat screenshots, then you shall be liable under legal action. Now, okay, second point. People, now I was not a complainant, but I stood for my friend. I said, yes sir, I saw the incident. I'm a witness. There also, if you made a false evidence, produced falsing, or did a misleading thing, there also you will be, strict action will be taken against you. Point number 1, against the agreed woman. Point number 2, against the witness. 2 things. Law will take a action when you have made a fake complaint. How? False evidence, forged documents, or misleading documents. They can file case against you. They can take an action against you. Similarly, one more point. Okay, I know. We will remember your inability to produce documents. There will be one point in your study material. Sir, I couldn't produce a document. I couldn't produce a evidence. That doesn't mean that the case is fake. Fabricated evidence is fake. You couldn't produce a document to support your claim. Need not be a fake complaint. Should not be a reason for fake complaint. The inability to produce is different. All good people? Okay. Now people, they can ask you a question. Sir, how do I determine what is a compensation payable? Okay, sir. So let's see how much mental trauma, how much pain, how much suffering, how much emotional distress caused to the agreed woman. Okay. So because of this incident, I lost my career opportunity. Sir, medical expense I have incurred for the rape, as well as, but it should not be one-sided. See how solid is the financial position of the respondent. If possible, allow respondent to pay payment in installments. So 3 points for agreed woman, 2 points for respondent. You have to check before you grant a compensation. 3 points. 1, mental trauma, pain, suffering caused by the agreed woman. Loss of her career opportunity. 3rd point, her medical expenses. Flip side, employer, what is his financial position, whether he can afford a one-time payment or periodical installment payment. Based on that, you will come with the conclusion regarding the compensation. Clear? Okay. Now people, one point, should have that point. People Right to Information Act, one point. There's a point. Let me see. My note. Did I forget? Yes, I forgot. Okay, I forgot the point, people. People, there is a point on Right to Information Act. Any people can access right to information, get the information. Now remember, notwithstanding anything contained under Right to Information Act, it is not the duty of the employer or internal complaints committee to give the details full spread. What happened? Incident need not be revealed. Notwithstanding, there is a power given to any person under Right to Information Act. There is another power given under this law wherein you need not give the complete details of the victim, issues happened, stories, and don't make a this thing. Give the people a chance to write a story. Why? If it's a happening live, yes, don't give clues and all. It's not available for Right to Information Act. It's a proper written. What if it's settled easily? If she is okay with the apology letter, why you people want to get interfering? Why do you want to interfere? So keep that in mind. Now, appeal. If you're not okay with the judgment given, you can prefer an appeal. Okay. Now, people, 2 more points. Okay. 1. What are the obligations of your employer with respect to this law? Obligations of employer with respect to this law. People, remember only 6-7 points to have a proper answer. Probable question can be, they can ask you in your sexual harassment chapter, any question can be important anywhere, and it's one of the repeated questions, repeated chapters as well. But you can expect, you can say that okay, sorry, it will come. No, being there are 16-17 laws altogether, and they can ask you maximum of 8 or 7 only. Maybe 8 laws, 8 into 5 40, or 6 laws. 7 laws, like 6 laws, 7 laws, 2 questions. 7th law, 2 questions. It can be 7 laws, but minimum 7 laws they can ask. Or I would say 8 laws. It's preferably 8 laws. 8 act can be asked. So it can be even the minute act, which is like your Equal Redemption Act. Okay. Now people, every employer shall. What are the duties of the employer with respect to this? Provide a safe working environment at the workplace. Okay. It can be persons coming into contact with the workplace, meaning it can be for the workers, customers, etc. Okay. Now people, how will I ensure? Make sure there is a particular passage where you go to canteen. Small, there you should have a CCTV camera. What if there's a problem? Okay. Properly lighted. Proper light should be happen. What if CCTV camera is not able to capture the thing? Those things should be there. Now, people at times, whenever you hear the penalty, death penalty, you'll be scared. Similarly, display at a conspicuous place, meaning not at the kitchen, at the front gate, where people will see that if you do this, this is your consequence. If you do this thing, this offense, this is a penalty. Give that. Now, organize workshops and awareness programs at regular intervals. Make a habit of every year, 6 months once, you do a program motivating people, or helping them understand the consequences, or kind of respect, dignity which you have to show towards fellow beings should be given. Provide proper facility for internal complaints committee or local committee as a case may be. Okay. Assist in securing attendance of what if respondent attendance comes together? What if they'll fight within the premises? Let's have first let the complainant come, then the respondent comes. Let's make sure that these people appear properly before the complaints committee. Make available such information internal complaints committee or local committee requests. If she is feeling that I should file a complaint, assist her if she want to make a complaint. Correct. It's okay. It's not wrong to write IBC it can be IPC. I mean IBS it can be IPC. It can be IPC because you are free to refer. You should know that to interpret it should be IBS. But when you write, you can write IPC. Not a big deal. Now, sexual harassment, you treat it as a misconduct in your service rules. Similarly, monitor the timely submission. Timely submission of issues are being properly done or not. That should be checked. Okay? Good. Okay. Now people, 2 points now. Okay. 1. People, your local committee, internal complaints committee, as the case may be, they shall report the same about the complaints which is, as a company, I would have received 10 complaints, or as an internal complaints committee, I mean, as a local committee, I would have received some 1,000 complaints. Everything should be given as an annual report to the district officer, meaning collector. He shall forward it to the state government. So remember, the act talks about having 2 kind of reporting. One reporting where I am telling you that I mean internal complaints committee or a local committee, number of complaints received should be reported to the district collector, who shall report the same to state government. This should be made within usually January 31st. Should be January 31st. Okay. Now people, 1 point. Now, two more case laws, something called as derogation. People, one small topic in the study method, one paragraph. Derogation. Correct? Derogation, people, derogation. People, derogation means simultaneously you can have. Meaning, you remember under your normal laws, a person cannot be punished for 2 offenses. Correct? That doesn't mean that person, there's a live case happening under internal complaints committee. That doesn't mean that I cannot file a case in police station. It's a derogative power that you should not prohibit a person from filing a case under other laws. He can still file. You cannot say, respondent cannot say, oh, no sir, you can't file a case again because already case is going. That is not given. You can still have that power. Okay. Now, that's given in Binoy Jacob versus State of Kerala. Okay, some people from Kerala like this only. They say, oh, why you have already raised a complaint here. Why do you want to create another mess? No. Punishment cannot be done because double jeopardy. Constitution. Jeopardy, leoparda, something. People. Now, remember, one more case law, Raila Satyanarayan versus SBA Mutual Funds Management, wherein they said conclusions arrived at the committee need not be the base for your, okay, suspend him, dismiss him. No. Your service rule says you have to follow this much steps to do a termination. Then don't jump into a conclusion statement that yes, my internal complaints committee has proved nothing. Let internal complaints committee be a opinion. It need not be the final opinion for you to remove that person. Let that be a base. From there you start the proceedings under your service rules before you terminate such person. So this is not an absolute thing. It's not a conclusion. Okay. Done with the chapter. 2 chapters done. Okay. People online. Okay. You are understanding. People who are new. Chemistry is working. Come below. Marathon. Okay. Done. 2 chapters are done. Easy. Okay. Guess people next chapter. Guess karo. The thing is, I don't remember which page, which number I know. Tell me, da. Guess. Break. Hungry. People will take a break, but not more than 20 minutes. Come back fast. Okay, people. 20 minutes break. Come back, people. Okay. If you have any suggestion, let me know. If you have doubts, keep it posted. Da. Let's clarify things. Thank you, people. People, next topic regarding next part, people. Your smallest chapter, labor laws, simplification of procedure for furnishing returns and many registers. People, settle down. Next chapter is simplification of procedure for furnishing return and maintaining registers. People, we have seen under different chapters there will be registers to be maintained and returns to be filed. Previous chapter we have seen annual returns to be filed to the district officer. Similarly, we have seen some registers to be maintained. First chapter, Equalization Act, we have to maintain some registers as well. Now people, it became complex for every employers to maintain 100 registers because there are different laws as well as filing returns. So law says, okay da, if you are a small sized organization, you need not maintain the exact full registers or you need not file the entire return. So let's have a relaxed version of filing return as well as maintaining registers. So this provision is applicable for those companies, those organizations, those establishments which are small. Those people need not file returns full-fledged or need not have registers to the corp. Now let's see what. So it talks about some kind of some establishment, one small establishment and very small establishment. People, law is talking about small establishment, very small establishment, meaning if your company is having less than 9 employees, 9 or less, it's called very small establishment. Or if it's 10 but not more than 40, it's called small establishment, very small establishment, small establishment. Okay. Now people, there are many establishment, small establishment and very small establishment. We are trying to give a relaxed provision. Let's see what is the relaxation. They have covered 16 laws here, like payment of wages, weekly holidays, minimum wages, factory side, blah blah blah. These are called as scheduled act. Some laws. So how law is regulating this particular? So the chapter talks about small establishment and very small establishment. What is the purpose of this law? Not every employer need to fulfill. The complaints will be hectic. They have to maintain 100 books, registers, 100 times they will file return. Why for every small establishment? These things. So whenever you are a small establishment, like a small or very small establishment, instead of having a full-fledged return or full swing register, you will have a relaxed provision. Let's see what is the relaxation. Okay. Simple da, simple point. Only one point to remember this chapter da. Only one point. What is the point? Okay. There are 3 forms here. Form number 1 of annual return, like a simplified, an abridged annual return. Form number 2, like a person's employed come employment card, like employee party details. Form number 3, muster come roll wages, meaning your payment slip related thing. So it can be annual return, it can be employment related, like employed persons register, or it can be wage kind of register. 3 registers. 1 annual return, 2 is a register of person employed, 3rd is muster roll. 3 points are covered. Now that's all our chapter. What is the chapter? Nothing. They said only this chapter, only this much is needed for exams, only this para. We know small establishment, we have seen very small establishment. These people need not fulfill the entire registers, or so it's like furnishing of register or furnishing of returns or maintaining of register as relaxed. So I'm an employer having less than so and so number, 40 or 10 as the case may be, and for these particular 16 laws, I need not have the complete register. I have only one annual return. And Form 2 and 3 is mandatory for small establishment. Form 3 only is mandatory for very small establishment. Meaning, for a small establishment and very small establishment, annual return is mandatory. For a small establishment, Form 2 and Form 3 is also mandatory. For a very small establishment, Form 3 is only relevant. So what is the climax da? If there is some 16 laws, these 16 laws, I am a company which is having 8 employees. I have to follow only Form 1 and 3. Form 1 and 3. I am having 18 people. It should be Form 1, 2 and 3. If I am having 45 people, I have to follow normal procedure of the law. Easy. End of the chapter. Easy. Very easy chapter. The law is regarding governing this much point. So they can ask only one thing. Whether it is mandatory for every company to maintain registers or maintaining returns. Okay. Good people. Thank you. People, one more point. Very good observation. Along with that, ensure that wage slips means wage related, minimum wages act party wage slips, or your measurement like piece rate workers, one cotton sari you will get 1 rupee, piece rate workers or a measurement, those two things, and any accidents happened under Factories Act or Plantation Act, these things should also be reported. So climax for small establishment and very small establishment, how the complaints is, they are giving liberalized annual return, liberalized registers. How? For a small establishment, annual return plus 2 and 3. Very small, annual return plus only 3. But no matter what, everyone should have additional these points. What? 1, wage slip, then measurement regarding your piece rate, then accidents reported based on Factories Act as well as Plantation Act. Okay people, online, this is okay? Extra information? Good. That's all of this chapter. Good chapter. So how many chapters completed? 3 chapters done. Okay. People, how many laws in total? 16 laws. 16 laws and constitution and this thing. So total 18 chapters. 18 chapters or 16 chapters in total. Okay people, so how many laws are put together? How many units? We have done with 3 units. How many total laws, total chapters? How many more? 15 you have, like including constitution and, so total 18. Total 15 total 18. Anyway 15 units have to be done. Okay people, let's move faster. Let's see something called as Maternity Benefit Act. Okay, Maternity Benefit Act. So what is Maternity Benefit Act? People, Maternity Benefit Act is a kind of a social law, social legislation. It is applicable for anywhere 10 or more people are working. 10 or more people are working. This law is applicable. Okay. There are different definitions. One, the term child includes stillborn child, by like a newborn child. Second point, there's something called as a commissioning mother, like celebrities. They will have like they'll use a biological mother to have babies, commissioning mother. So law is here to protect these two people. One, a normal mother as well as commissioning mother. So what is this point? People remember. Now people, first time we are seeing establishment. It is applicable for factory, mine, plantation, exhibition of acrobatic, shop or assembly. Everywhere it's covered. And remember, it applies to a place where 10 or more people are employed. Now, wages. People online, tell me why wages are important in different laws. Why do you think wages are important? People concentrate, Yuvraj. Why wages? Why the definition of wages are important? Why wages is not common everywhere? Because people, say for example, my salary is 1 lakh rupees. Okay, salary is 1 lakh rupees. It has different components. This like different items. It can be, say for example, 20, 40, 30, 5. Different items. For different law, it's different. Why? Because, say for example, I got 1 lakh rupees, but for the purpose of maternity benefit, your wages is just 40 plus 30 plus 5 only. So, my salary is actually this for the purpose of this law. That's why wages has been defined under different laws in a different types. Because when I say wages, you should not think like, oh, my salary after adding or deleting some points, some adjustments are to be made in your salary to know what is the wage or salary for this particular law. That's why wages are redefined for every laws. Concept clear, people? So here they say wages include cash allowance, incentive bonus, but does not include any bonus other than incentive bonus, overtime earnings, contribution pay, nothing. These things are need not be required for an exam purpose. You should know that you are computing something on wages. Wages for different laws can be different. Okay. Now people, let's see why this law. Tell me why this law, why maternity benefit law? Don't smile, why maternity benefit people are smiling? Sir, why sir, I'll say maternity benefit. People, maternity benefit act, again, remember your General Clause Act, maternity benefit act in the modern era can be, sir, one husband and wife posting in Instagram that we are pregnant. The law has nothing to do with that. Sir, modern version, sir, we'll say we are pregnant only, sir. Not my wife is pregnant. We'll say we are pregnant only. The law is here to protect Okay. Sir, why these people should be protected? People, maternity benefit act is nothing but during this particular period, you need not work, still we will pay you. So it's like an earned leave. It's an earned leave, so that our woman and her future generation is safe. So what if she has to take a leave? She will lose revenue. What if she is the bread earner in the family? So law says we will pay you amount during those days of leave. So maternity benefit is something which an employee earns during her maternity leave. She is earning. Correct? Yeah? Now let's see what the provisions are to be done. First point, people. First point. Important. No employer shall knowingly employ a woman. Similarly, people, no women shall also work. People, it makes obligation for the employer as well as you people, employer, you should also be careful that you cannot, you cannot, you should not, or you need be, you should not be allowed to work. Eppo sir, when 6 okay, so what's a 6 weeks immediately after following the day of, it can be delivery, miscarriage, or medical termination of pregnancy. People remember, the law will have different parameters. First parameter, an employer shall not offer a pregnant woman answer, no, need not be. It's like someone who has come out of delivery or miscarriage or a medical termination of pregnancy, employer shall not offer her work, or employee shall not work under him for the next 6 weeks, because she should recover mentally, physically. So law is allowing her protection, that don't do. Okay, first point done. Now people, similarly, if she can apply, sir, I'm a factory worker, I have to come under factory, can you please give me, that's like 1 month before the expected date of, before the period of 6 weeks, meaning 1 month before the leave, like your maternity leave. They're saying, before you go for a maternity leave, if you want, you can request the employer, and if the employer is okay, you will be given relaxed provisions, like relaxed work from home, or too much standing not allowed, too much hectic work they won't give you. So this can be given purely based on the agreement between the employer and employee. If you want, you can get a relaxed provision. So 2 points covered here. 1, no work or relaxed work. No work or relaxed work. Relaxed work 1 month before the thing, or no work, mandatory no work 6 weeks after the date of delivery, miscarriage, or termination of pregnancy. Clear? People online, good? Okay. Now people, okay. Now point. Right of payment of maternity benefits. Every woman shall be entitled to, and her employer shall be liable for the payment of maternity benefit at the rate of average daily wage for the period of her actual absence, that is to say, a period immediately preceding the day of her delivery actually. So you will get an average daily wage, average of your wage. Now tell me, sir, average. So sir, what is my average, sir? It's like my salary? No, it's not salary, it's wages. So your wages, your salary is 1 lakh rupees. You need not get 1 lakh rupees. You might get 35,000 only. Why? Wages excludes many parameters. That's a point why wages are defined. Okay. So average means last 3 calendar months, what was her return? What she got as her salary, like a wage. So if your last payment is 10 lakh rupees, divided by 3 should be the what she can expect as a average payment. So she can get an average pay of last 3 months oda payment, not last month's 3 months salary, last 3 months oda wages. Okay. Okay. Now she shall be entitled to get maternity benefit provided she has worked with the employer a minimum period of 80 days in the preceding 12 months. She can claim maternity benefit provided she has worked in the with the employer for a minimum period of 80 days in the preceding year. Clear? Clear? Now comes important point. This is the actual benefit. Okay. People, what is maternity benefit? she can enjoy 26, she can enjoy 26 weeks of earned leave, meaning leave without wages. I mean, leave with the wages. Leave with wages. 26 weeks. Okay. Now law is asking, sir, 26 weeks should be taken after the your delivery. Law says no. People, if you want, you can take before also. Before cannot be more than 8 weeks. So if you want, from the date of delivery, you can take 26 weeks. Or if you want, take 26 weeks. Okay, sir, can I take 20 weeks before? No. Law says it should be maximum 8 weeks. After can be 26 weeks. So put together 26 weeks, but not more than 8 weeks should be before the date of expected date of delivery. Okay. Now people, law is giving one more point. Sir, what if I am already a mother of 2 surviving child, meaning this is my 3rd pregnancy? Then your maternity benefit is not 26 weeks, it is 12 weeks. Oh, 12 weeks, sir. But remember, prior is 6 weeks. You cannot have more than 6 weeks before. So if you are already a mother of 2 kids, you are having your 3rd pregnancy, you can claim only 12 weeks. That 12 weeks can be after the date or before. But if it's before cannot be 12 weeks. It should be maximum of 6 weeks. So put together 12 weeks. Okay. People okay?
So before delivery, the woman took for 8 weeks.
Huh.
Then after delivery, she can go up to 18 weeks of leave.
Correct. 18 weeks. 18 plus 8 is 26. Now, people, where another point, where a woman having been delivered of a child dies during the delivery. Okay. Now people, if the woman is dying, you still have to make a life payment till the date that the woman is alive. So if after the delivery she dies in 2 weeks, you still have to pay payment for 2 weeks. Or woman and the child dies, still woman death varaiku you have to make sure you are making the payment to the woman. Okay. So this law is regarding the protection of women. You have to pay her the wages. Now we have seen something called as commissioning mother. What is commissioning mother? I am giving an egg to another biological mother. She will carry all this pregnancy. Then she will give me back the baby. Now, if another person, I am adopting a child less than 3 months. 3 months old baby I am adopting, or I am a commissioning mother. I got the baby back from the biological mother. So I am a mother, I am a celebrity. I gave my egg to someone. She gave me back the baby. So for a mother who is adopting a child less than 3 months, or a commissioner mother after receipt of child, she can also avail a maternity benefit of 12 weeks. Okay. 12 weeks of handing over or 12 weeks of adoption. There also they can take a maternity benefit. What is maternity benefit? You need not work, but you will get payment. Good.
That is called surrogacy, I guess.
Yeah. Kind of.
Surrogacy.
Surrogacy. Surrogate mother. That's normal maternity benefit. No. For her, it's correct. Like for her, it's like normal maternity. She's pregnant now. She'll get 26 weeks kind of thing. That's as per her thing. For these people, different thing. Okay. Now people, remember, she should give a declaration that she is not going to work during that period. She cannot work with any other employer during that leave. If not, she will earn from me, paid wages is there, then you will take work somewhere else. So law says you have to give a declaration that you are not going to work somewhere else. Okay. Now people, when should I pay? So Act gives you permission to take leave before the maternity as well. So if you are taking that, you can claim advance, or after that also possible. So if you are taking before that, you can take the advance payment eligible, or after that if you are claiming, you can produce the documents 48 hours after the childbirth. You go, they will give you the balance amount. Or if you are planning to get all the maternity benefit after that also, you go after the childbirth, you or your nominee will get the amount. So amount can be received as an advance, or after the childbirth you can go collect the amount. Now, other points. Every woman, so this is the point of 48 hours. Now, every woman delivered a child who returns to duty after such delivery, in addition to the interval of rest, allowed her 2 nursing breaks till that. Okay. So she is coming back. She is coming back to work. Law says, along with the normal rest intervals available to her, you have to give her mandatorily minimum 2 nursing break till the child attains 15 months. So you have to feed her the child. So the law is giving you, along with the normal rest breaks, 2 extra breaks for you to take care of the baby till the baby reaches 15 months. Okay, sir. Now every establishment having 50 or more employees shall have the facility of crèche. Okay. People, in case your company is having 50 or employees, then you should have a crèche facility. Crèche facilities like a baby play station, where the employer shall allow the woman to come 4 visits, be there, be with your child, should be there. Last point, people, abstract of the provision of this act, meaning the summary of this law, shall be in English and the local language exhibited in the place where women are employed, so that she knows her powers. Now people, summarize points. No, this position is regarding payment of wages even though she is absent. So first point, considering her health, she shall not be offered work during the 6 weeks after her delivery, miscarriage or termination of pregnancy. Then if she wants, she can take 1 month work from home kind of thing. Employer should allow. Okay. Now next points, she can claim 26 weeks of maternity benefit, but the 26 weeks should be like this. It cannot be more than 8 weeks before. So if she is already a mother of 2 kids, then she can claim only 12 weeks. That too, 6 weeks cannot be more. Now she can take the amount in advance also, or 40 remaining 48 hours after the childbirth. Okay, manageable. Any illa childbirth, remaining amount after the 48 hours of the childbirth. People, okay, online, under control. Okay. Okay, so 4 chapters done now. People, next chapter, payment of bonus act. Payment of bonus act. Okay. People, 4 laws are okay. 4 chapters okay so far. Good enough. Good to go. Okay. People, bonus act. People, why bonus act is important?
Maintain the same rate.
To maintain? To celebrate Diwali. To celebrate Diwali in a peaceful manner. Okay. To save, to ensure that your in-laws are happy. Because Maple has a Diwali bonus to share. Okay. Now people, let's talk about bonus act. Bonus act is something which the employer offers the employee free of cost. It's actually a 1 month pay. Usually a 1 month pay. Why 1 month pay? Because the law talks about 8.33. What is 8.33? 1 month out of 12 months. So that's technically 8.33. So law talks about payment of what bonus? Statutory bonus. It's a statutory bonus payment. The law is regarding not your Diwali bonus, not your Christmas bonus, not your Onam bonus. It's all about your statutory bonus. Okay. Ugadi bonus. Okay. Puja bonus. Okay. Now people. Now law is talking about, sir, do I really pay bonus? Law says yes. Irrespective of whatever be the case, you have to pay bonus. Sir, loss also? Yes, bonus. Sir, my question is, I am paying puja bonus. Should I pay 2 bonus, like a puja customary bonus and a statutory bonus? Law says, now there's a different scenario. People, first box in your study material. Very important, very careful analysis. Okay. Let's see. Which case will order first box? Okay. Faisal Bhai. Okay. People, say for example, understand the very much important. There, if you see, I want you to underline 2 words. One is promise. What is that? Promissory and expectancy. Expectancy. Okay. Promissory and expectancy. Now, people, question happened. Sir, the bonus act came into effect from this year. Okay. Now I have to pay statutory bonus, meaning minimum 8.33% you have to give. Sir, usually but Diwali I am going to, usually every Diwali I pay him this much amount. Now, should I pay both or should I pay only one? It became a question. Now people, law says, okay, let me analyze the scenario because this will change case to case. Okay. What is your usual trend? Sir, usually whenever I have money, I will share with my people. Why? Because we are sharing prosperity. Oh, because joint effort only you are able to survive in this industry, in this world. Oh, abdiya, that's why you are giving him. Okay. So when will you give? Sir, whenever I get profits. Okay. Meaning, they don't usually expect your Diwali bonus. Correct? Or there can be scenario. Sir, no matter what, sir, I want people to celebrate Ramzan. Whatever the case, I pay every time Ramzan. Now, people will have a promising effect or an expectancy that they'll get a customary bonus. If that be the case, no matter what, you have to pay both. You cannot say, sir, I'm paying statutory bonus. Now I will stop customary bonus. But you have made people believe that, estoppel, that I will feed you as a puja bonus or a Ramzan bonus or a Christmas bonus. Then make sure, based on facts of the case, you have to pay. If not, you can say no. Anyway, today onwards, I'll pay only statutory bonus. I'll go with that because that anyway I have to pay. Why should I pay 2 things? Meaning law is not there to give a law bonus. Yes, it is. But at the same time, they don't want to put an additional burden on the employer. Okay, it should be like a blend of employer and employee. Good. First case Loda. Now let's see people who are exempted from the bonus act. So why people are why will someone accept or like give a rejection for this bonus? They're telling that's different. This list, insurance sector, those sector. These people are excluded because they will be having separate your service rules which will talk about bonus payment. For a insurance sector, for a seaman, like a sailor in a ship, dock workers is nothing but ship workers. Seaman is sailor, workers are like people who work fixing ship and all. Government industries, your Indian Red Cross, universities, RB employees, financial related sectors, these people, law will be having different statutory laws would have been already enacted. Go with the bonus payment accordingly. You don't interfere with this thing. So when there is a super cool law for these people regarding the bonus payment, I don't care. This is for poor people who will be happy to get that extra 1,000 rupees, 10,000 rupees as bonus. They'll be more happy. Okay. So we are here to protect those people, minimal people. Okay. Now people, first word is accounting year. So people, what is accounting year? Because law says for the accounting year we will pay bonus. For the accounting year if you have worked we will pay bonus. Now what is accounting year? Usually when the books are closed. For a corporation, when books are closed. For a company, when the books are closed, for which you have to keep that in your AGM. Adoption of annual accounts, first ordinary item. For that you have to prepare a books of accounts as on 31/3. Or any other case, starting on 1st of April, ending on 31st May, 31st March. Based on that, you will have an accounting year. Should I really need that? No. For the purpose of writing your answer, you should know the word, not the previous year, not the 12 months. It's accounting year. This law talks about something called as accounting year. Okay. People, what is award? Means interim or final determination of an industry dispute. There is a problem regarding bonus payment. Court has decided, hey, this is the final judgment, final order. We call it as award. Okay. Now people, available surplus, allocable surplus. Wait, we'll come to that part. Okay. People who are not covered. One, employee excludes apprentice or anyone earning more than 21,000 per month. Meaning for them there will be some other law. For us, for the purpose of bonus act, we are excluding apprentices as well as anyone earning less than 21,000 per month. Okay, sir. I mean more than 21,000 per month. Okay. Now. Okay, sir. Now again, sir, salary wage is been defined. Why, sir? Because you can't expect. So my salary is 10,000 rupees, sir. So I'll get 10,000 into 12 into 8.33, sir. Need not be. Because 10,000 minus does not include. You have to compute. So say for example, my wage can be 7,200 only. Okay. My wage can be 6,900 only. Even though my salary is 10,000. Because we are recomputing wage for the purpose of bonus. That's why bonus wages definition is given for every law. Okay, people, getting the connection? Why definition is given? Yes, no. Yes, people. Online. Okay. Now, people. Okay. Now let's see. The provisions. Okay. Let's see the eligibility and procedure. Then we'll come back to the computation part. Okay. Let's see, people. Let's see what is eligibility. Okay. Sir, I will be entitled to bonus provided my salary is less than 21,000 and I am not an apprentice and I have worked in with the establishment not less than 30 days in the year. People, previous topic, maternity benefit, it was 80 days. Now it's 30 days. Don't confuse yourself. Maternity, 80 days. 8 months pregnancy. This is 8 weeks, to understand. 8, more than 8 weeks of pregnancy. Like this you remember, so 80. Here it says, for bonus you should have minimum work period of 30 days. Okay. People. Now sir, 30 days I have to work. Sir, but I have worked only 70 days. Ayyo, not eligible for bonus. Now law says, in the computer that the particular 30 days, no. 30 days need not be a physical working. Say for example, because of raw material shortage, the employer laid off, meaning, hey employee, you don't have work today. Okay, 2 days likewise he went. Now, paid leave. For every month you are working, you will get one paid leave. That one day, he is temporarily disabled because of an accident, temporary disablement. 4 days. Maternity leave for 6 weeks he took. So put together, you can enjoy all these things. Put together, you can enjoy all these put together as working days. So your earned leaves, everything counted together, add back, you get number of working days. If the number of working days are 30, you will be entitled for this law. Okay. So 30 days, you should count this as well. Okay. Okay, sir. Now I counted, I computed, I came to know that I have worked for 30, 35 days, 45 days. Okay. Now people. Okay, sir. First point done. Sir, bonus I am giving because of the combined effort of employer and employee. Because under a prosperity, the company is prospering because of your effort. So I will give you a bonus because I will consider your efforts as well. But I have suspended you because of your fraud, violent or riotous behavior, or theft, misappropriation or sabotage of any property, meaning stealing, disturbing the property. Then where is the role of combined effort? You are spoiling the company. I can say no to your bonus. So you can say no to a bonus even if the employee has worked for more than 30 days, provided he was convicted for fraud, riotous or violent behavior, theft, misappropriation or sabotage of property. Okay, sir. Now, so I have eliminated everything. I became an eligible employee. Now people, remember there is something called as allocable surplus. Allocable surplus. We'll see the allocable surplus, not now. Allocable surplus. Just for the time being, remember profit. Time being, remember profit. Meaning, sir, whether the company has made a profit or not. Whether the company has made a profit or this allocable surplus. Allocable surplus for the time being is just nothing but profit. Whether the company has made a profit or not, since it is a statutory obligation, no matter what, you have to get 8.33% or rupees 100, whichever is higher, as minimum bonus. For an employee less than 15 years, it's 8.33% or 60 rupees, whichever is higher, shall be received as a bonus. Minimum bonus. Okay. Now people, think like this. Sir, my salary is technically 10,000 rupees. Okay. Salary is 10,000 rupees. Okay, sir. Now, the company has made a profit or not. Like allocable surplus is you find something, add, delete everything, you found that you got some amount, some X amount. Law is telling you, irrespective of the what, you have this profit, this allocable surplus profit or not, you have to ensure that the employee receives his wages. Now first you have to compute what are the deductions. You came to know it's 2,300 is his wage. 2,300. Now, no matter what, you have to pay wages at the rate of 2,300 into, like 12 months you have worked, into 8.33, irrespective of the fact that whether you have earned a profit or not, irrespective of the fact whether you have earned a allocable surplus or not. So bonus is confusing people. Remember, whether the company is having an allocable surplus, a positive fact or not, you have to make a payment of 8.33% to every employee covered under the law. Okay? Now, people, sir, can I make more than 8.33? Yes, you can make a maximum of 20% of wages earned for that year. People, salary, like, okay, it's not salary. Say for example, you are working for 10,000 salary, but you got only 6,000 salary because of some stupidity. Now, wages should be computed based on wages earned, not your salary discussed, not the discussed salary. Practical insights, not the exact salary. It can be total earned wages. Your agreed salary was 6,000, but you got only 5,800 per month because of your taking unnecessary leaves. Then it's 5,800 into 12 into 8.33. Only the earned part. Some months you have earned 7,000 rupees. So 7,000. Then 2 months you have earned only 5,000. Then 7,000 into 10 plus 5,000 into 2 into 8.33. That's how you compute. Now, people, sir, what if the amount I computed, allocable surplus is 10,000 rupees. Okay, sir. And my minimum payment is 4,000. Minimum payment is 4,000. Sir, okay, come again, people. Let's see how it's to be done. Okay. So let's see, people, allocable surplus is nothing but what I find as per computation. We are yet to see the computation. For the timing, it's the profit or not. So I have found that my profit or allocable surplus, allocable surplus is 10,000, is like 10,000 rupees. Okay. I have different employees put together. I found their salary minus all those things. I came to know that I have to pay 8.33 for different people put together. But this 8.33 comes to 12,000 rupees. But I have only 10,000. What I will do? I have to pay 12,000 no matter what, because it's a statutory obligation. You take loan or not, I don't care. You have to pay 12,000 rupees. Okay. Now, sir, my allocable surplus is 10,000. My minimum is 8.33, which is 3,300. And maximum is 20%, which is 9,500. I have to pay 9,500 because you cannot have more than 20% paid. Okay, 20% is the maximum. You cannot have more than 20% because you will attract evil eyes. You can't have more than that. Now, say for example, my allocable surplus is 10,000. Okay. Now, my 20% is 16,000. My 8.33% is 3,900. Meaning, you have to pay 20% illa 10,000 you have to pay. No matter what. So remember, 8.33 is the minimum, 20,000 is the maximum. But if you have more than 20,000, still you have 20,000 obligation. So people, 8.33 is just 3,900. 20%, but you have only allocable surplus 10,000 rupees. You can't pay more than allocable surplus, which is not available. You can't pay, but you have to pay up to 10,000 rupees no matter what. People, clear? Try to understand these three scenarios. Make sure you are comfortable. People online who are fresh to the thing, ensure that you are pakka with this point. Online people who are very new to the class, please ask the Okay, people. Yes, no. You want me? Please feel free to tell the. Okay, good. Feel free to ask the. It's okay. It's your marathon. It's a teamwork. Okay. Okay. People. Say for example, I computed. People concentrate. People, everyone concentrate. Allocable surplus is an amount available with the employer to pay all its employees. Okay. So I found, we are yet to see the computation part. We have found that 10 lakh rupees is the allocable surplus, meaning this is the only bucket which we have for paying bonus. I have a bucket of 10 lakh rupees. Okay. Now there are different class of employees working under me. I have found their salary. One person is having 3,200, 1,000. Likewise, I computed this much. Into I found that 8.33% for everyone put together. Meaning, they asked for 8.33 for different people put together. I came to know I have to pay 3 lakh rupees as my total bonus for all the employees put together. Okay. Now, I have to find 20% as well as. So 20% when I computed, it came to 23 lakhs. For example, now one scenario. This is one scenario. Or second scenario, same 10 lakhs da, but my minimum comes to 12 lakhs. Maximum is 24 lakhs. Second scenario. Okay. Okay. Third scenario, people. I got 10 lakhs. Minimum is 3 lakhs. Minimum bonus availability is 3 payable is 3 lakhs. Maximum is 10 lakhs. Okay. Now, people. My allocable surplus is 10 lakhs. 8.33 computed is 12 lakhs. But 8.33 being a statutory obligation, no matter what, you borrow from somewhere, your cousin, mother, everywhere. I don't care. You have to make a 12 lakhs payment no matter what. Even though your bucket has 10 lakhs only. Because it's a statutory obligation. Now, sir, what if I have in my pocket 14 lakhs, but my maximum is 9 lakhs, minimum is 3 lakhs. So my bucket is very much. Can I pay more? No. You can pay maximum of 9 lakhs only because you cannot have more than 20%. Okay. Sir, what if my allocable surplus is 10 lakhs, minimum is 3 lakhs, but maximum is 23 lakhs. So should I pay minimum only? No. Now law is giving a point that 20% is maximum, but it is minimum also. Meaning, no matter what, if it's more than that, you need not pay extra, but you have to pay up to 10 lakhs. No matter what, it is more going beyond, but you have to make a contribution up to 10 lakhs. So 20% is 23 lakhs, but your allocable surplus is sufficient, good enough, healthy. Make sure you pay up to that limit. Srija, see if it's okay. Supanda has left. Just now. Sir, it was okay, sir. Now, just 1 second ago. Allowable surplus, allocable surplus, I don't know, sir. Left. Okay. People good. Done? Okay. Okay, sir. Okay, sir. Okay. Okay, sir, I found that. Okay. People, one more point, people, very important. People, in your study material, that point, which point? The 7,000 point? Calculation of, computation of bonus in certain exceptions, certain scenarios, certain number. Which page number? 517. People, 517 in your study material, people, calculation of bonus with respect to certain establishment. People, remember, one more point to be noted, very crucial. Very crucial. You have to remember something called as 7,000 rupees. People, 7,000 rupees. Okay? Okay. People, let's focus the people salary minus all those things is actually wages. Correct? Wages. Sir, my wages for the month, like a monthly thing, is 3,000 rupees. I'll get is like exact 3,000. Then 3,000 into 12 into 8.33. Correct? That's my minimum bonus or maximum as the case may be. Correct? Yes, no? Say for example, sir, my salary is 23,000. Like a wages computer is 23,000. Then into 12 into 0. Because you don't fall under the category of bonus eligibility, 21,000. Sir, my payment is 6,000. I'll get 6,000 into 12 into 8.33. Correct? Sir, my salary is 7,000. 7,000 into 12 into 8.33 or 20 as the case may be. Sir, my salary is 8,000. Then it's not 8,000, it's 7,000 into 12 into 8.33. Meaning, always remember, you are not putting an extra obligation on the employer. Relax him also. So law says beyond 21,000 you need not pay. You need not consider that person. But if it's 7,000 or more, then ensure that you limit yourself to the category under 7,000. You can't have more than 7,000. Fair idea? So it can be 6,000, 6,000. It is 7,000, 7,000. 8,000 also 7,000. 25,000 not applicable. So remember, your minimum wages is fixed by the law, or your salary is 7,000 or more, you can still avail, but the computation part will happen as if it's 7,000 rupees. People online, fair idea? Where the salary or wages of an employee exceeds 7,000 rupees or minimum wages as per schedule employee, like government is fixing a minimum wage of 3,000 rupees, whichever is higher. People says whichever is higher, then bonus shall be paid by such the employee shall be calculated as if his salary where 7,000 or minimum wages as the case may be. Fair idea? Okay. Okay. Now, people, now let's see what is two concepts of available surplus and allocable surplus. Very important. People, take your study material, their computation part. Okay. So I want you to quickly go through definition part of the study material. Allocable surplus, available surplus. Allocable surplus, available surplus. Just go through that material. People always feel free to ask no matter what. It's a marathon for you people. Feel free to ask no matter what. So cool. Okay, Sarthi, why are you not asking? Sir, I've already told you 100 times, sir. Why are you repeating again? Tilva irka? Out irka? Seri. Okay. People, what is allocable surplus? What is allocable surplus? The law says, or definition says, allocable surplus means allocable surplus as per the law. Yes or no? Now there is something called as available surplus. What is available surplus, sir? 2 points. There is a company. What is this? People, what is allocable surplus? Banking. So 60 percentage. So 67 percentage and 60 percentage. 67 is applicable for any company other than banking company who has complied with dividend provisions. Okay. Ama. No. No.
Not complete.
Okay. Okay. Sorry.
Does not pay dividend.
Company which dividend. So there are 2 points. Company and dividend. So company which has complied with dividend provision, meaning already paid dividend to shareholders, should come under 60% category. If it's not dividend paid, it falls under 67%. Okay, clear? 2 categories. Do I really need? No. Do I need? No. Just to understand, there are 2 categories. One 60% category, one 67% category. Now let's see. We have already seen the base. What is base, sir? Your company has to make a bonus, irrespective of the fact whether you have a allocable surplus or not. Correct? So allocable surplus is one point which you have to find. Correct? So how to compute allocable surplus? Law says from your available surplus, if you are so and so industry 60%, so and so industry 67% of your available surplus, you will compute available surplus. If you are coming under this industry, that into 60% is allocable surplus, meaning available for dividend, available for bonus, into 67% is something which is allocable surplus, which is available for those so and so companies. Fair idea, people online? Okay, put a thumbs up. We need allocable surplus. To get into allocable surplus, we need something called available surplus. Okay. Let's see the provisions. Sir, how do I compute available surplus? Study material. Remember study material. There are points. Okay. That points, the first point says, so they can ask you a question, theory question, how do you compute? Theory question, not a sum. Sir, first step is finding of gross profit as per different schedules. For a banking company, it's schedule 1 now. Schedule 1. Other companies, it is schedule 2. Okay, sir. It's gross profit computed as per the law. As per this act, you will compute gross profit. Okay, sir. So then, sir, you have found gross profit. You have to deduct. There is some deductions. 4 deductions there. Meaning, oh, sir, in my gross profit, you have to reduce these items to come something called as available surplus. Yes, da. What are the 4 items? Depreciation you have to deduct. Development rebate you have to deduct. Then direct tax paid you have to deduct. Or other exemptions are other sums and taxes you have to deduct. Nothing. You have to deduct all these things to get a net kind of thing, net profit kind of thing. Not as per law, not the normal net profit, but a different net profit. Okay. So you'll deduct depreciation, development rebate, direct tax, and other taxes. There they have given a suggestion for direct tax as well. In the computation of direct tax also, you have to ignore losses for the previous years, unabsorbed depreciation, meaning depreciations for the previous years, as well as any exemptions given, like any exemptions given by the law, that also you have to ignore. You will come across the actual direct tax payable. So direct tax as per this law is different. You will compute, you will come with something called as net profit, or we call it as it's called available surplus. Okay, sir. So what is available surplus, sir? So we have to find allocable surplus, because allocable surplus is the only part which is available. So don't get confused. Available surplus is not available. Available surplus uda allocable part is available. So available surplus is not available. Available surplus uda 60% or 67% becomes allocable surplus which is available. So available is allocable surplus, not available surplus. So what is available is not available surplus, it's allocable surplus. Clear? Okay, sir. Now come again. Sir, how did I find, sir? Easy, sir. You find a gross profit. You deduct 4 items. Okay, you come with something called as available surplus. Okay, sir, I found available surplus. Now after 1968, 1968, correct? After 1968, your available surplus is not this. There are two more points to be considered. So what, sir? Come some more clarity, sir. Sir, available surplus is nothing. Gross profit minus so and so. That was before 1968. After 68, no, they said one adjustment you have to make. Oh, so what is that adjustment? Your normal available surplus. What is available surplus? Nothing but gross profit minus allowance. You'll get that figure, no, X. That X should be adjusted with one point, one concept. What is that concept? Sir, previous year. Okay, sir. So bonus is always a cost which the company can claim. So people, previous year my net profit was my tax payable was 1,000 rupees. Oh, okay. Did you pay bonus? Yes, sir, bonus. Oh, because of bonus your tax liability has reduced to 2,000. So okay, let me consider, if the bonus was not paid, so bonus was not paid, my tax liability would have been 1,300. Oh, so because of bonus you saved a 300 rupees in the previous year. Now add back this to your existing available surplus. It is called actual available surplus. So after 1968, whatever gross profit minus 4 items is your available surplus illa, plus you have to compute one more item. What is that item, sir? How much profit, how much benefit I have added to my previous year's tax because I paid bonus. So I compute a tax without bonus, tax after bonus. That benefit, no, that has to be added. That will be the net effect of your available surplus. Now you got the available surplus as X amount into 60% or 67% will become the total allocable surplus available with the company, total bucket, from which now you have to compute how many employees, what is the total outflow. 8.33 comes to this much amount, 20% comes to this much amount, compute accordingly, pay accordingly. Online, you have a clarity. Huh? Balance amount? 40%. 40% normal business profit. Okay. Now, people, fair idea? Confusing chapter but easy. If you go with the flow, I've given a flow chart. Go according to your choice. Whenever you feel it's okay, do that. One more point under this topic. Okay. Okay. Sir, there's something called set on and set off. People study material see set on and set off. People online, can I ask you questions? Give me an answer, people online. People online means people who have not attended my regular thing. Okay, try. People, my allocable surplus, I have 25 employees. My allocable surplus, which means available surplus into 6, which is the bucket which I have produced, I have found, is 20 lakh rupees. I have a bucket of 20 lakh rupees. These 25 people put together, I have to pay a minimum of 8.33, which comes to something called as 25 lakhs. Now, should I pay 25 lakhs or should I pay 20 lakhs only? Should I pay 25 lakhs or should I pay 20 lakhs only? You have to pay 25 lakhs because it's your liability. 8.33 is your obligation, no, statutory obligation. Even though you don't have a bucket, it is a statutory obligation. You have to pay 25 lakhs. It's a bucket da, but your obligation is more. But you have to pay no. 8.33 is you have to pay minimum. Minimum is statutory requirement. Yes, no. Okay. Okay. Okay, people. Now. So now I have to pay 25 lakhs. But I have only how much, sir? 20 lakhs. Statutory obligation of 20 lakhs, but I have to pay 25. No matter what, I have to borrow and get 5 more lakhs to pay. Now this 5 lakhs will be my negative balance. Huh? My obligation is 25 lakhs. I have to pay 25 lakhs. No. Huh. I have to pay 25 lakhs even though my allocable surplus is 20. Allocable. Okay. Compulsory 8.33 when you are having loss or negative also. Loss, negative, but lesser also you have to pay 8.33 no matter what. Maximum 20% da. You cannot have more than 20 because you will be attracting evil eyes. But I have 30% to be paid. Should I pay? No, you can't pay. But I have 20. 30 you have, it's not minimum. You have to pay minimum of 20. So it's like minimum also will be maximum. Maximum, minimum also 20 can happen. If you are a good company, your maximum and minimum is 20. If you are a poor company, you have to pay only minimum of 8.33. Clear? If you are rich enough, you have to pay 20. It's like you may pay. If you are a poor company, you have to pay 8.33. If you are a rich company, no matter what, you have to pay maximum of 20. You are a very rich company also, you cannot pay more than 20%. Clear, people? Now I have to pay 5%, no, 5 rupees extra. I am taking a loan for that 5 lakh rupees. Now this is a negative balance. I will call it as set off. I have to carry forward this to, I may carry it forward to 4 years. Next 4 years later, whenever I get a profit, you can set off. You can like adjust. Now, people, my allocable surplus is 25 lakhs. Allocable surplus is 25 lakhs. Okay. My 8.33 is 12 lakhs. 20% is 70 lakhs. 70 lakhs. Still I have to pay 70 lakhs because it becomes an obligation, people. Becomes an obligation. Because I have sufficient funds, I have to pay. Now 70 lakhs I have paid. But my bucket was 25 lakhs. 8 lakhs extra I have earned, no. That also you can take it as a set on reserve. So that in next 4 years, anyway 8.33 is my liability. Next year I got a loss. I have to pay 12. I can adjust from this amount. This also can be carry forward to 4 years. Loss also can be forward to 4 years. So deficiency of 8.33 obligation or extra after paying 20% you have in your pocket, you can carry forward to a maximum period of 4 years. Yes, no, people? Good, perfect. Okay. Tiny reserve. Specific reserve. That's why we call it bonus set on kind of thing. Accounting in area. People, everyone, freshers, first time attending, all good. Okay. People, order of set off, nothing. When you have I have set off this 2022, 23 also profit, 24 loss. I have to first use 22 because this has only 4 years, that has still 4 more years. Use that on a priority basis. First you take from the first set of thing. First carry forward, use first. Like a FIFO. Good people. Now. Huh? Okay. Now people. Time limit for paying bonus. People, I am a normal employee. I should get bonus within 8 months from the end of accounting year. So that's why accounting year, when your books are closed from there, 8 months. So probably I'll get it before November. Accounting year closes on 31st March. I'll get honor before November of the year. Sir, what if an employee is done misconduct? Then you can deduct the loss. Okay, sir. Sir, what if there is a dispute? There's a fight between. He said, I am eligible for bonus. I said, no, you are theft. You are a thief only. You did stolen things. You're not eligible. Now he went to court of law. Court said, hey, no, he's poor only. He's a genuine person. He should be paid bonus. All those 5 years you didn't pay, no, pay him. If there's a court order asking that he should be paid bonus, then you have to make a payment within 1 month. 1 month. So 3 points to remember under time limit. One normal scenario 8 months from the closure of accounting year. If there is a dispute from the award, what is award? Final or Indian dispute. I mean your award given by the authorities. From there 1 month you have to make the final payment. You are free to deduct the bonus from the misconduct amount. He has put something broken that can be deducted. Okay, people. Now, topic we started. First point, if it's not mandatory that as per the scenarios, you have to pay only one bonus. Like no need of paying customary bonus and this also. You have paid customary bonus. You can adjust that with this. If it's so, it's purely based on circumstances. If the circumstances says you have to pay both, you can't adjust. If not, you have paid Booja bonus this year by January. Now this liability will come in November. You can adjust that amount with the thing. Or you paid a part-time payment also, you can adjust with the total outflow. Clear? Sardi, okay? Hey. Adjust. Okay. Now people, bonus linked with the productivity. Like, sir, say for example, bonus being a combined effort. Can I keep that? Hey people, let's work together. If you work more, I'll give bonus. Okay. So what if I work less? You won't get. You can have some policies, but if that be the policy also, ensure that 8.33 and 20% limit you cannot cross. So meaning, if I'm getting my productivity is based on, I have produced 1 unit this much amount. It came to 10,000 rupees. Is profit based on is payment based on productivity came to 10,000. But 8.33 is 12,000. You have to pay 12,000. Okay. So what if it's 16,000? You have to pay 16,000. So it can be productivity based one, but it can never be less than the normal or more than the normal. Clear, people? You can have an extra point like upcoming points, like new innovative things coming in bonus. People, good enough to wrap up the chapter? Allocable surplus, available surplus. In the husband.
Minimum bonus 3.8.
You can deduct. Based on case to case. If I don't have a regular mode of paying a customer bonus, but I paid for this puja holidays, then by paying the statutory obligation I can deduct. Yes. in a financial, for a financial 8.33. Good. People okay? This chapter is okay? How many chapters? 5. How many more?
13.
1 minute, breathe it up. Asking myself. Suraj, breathe it up. So people who are new to the class, okay, you are able to understand revision speed. I'm sorry, but you have to adjust. So feel free to ask doubts. It's okay.
Profit based bonus deduct பண்ண முடியாது. Profit அதிகமாக வந்துட்டு bonus கொடுத்தா அது இதில் வராது. Adjustment.
இல்ல வராது. Customer bonus மட்டும்தான் you can adjust. People, one very small chapter, standing order. People, standing order. People, standing order. Very small chapter, very easy to understand. So why is standing order? People, law says it's better whenever an employer wants to take people. You do one thing. What are your conditions? You write. What are the terms and conditions? You write. Okay. Okay, sir. Anyway, I'll write in contract only, sir. Why? No. Law is telling you, you write. Write and send it across so that we will review and we will see whether the points are okay. Then we will approve that. Now, this will become a statutory obligation. You keep in the premises. That should be known to people, that they will know what is the working hours, when can they expect a bonus. So every factors, those can impress the employee. Should be drafted by the employer with subject to this act and schedule, present to the authorities will approve and keep it. Now you have to paste it in the proper premises where people are watching, so that they, without asking, sir, when can I expect a leave, sir, wages, sir, what is the procedure, who is the HR here, those information will be displayed. So it will be self-explanatory to the point. It's a collective effort that the employee knows everything before he joins. Similarly, employer cannot go back from its obligation. That's why concept of standing order comes. People okay? Okay. This certified, I told you, certified standard, it should be certified by an authority. The certificates and order become part of statutory and not contracted terms. That's the crux of this chapter. Meaning, you go to a court, you go to authority certifies the same, it becomes a statutory thing, not a pure contract. Many contract you can alter. Statutory is legal. You cannot go beyond that. People okay? People, the introduction is clear. Online? Okay. Now let's see what this chapter has to do. Okay. People, this certification should be done by a certifying officer who is a labor commissioner. Labor commissioner. Okay, sir. Labor commissioner. Employer can be anyone. Okay. Sir, we don't need that. Industrial association can be anything. We don't need that. Now comes the law. From here, the chapter will ask, they can ask you the question. Okay. This much only. Few points. Done. Now people. 6 months from the date in which act is applicable. So here applicable to epoda, your company is having 100. People remember 100 or more people are in your organization. This will apply. First page of your notebook, law. Chapter it will have 100. If your company is having 100 people, then you come under this category. Law says, I was having 95 people. Now I recently appointed 10 more people. I come under this bracket within 6 months. Within 6 months. The employer of the establishment, the employer of the particular factory, shall submit to the certifying officer. How many copies? 5 copies of his draft standing order. Whatever his terms and conditions are regarding the employment, that you prepare in 5 copies and give it to who? Certifying officer. Who is certifying officer? A labor commissioner. To certify. Correct? Yeah. Okay. Whenever you are preparing that particular draft, the draft should be as per your model. Meaning, whenever you are preparing a MOA, AOA, that should be your table AF. Remember? Company law. So the draft thing should always should stick on with the model standing order. Okay. Should contain every matter set in the schedule. It's a schedule of the act, but to comply with all those items in the schedule. And should also contain the particulars of workman employed as well as trade union. You should give the details of all your employees as well as trade unions working within your organization. Clear? Huh? Fair idea? Okay, sir. Now, it is the duty of the certifying officer to check whether it is fair and reasonable. Whatever draft you have prepared after checking model, let me see if it's anyayam or not, if it's good or not, if it's cool or not. Let's see the fairness and reasonableness. If you are not sticking with the provisions of this law, or if it's unreasonable, certifying officer will reject the same. Clear? Okay, sir. Okay. Now, what to do? So I'm an employer. I'm giving a 5 copies of my draft certifying of thing after checking the schedule of this act as well as the model given in the law. I prepared everything, sent to him. He observed the same thing. If he feel it's okay, he might approve. He might. Now what he has to do? This person, certifying officer, he shall forward the same to trade union or workman to give their objections if any. This is given by employer only, So let's see if your employees or trade union has something to say with this standing order. Okay. Now, after hearing both parties, employer, trade union, etc., you may certify. Then once it is certified, the copy should be given to employees or trade union or employees within 7 days of certification. So you don't straight away approve. You give a copy to employees or a trade union to get their consent as well. After that, you will certify. Certificate copy should be given to employers and employees. Okay, sir. This can be, this people giving an order, no, can be challenged. Meaning, no sir, anyayam, this is unreasonable. Whatever I have given 10 points, so why are you altering that point? That can be asked by the employer. Oh, how can it be that much? How can bonus be only 3%? It can be questioned by the workman or tradesman as the case may be. Within 30 days in which copies are sent by the employer, copies are sent to the employer or trade union as the case may be. Clear? Huh? Then it shall come into operation on the expiry of 30 days from. So once you are getting an approval, it shall come with the effect when 30 days from the date of approval. Okay. Now people, this shall be prominently posted in English as well as language understood by majority of his workmen, meaning Malayalam. Why being partial? Tamila, you want Tamila? You want Kannada? Okay, take your choice. You write in that language. And where should I keep it down? Where should I keep?
Where the employees come.
Front gate? It can be front gate. Need not be front gate. Wherever. Can be front gate. Need not be front gate. Wherever. Majority of my people jump through the back gate only. Then keep it in the back gate. Why? Or close the back gate, ask them to come in front gate. Why, sir? Now, the employer shall not modify, okay? Or once you prepare, you cannot modify, or second modification, third modification cannot happen within 6 months from that previous modification or first time. So first application or third modification, whatever be the case. Next modification should not happen within 6 months for the employer. But employee may appeal to get it changed. But employer, they are telling you, you only made this application. You have made this standing order. You cannot this changes within next 6 months. Employer cannot make an alteration in the next 6 months. Clear? Fair idea? People, last 2 parts of this chapter. People, what are the things I will disclose in the standing order? What I will disclose? You tell me. My classification of workman: permanent, temporary, part-time, apprentice, this is that. What are your period of work? What are your holidays? What is your shift? Attendance, late coming, punching. Who is the authority to grant you leave? Which gate we should come in? Closing and opening of gate. When can you expect a bonus? When can I terminate you? What is the payment at the time of laying off? Those things can be in your suspension, dismiss, etc. can be in your standing order. General point, but try to remember 4 or 5 points. Okay? Okay, thank you. Thank you. Okay, people. There is something called as one question they can ask you, 5-mark question. Every question is 5 marks. There is something called as subsistence allowance. Very important. People remember subsistence allowance? People, in a establishment, you have made it clear that you are going to terminate employees as and when required. Now, I am terminating someone because of his misconduct. Okay? Misconduct. Now, people, misconduct should be proved. Correct? Misconduct should be proved. Theft. I should check the CCTV and to confirm. Now, before that confirmation, I am asking him to go out. Hey, go out, Ra. You will come after only after if it's proved otherwise. Then only you will come back. If not, you go. End of your career. Now this thing is happening. Judgment is happening. Court is hearing. That period, you have to pay wages at the rate of 50% for initial 90 days of termination. Okay, so your initial period of your suspension, you have to make payment at the rate of 50%. Sir, after that, sir, it is going beyond 90 days, then 75%. Provided that this was not due to the reason of the employee. Come again. Sir, I am sending you out for 2 months. I have to pay 50% for each month. Sir, I am asking him to go out for 90 days. Again, half pay. After 9 months, court said come back. He is not coming because he will get payment now. It's like, oh, anyway, I need not work. I'll get 75%. It cannot happen. If it's your reason you are not coming back, it's again 50% only. If it's employer's reason that you are not coming back, not reinstating, then you'll get 75% of the wages as compensation. Provided you are not working somewhere else. Remember, inbuilt thing, no second employment. Suggest some good gyms in Koramangalava. People, I am from Trivandrum, Kerala. I am here in Chennai. Okay? Okay? Happy? കോറമംഗലക്ക് എനിക്ക് സംബന്ധമില്ല. ഐ മീൻ ಗೊತ್ತಿಲ್ಲ. Okay. Poor Malayali who came to Chennai to teach, that too in Tamilalam. It's Tamilalam da. In Kannada I can talk in Kalmalu. Kalmalu, Malayalam and Kannada put together. Kalmalu. Telugu easy da. Telugu. No Telugu, it's okay. Okay? End of the chapter. So subsistence allowance only the important. Otherwise it's cool. Suspension period is expired. This happens only when this is an issue happening in a labor court. Suspended, he is going out. Okay.
After 2 months of suspension, if he is not voluntarily not going, then will he get a person?
No. Only when the issue is running. He should not suffer, no. His daily wages should not suffer, no. I have to pay. Or say for he is proven guilty, I have freedom to take it back. I can recover it back, or I can deduct from his gratuity, etc. That can be done. Now this is to protect the employer as well. Employer should not suffer during the that period. Okay, sir. People done.
So if he is found guilty,
If he's found guilty means payment is done. Payment will be given, but that can be deducted from your gratuity accordingly, because you can't get bonus. Those things can be deducted. No, that can be deducted. So till proven, I'm giving you money, but I cannot pay full pages because you are not working. Okay, people. Sixth chapter. Sixth chapter done now. Oh. Sixth is done. Now it's seventh. So total 18. Six is done. Oh, 18. 12 more. 1/3 done.
Today around 10 chapters will be.
No. 12. I'm planning majority portions today. Tomorrow we'll quickly see other chapters and a kind of revision of these small chapters. Again revision. Okay. Now we'll see. Let's see.
Even like previous year question papers.
Previous year question have nothing to do with it. Nothing. Straightforward. Just to
See like how questions they are
But that's given in regular. Okay, we'll see. Okay. 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 Okay, people. Let's see. Now, people. Payment, wages, payment of wages. Okay. Anyway, it will come in YouTube. You can watch again and again. Make yourself clear. Slow, 2 speeder, 1 speeder. It will work. I'm already like it's like almost 30 days of law. Foundation and this thing, your CS executive. So, okay. Wages, minimum wages. Okay. 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 People, let's focus on wages, minimum wages. Okay. Then we'll take a break probably. Then we'll start with PF and ESI. Okay. Then we have small chapters. Yeah. Okay. Gratuity. Small chapter. Child, adolescent. We can say. Okay. Cool. Okay. So probably I want Factories Act, Industry Dispute, Gratuity, Constitution, your Labor Code for tomorrow. Anyway, that's 5 chapters are for tomorrow. We'll try to finish. See other chapters. Let's see. Gratuity is continuous service. Okay. Okay. People, let's see wages and minimum wages. Okay. Okay. You see, it's minimum wages. What's this? What's your price? This is pretty. Okay. People, tell your corporate story. Roma Mukyo. Sumanada. People, Minimum Wages Act and Wages Act. It will be motivating for everyone, I know, but sad for me also. No? I'll be like, oh, you, why is teaching? So I should have been in corporate now. People, teaching people like you. Okay, people, Minimum Wages Act. I'll put an Instagram story, motivating story I'll put. Trust me. Now, people, Minimum Wages Act. People, why minimum wage act? Why do you think it's a minimum wage act? Why?
So the worker can at least survive.
Yes. People, India, unemployment, employers are less, employees are more. If something happens, I can terminate too. Similarly, I have a power to fix a salary like 10,000 rupees. If you don't work, will come. Echil kay atana ayiram kaka. Okay. Meaning, if you show that hands with the food extra, there will be 100 cross coming to you. That's how the system is. Cross illada, cross. Okay. Now, people. Now, so let me intervene. Who? Let me. The government be intervening to fix a wage, minimum wage, so that people will at least be safe. Employees will not be exploited. So let's have government intervention in fixing a minimum wage. Okay, sir. Okay. People, first part is there are two schedules given. People, very important, two schedules. From there chapter starts. It's not about salary. It's not every, it's about your note on schedules in the Minimum Wages Act. There are two schedules in the Act. One part, two schedules. So first schedule you have part 1 and part 2. Part 1 talks about 12 entries. Not 12, there are more. And second part is regarding agriculture. So part 2 is regarding agriculture industry. Other thing is regarding any other subject matter. Okay. So any other subject matter is part 1. Part 2 is agriculture. Okay, sir. Okay. Now, people, appropriate government is required to fix minimum wages for the employment listed in part 1 of the schedule. Must be fixed. Part of the schedule. Okay. Now, people think like this. Appropriate government, meaning state government. State government may fix minimum wages payable to any industry in the particular state. Say for example, I am coming from Tamil Nadu. There is some industry called crackers, Diwali. Okay. So Sivagasi, Madurai, everywhere it's happening. So government should fix a minimum wage for the entire state. Meaning, let it be Kanyakumari, let it be Chennai, let it be Kadalur. Minimum wage should be 185 rupees only. But in a state, availability of water, availability of sun, availability of fertilizers, availability of tractors will be different. Okay. So Pollachi may have a different wage with respect to agriculture than Chennai. So let's say for agriculture industry, even though within the state they can have a different classification by the appropriate government. So appropriate government, while fixing a minimum wages for an item under schedule 1, part 1, which is for any other industry other than agriculture, it should be uniform. For agriculture industry, it can be place to place difference even though within the same state. Okay, all good. Okay. Now people, if the total number of people working in that industry, say for example Uber, say for example it's a year 2012, Uber is coming to Tamil Nadu. The number of Uber workers are only 600. An entire state put together. Then government need not fix a minimum wage for Uber industry. Ola, Uber, you need not fix. If the total number of employees working in that particular sector in a state is less than 1000. Okay. 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 Sir, how minimum wages are fixed? It can be time based, like hour based thing, or piece rate thing, or a guaranteed time rate, or overtime. I can say that if you work for 8 hours, you will get 1000 rupees, or 1 unit of churidar, you will get 1000 rupees. It can be time rate or piece rate. But what if an employee is not able to stitch a particular churidar in a single day? Law says we will give you guaranteed time rate, like a 500 plus material, so that he will not suffer for the day. You have to buy things now. So we can have guaranteed time rate when it comes to a industry where piecework is there, but people might find it difficult. Inexperienced people will find it difficult to produce the desired level of output. Okay. Now, there can be variation on the subcategory, like a 5 years experienced tailor and 5 years experience of a constructor worker can be different pay. Adult worker, adolescent child apprentice can be different. Different zones, different cities can also be different, because people for a sunrise in Gujarat and sunrise in Assam, both having tea plants, can be different. Sun comes very early in Assam, being the east side, correct? Yeah? Assam, West Bengal, which side? Ra? Yeah? West Bengal, which side? Ra? West illa? People West Bengal, east or west?
East.
Okay, welcome to law. Okay. People wages can be fixed for hour, day, month, or any longer period. But remember, it is subject to Payment of Wages Act. What is Payment of Wages Act says? It says it cannot be, no wage period can be more than 1 month. Meaning, I can say that you work day, I'll pay. You work for 2 weeks, I'll pay after 2 weeks. If I say I'll pay after 2 months, it's not possible. No wage period can be more than 1 month. Okay. Okay. Now people, you're that part, the components of minimum wage. There are 3 parts, 3 options, correct? 3 options. You have 3 options to compute. 1. Okay. 3 options, the option 3. Option 3. Okay. People, it can be basic wage plus cost of living allowance, or basic wage excluding cost of allowance but including value of concessions, or it can be all the put together. Okay, so it can be basic pay plus your allowance, which is cost of living allowance, or basic pay excluding cost of allowance but including value of concessions, or it can be all the 3 when you fix the minimum wages. So minimum wages cannot be 10,000 rupees, it can be 300 rupees. Okay, but 300 participants can be basic pay plus cost of living, or basic pay plus value of concession, or put together all. Okay. Okay, people. Okay, now people, this is the most expected question from this chapter, if any. Okay, people, appropriate government, for the appropriate government to fix the minimum wages, they have 2 methods. One, committee method. committee method. Second method is notification method. People, appropriate government may appoint committees. These committees will consider everything. They'll come with the minimum wages. And government is it's an advisory support. Government is not obliged. If they want, they can take that. If not, they don't want. And remember, your committee should have representatives of employers and employees, 1/3 being independent. Okay, they'll have a committee with these people. Once this is approved by the government, they'll put it in the official gazette. They'll keep it in the official gazette. People study material, you have the one more point. Keep it in the official gazette. Now it will become a minimum wage. So how to fix a minimum wages as per committee method? You'll have a committees or subcommittees with 1/3 being employer, employees and independent people. They'll work on the various parameters, come with an answer. That will be notified in the official gazette. Or notification method. What I'll do? People, I can make a notification in the gazette asking people to reply. Hey people, we are planning to revise. You give me suggestions. They'll consider all those suggestions and they'll review everything. Then they will come with something called as notification method. No committees. They'll have an advisory committee to help with them. But notification method is more open, where it's open to you people also to give suggestions. Say for example, ICS is revising a syllabus. I frame a committee to redraft the syllabus. It's called committee method. I'm putting it in open platform in Instagram, asking you people to comment. From that I'm giving, that's called CA? CF Tukanama. Important subject. Corporate accounts and financial management. So you want to remove JAG and CA, Papa?
JIG is still better.
Okay. How much syllabus? No comments, people. Enjoy. Tax all no da. Tax. Okay. People, you can have taken advice of advisory boards as well. Okay. So you give a Instagram notification, people will comment, that will be asked to advisory board, advisory will decide, then we will put in the again in the notification. From there, this will be effective. Okay, sir. Advisory board will have committees, subcommittees, they will advise on the same. Advisory board also will have representative of employees and independent persons. Okay, sir. Now, people, representation from employers or employees need not be of every industry. Say for example, there are 100 industries, khadi, this, that, but I want only 3 people. But I took only textile, crackers and steel. It's okay. You need not have every people representation. Any three or any 4 people should be there. Different industries can be possible. Minimum wages should be paid in cash or kind. But if it's kind, no, should have that properly accounted as what is the monetary value of the kind. It's okay, but yes. Kind also. So if I say 100 rupees as the minimum wage, you can pay 100 rupees or 10 kg wheat. But 10 kg wheat is 80 rupees, then that's a violation. You have to pay in that should be as per the monetary value. Okay, Sardi? Okay. Okay. People, fixing hours of a normal working day. People, appropriate government, no, they can fix the normal working hours. Sir, 8 hours you have to work, 6 hours you have to work. That can be fixed by these people. And remember, 1 day off. Like every 7 days you should have 1 day off. That's why Sunday you are not working. Okay. Then you have to pay overtime at a like if you are paying, say for example, if you Sunday you are asked to work, then if the overtime payment is 1 lakh rupees, you have to get that 1 lakh rupees for Sunday's work. So people, appropriate government can fix the normal working day. They have to give 1 day off. If you are asked to work on 1 day, then 1 day's payment is not normal pay, it's overtime payment, like extra payment you will get. Okay. Now people, this provision will have an exception. Say for example, emergency worker, fire engine, we can't allow them to work for 9 to 7 only. After emergency, you have to work. Not less than the overtime. Minimum overtime payment. Okay. Preparation of complementary or other work. Preparatory or complementary. Say for example, office starts at 10 o'clock. Buyer should be there to clean everything. Make coffee. That should be done. Preparatory complementary work should happen. Or something which has to be dependent on natural forces. Like say for example, if it is going to rain, before that I should complete the work. So if that be the case, those things can have a separate rule regarding working hours. Otherwise, working hours is fixed. Okay. People wages for less than normal working day. Very important point. Say for example, if you're an employee, not because of his fault, he is asked to work for less than normal period. 8 hours you have to work to get the payment. But because of employer's fault, you are getting only 6 hours work. You can claim wages for 8 hours. Because it was not my fault. Employers should keep registers, should display the notice, maintain wages, books or slips. Okay, one more point. If there is a problem, we have Commissioner for Workmen Compensation, any other officer appointed by central government or state government for the purpose of having this problem solved. Very easy chapter. One point you have to remember is committee methods, those two methods, and fixing the hours of work, and scenarios in which working hours need not be fixed. Natural calamities, preparatory work, supplementary work and all. 2 points. This was previous chapter. No, that should be as per my note. No.
No, I saw the next chapter was payment of wages.
But I saw it was bonus. I thought it was bonus. No. Okay. See.
After bonus, it was payment.
Okay. Next is bonus. After that was okay.
Payment. Okay.
Labor code.
Labor. Maybe the previous.
Or I didn't add.
number
I,
page.
I saw this. I tried.
No, second number page. Direct to the text. You can type 2 and
Okay. No, one.
140.
It's not covered? No, Allah? Okay. Okay. So payment of wage act is to be covered. Okay. 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 People will see child and adolescent worker, they'll come back. Payment of wages is to be covered. It's not there. People, which chapter? Child and adolescent. Okay. Very small chapter, people. Child and adolescent. People. Child and Adolescent Labor Prohibition and Regulation Act of 1986. People, this is based on a law where they say, like, you usually till 14 years you have to give a free and compulsory education. Now law says it's prohibition of employment of child under 14 years in hazardous occupation. Okay. Now let's see. There are two concepts to understand. One, who is an adolescent, who is a child. Law is telling you adolescent means a person who has completed 14 but less than 18. Child is someone who has yet to complete 14 years. 2 points. To understand this chapter, you should know the chapter is regarding how to control these people, because child labor is a challenge. It's a burning issue. So they said because of some issues you can't have child labor. Law says they should have the schooling. Law says let's regulate their employment. So child they have defined up to 14 years, adolescent up to 18. Now people, 2 points, only 3 points under this chapter. Da. 1, you are having prohibition of employment children in any occupation. First point, children cannot be asked to work in any occupations. Any occupations or yes, any occupation they are not allowed to do, except help his family other than any hazardous thing after school hours or vacation, or he can be a cinema actor. Okay. So a child cannot work in a factory or a hazardous occupation. Okay. But so meaning he can work with his family business after school hours. He can work with his family after school hours. Otherwise no. Or vacation time he can work. Otherwise no. Okay. Now people, adolescent means 14 but less than 18. Those people can work but cannot work in hazardous occupation. They need not have after school and all. After 14 he can work, but not in hazardous. What is hazardous? Mine, inflammable substance, hazardous process. Asara process means as per Factories Act. After factory, subject to Factories Act, or like as per Factories Act, you have to check what is Asara process. Okay. Now, one more point for this chapter. So, two chapter. One, child cannot be entitled to work in any place, any work, but exception family, after office hours or this thing, or cinema artistic kind of thing. Huh? Holidays, sir. Okay. Then for a adolescent. Okay. Good. Now one more point, which is work slot, work time of a adolescent. They are telling you. Remember, people, there is a correction there. There, your point will be having second point. There will be called child. This child shall be arranged that inclusive of the rest interval. But I would say it's not child. It should be adolescent only. Every point is regarding adolescent. Now, point says this is the most important question from this chapter. How this law is regulating the working of adolescent. Child, anyway, you can't work. Only those two scenarios. Adolescent, you know, he can work, but person who is not completed 18 years, he cannot be access to work like 3 hours continuously. Only after 3 years he can be allowed to work, provided he is given a 1 hour break. And you give 3 hours, 4 hours, whatever be the case, total spread over, total working time you are here in the factory cannot be more than 6 hours. Okay, 2 points. Now, you cannot be allowed after 7 p.m., 8 a.m. That time slot is not allowed for an adolescent. Now, no overtime. Similarly, he is already working with some other place. That day, he cannot be allowed to work in our factory. Yeah. Another, you cannot have double employment. So, no double employment, no overtime, no 7 p.m. to 8 a.m. That's all. Only those 2 points you have to remember. One, no child labor, no adolescent labor, adolescent working hours has been regulated. Okay. Nanna. 8 chapters done. Now, Nayana. Now 10 is there. 10. Okay, we'll take a break and come back. We'll complete that. Hey, hello. People will start with EPF ESI. Probably there is a copy paste error of the Payment of Wages Act. I failed to copy paste. Yesterday's last minute shortcuts. I had failed to copy paste. So tomorrow we'll do that. Let's do EPF and ESI. People, ESI and EPF. So people, what are the chapters you remember pending? People, you have Factories Act pending, Industrial Dispute pending, Industrial Employment, what did you say? Standing order is done now. Contract labor is pending. Apprentice is pending. Gratuity is pending.
Payment of wages.
Payment of wages, POGA is pending. I mean, pay wages. Labor code is pending. Constitution. Only this. 1, 3, 4, 5, 6, 7, 8. So, other than PF and ESI, 8 is pending.
Yes.
Now it's 8 done.
8 done.
Okay. So we'll try to finish Okay, we'll try to finish 3 units: EPF, ESA, and one more unit from this part, contract or apprentice. We'll see. Today, now 3 chapters: EPF, ESA, and this apprentice probably. Let's see. People, ESA. People, state insurance as well as provident fund. 2 chapters. Small chapter but impactful chapters. People, what is employee state insurance? The provision is regarding creation of an insurance scheme. People, why insurance scheme is very important? People, for people like us, company secretaries, for us, we will be having good payment, good enough to take an insurance. From your payment, say for example, yearly it's 1,000 rupees. Still, we will be able to manage that thing. But think about a normal person, normal employee who is working for 16,000 salary, paying a health insurance, life insurance, those things. So, law made it mandatory, Yuvraj, law made it mandatory for employer also take insurance, like a insurance during the work time, so that employer will pay us part, employee pays a little part, so that put together we will be helping the employee. So if I ask him to pay, he won't pay. But if I put something, he is asking him to pay, he will also put something. Thereby I can do something for his benefit when it comes to sickness, maternity, disablement, dependence benefit, or any other welfare related support to employees. So this employee state insurance is an insurance coverage given to an employee with respect to sickness, maternity benefit, disablement, dependence benefit, and any other welfare. Okay. It applies to 20 employees. So when it comes to a employment where 20 people are employed, you will get a coverage, insurance coverage. You have to, employer has to take insurance for your employees. Okay, sir. Now people, there's one point called as confinement. What is confinement? Confinement means a labor, meaning an operation of that particular woman after 26 weeks of pregnancy, resulting in a child living out death. Meaning after her pregnancy, some complications happens, provided you are making a confinement, meaning after 26 weeks, there is an operation being held, whether the child survives or not, I call it as confinement. Law is here to protect that also. Say for example, after 3 weeks of pregnancy, something happened, we are not to protect. But confinement, there should be a confinement period, like 26 weeks. After 26 weeks, something happens, we are here to protect you. That's why this word is defined. Now, contribution means sum of money payable to the corporation by principal employer and in respect to employee and the inclusion. Okay. People, I have to pay on his behalf as well as I have to pay for him. Meaning, I have to, say for example, 10,000 is his pay. I have to pay some 100 rupees. I have to deduct 100 rupees from his payment as well. Both should be submitted by the employer to the ESA fund. Okay, so that there is a fund available, so that something happens, ESA fund will take care of all these things. Clear? We are creating a fund out of this ESA. Okay. Now people, there are people dependent, like this is to cover people also, my dependent also. Say for example, the employee dies, there should be some benefit given to his dependent people also. So to know who is a dependent, we have given like this: relatives of the deceased person, like his widow, his legitimate or adopted son who has not attained 25 years, his widowed mother. If someone is wholly dependent on him or wholly or partly dependent, do I really need? No. You should know there are dependents. This provision is applicable for protecting the insured person as well as dependent. Okay. Now people, there is something called employment injury. injury to an employee caused by an accident or occupational disease arising out of and in course of employment. People, a person got varicose vein during the continuous standing, or there is a asthma because of arising out of or in the course of employment. We are here to protect, because employment injury we will get insurance coverage. Okay. Now. Okay. Wage limit, people, up to 21,000 only we are covering. Insurance is covered for people employed up to 21,000. Okay. Okay. Few definitions, extra definitions. We are yet to start the chapter, but few definitions. There can be a seasonal factory. People, seasonal factory is something which is like a cotton, jute, groundnuts, coffee, indigo, something we call it as seasonal factory. Or if it is working less than 7 months in a year, we call it a seasonal factory. Do we need? No. Just to know that seasonal factory also, whether seasonal employees are covered or not. That's why we have this provision. Now people, there are two words: permanent, partial disablement. Permanent, it's permanent but partial. Say for example, I work in a factory using my hand, legs or something. I lost my hands or legs, because of which my earning capacity is reduced, not the entire capacity. If I have lost my entire capacity, it's called permanent total disablement. Just my some earning capacity. Earlier I would have received 10,000 rupees, now I can get till 8,000 because I became slow. Or I can't be getting appointed because I lost everything. That's called permanent total. Why the law is telling all these things? If it's a permanent total, you will get 100 rupees compensation. Not permanent, it's like based on the limit of the injury. Like you got only 80% damage, then 80% insurance coverage. Okay. Okay. Now let's dive into the provisions. Okay. Who must be insured? What is this provision? This provision is regarding the insurance to be given. People don't eat nails. Too many people every morning, from morning eating upma and nails. What a combination. People, it is mandatory for all employees working in a factories. Okay, all employees working in a factory, we should give something called as insurance. Who pays insurance? Law says it should be employee and employer. Okay, it should be paid by employer and employer. How paid? Employer will pay from his pocket. From employee's thing, he will deduct and pay the remaining only as salary. What advantage I will get? So they can ask you the question, what are the advantage I am getting? Sickness benefit, maternity benefit, disability benefit, dependence benefit, medical benefit, funeral expense. I can get for my sickness, maternity benefit, disablement if any, dependence benefit, medical benefit, or even funeral expense. Thus, the funeral expense also can be covered under insurance. Okay. Okay. Now people, okay. Now let's see something called as first topic, first exam related topic. What is ESI corporation? People, for the purpose of governing this law, we have something called as ESI corporation, Employee State Insurance Corporation. People, this corporation will have two subunits. One is a medical benefit committee and a standing committee. Medical benefit and a standing committee. Two two parts are being added in this list. ESA corporation. Okay, people. So what is this committee? They say this committee, this particular ESA corporation, they say the corporation consists of people like chairperson, vice chairperson, members representing employers, employees, medical professional people, nothing more to worry. First question, what are the powers of this corporation? ESA corporation power. They are telling you they are aimed to promote measures for improving health and welfare of insured person. Whoever be the insured person, for their health and welfare to improve, what are things I can do? Can I create more hospitals, more dispensaries, more insurance coverage, add more items to their health problems? Those things can be done by these people. And for rehabilitation, re-employment, what if a person lost his 2 legs? Rehabilitation center, or get some other job which will be helpful for him. So what is the purpose of ESI corporation? To try to improve health and welfare of insured person, plus trying for rehabilitation and re-employment of insured person. 2 objectives. Clear? Okay, sir. Now come to what are the wings of this corporation. So when someone is asking a question on ESA corporation, write something. What is this ESA corporation? Now come to 2 wings, very important. First thing is standing committee. What is standing committee? Nothing but a replicate of our corporation, meaning administration work. Same. Whatever corporation has to do, corporations do the same work has to be done by this standing committee. They have to do same administration. Now we have medical benefit council. We will have doctors kind of thing. What their power is? To administer the medical benefit. Powers and duties of investigation. If something is going wrong in a factory, they can inspect. Then medical treatment, etc. So what are the powers of medical benefit council? They'll see what are the medical benefit available. Advice on medical benefits to be given. Whenever there is a occupational injury happen, let me investigate. Or some medical treatment and attendance. That should be the role of medical council. Okay. Now people, okay, people out of syllabus da. Out of syllabus. People, I told you contribution should be made by employer and employees. How much? They are telling you employer should pay 3.25% of the wages of the employee. From the employee's part, he should deduct 0.75% from the wages. PF 4% in total, 3.25 from employer, 0.75 from employee. That's how you do. People, you have to make a contribution on or before the last day of a wage period, meaning before 30th, you have to make a contribution. Okay. Okay, done. Extra points da. Now come to this part. ESA fund. We have seen for ESA chapter, we have 3 topics, not the contribution. ESA corporation comprising of 2 committees. ESA fund. Similarly, ESA tribunals. ESA courts, 3 parts. Now people, ESA corporation, what is their role? To improve health, this thing, rehabilitation, all these things, they need money, no? So they should need something called as ESA fund. So ESA fund means a fund created by the ESA corporation. Okay. This ESA corporation, one of the element of the fund is employers and employees contribution. Now let's see what are the amounts which will be added to this fund. 1. Employers, employees' contribution will come under the fund. Then grants, gift, donation given by central government, state government will come under the thing. Okay. Now you have to open a bank account with RBI or some other bank in the name of this ESI, because that's where your funds will come. Okay. Now people, what they will use the funds for? One question. Now people are asking for Medicare benefit. You go for Medicare benefit. You'll get a hospital bill. Who will pay? Insurance. For that amount, where will they get from the fund? Payment of benefits and medical treatment. People, there are people in your Medicare benefit council. Who will pay their salary? Fund will pay the salary. So salary, fees, etc. will be paid from the fund. Now, let me have more hospitals, dispensaries. Who will fund? ESI fund will fund that particular activity. People, what if some people are, say for example, I have paid some private hospitals, you have made payment. You went to a bill with a private hospital, treatment with a private hospital. Let me make a payment to that private hospitals. Or asking a facility in the private hospital to create this thing for, because say for example, immediate hospital is 10 kilometers away. So I'm allowing a private company, a private hospital, can you also provide that facility? I'll give you so and so amount. So and so allowance I'll give. Now, insurance, for insurance you will have to fight in court. That court fees also can be given by the ESI fund. These are, or creating a health and welfare for the people are also the obligation of ESI fund. That's all. It's a duty of the principal employer to pay contribution in the first instance. What if I am appointing the employee through a contractor? It's an obligation of the contractor. But if I have paid, I can deduct the amount from the amount payable to the contractor. I can do that. Now people, important point. What are the benefits I will get from the ESI? 1. If the sickness is been certified, I can get periodical payment in the form. For sickness, I will get the amount. In case of confinement or miscarriage, I can get periodical payment. Disablement, I can get periodical payment. I died, dependent can get periodical payment. Medical treatment of the insured person, funeral expense of the insured person. So I can get periodical payment with respect to sickness, confinement, disablement, periodical payment with respect to my health or medical treatment and attendance on insured person. Funeral expense, everything can be claimed by from the fund. Insurance can be claimed. These rights are not transferable. Sir, I don't have a problem. My neighbor is having a problem. I have already paid insurance. That doesn't mean that you can assign your power to your neighbor. It's for you or your dependent or your family. It's not for your neighbor. Now, for the purpose of this thing, we have ESI court. Okay, sir. They have two powers. One, adjudication of dispute, adjudication of claims. Whether this item is a dispute, who will decide? ESI court. How much amount of compensation should be given? Decided by ESI courts. Very small chapter, but remember what are the benefits available, what is ESI corporation, what is ESI fund and uses of fund, then ESI courts and two powers. What are the two powers? Adjudication of dispute. Problems you can decide or claims you can finalize. These are the two powers of ESI court. Small chapter, 5 marks question probably. People, we will push 2 more chapters. One is Provident Fund and probably Apprentice Act. Okay. Provident Fund, another important contribution based chapter where you have to understand what happens in this chapter. Provident Fund. Okay, people, Provident Fund. People, ESA has insurance when it comes to employment issues, employment health injury and all. Provident Fund is actually another people. Provident Fund, no? Provident Fund, we have three schemes. People, very important chapter for this exam. Employees Provident Fund. One, we have a PF scheme, a pension scheme, and an IDLI. What is IDLI? Employees Deposit Linked Scheme. Okay, insurance scheme. Three things. So people, three insurances covered. Three insurance. Sir, why it says Employees Provident Fund? It says Employees Pension Scheme. It says Employees Deposit Linked Insurance Scheme. People, remember. So previous chapters we saw something else, insurance. No, that insurance was for the employee. Now it's for the nominees. Let's see. Let's take, it's a life insurance. Okay. Now let's see this chapter. Okay. So this chapter is also very small but very important for exams. Okay. People, Provident Fund. Tell me what is Provident Fund, Ra? You are working in an employment, you are leaving the organization, I will pay your lump sum payment. Or you are working in a factory, you are going out, I will pay you monthly based in the form of pension. Or you are working in a factory, you died, I will help your nominees in the form of IDLI. So three benefits. One, you retire, you get a lump sum amount as PF, or you retire, you get a monthly payments as pension, or during your death you will get your legal representation, you will get something called as IDLI, benefits from insurance. 3 points. Okay. People, whenever you have 20 or more people employed, this applies when you have 20 or more people employed. Okay. People, there are 3 exemptions. People, small corporate society, meaning I have more than 20 but less than 50. I have more than 20 people but less than 50 people. Okay. Then even though I am more than 20, I need not comply with EPF Act. So I need not comply with EPF Act if I am less than 20. But law says if you are more than 20 but less than 50, but you are a cooperative society, you need not comply with this thing. Or when government controlled industries, you don't have to follow, because government will have already designed some good system for Provident Fund and ESI. Why would you bother? Okay. Now, okay, people, 3 topics we are done. People understand. It's not in the syllabus, but understand. People, in your books it will be given as 10%, 1%. But I am redrafting this thing, very important, people. People, say for example, salary. Everyone online, very important. Say for example, your salary, you have to recompute as per this chapter. Say for example, you have payment, you have a salary. Employer has to pay and employer has to pay. Law says it was 10%, now it's turned as 12%. Meaning, from employee's salary, I'll deduct 12%. From employer's salary also, I'll deduct 12%. But there are 3 schemes now. Let's see how these 3 schemes are drafted. 1. 3 schemes are EPF, ESI and IDLI are, I mean EPF, pension and IDLI are 4. From employee, no, you deduct 12%. 12% you are deducting. Then keep the 12% entirely for PF. PF. So you have to deduct 12%. 12% straight away you give to PF. Employer, you have to deduct 12%. But in such a manner that, 3.67 goes to PF. EPS 8.33. Put together 12. So let's assume go like this. You have to contribute 12 from employer and 12 from employee. But we have 3 schemes: PF, pension, and IDLI. Law is telling you from employee, entire 12% goes to PF. Employer part you divide further. 12% should be divided between these two people. 3.67 here. 8.33. I mean 8.33 here. Done now. Sir, but IDLI extra 0.5. Extra 0.5. But remember, for its law says it's 12. Your book also says it's 12. But I am telling you different. It's not 12. It's 12. But 12 means from employee, the entire 12 goes to PF. So employee anyway, he's contribute 12% to PF now. Employee has to also contribute. They say not equally. Pay like you have to take 12%, but 12% you have to give 3.67 to PF, 8.33 to pension. So it's 3.67 plus 8.33 comes to 12. Done. Sir, upon IDLI extra you spend 0.5. So employer might have to pay 12.5. Employer has to pay 12. Then for these 3 schemes, there is an administration cost that should be borne by employer only. Employee varadu. It should be everything should be, any expense relating to administration of the scheme should be done by employer. So let's see how this is done. People, law says it's equally. Now people, 12,000, how will you distribute? Obligation is actually 12%. How much da? 1,200. Correct? Straight away it's 1,200. So PF done, employee is done. Nothing more. For employer, 1,200 you have, that should be distributed among PS more, PF less. Like this you do. Then extra 0.5 for IDLI from employer only. And there can be some administrative expense also, some expense, if any. Put together, employer might have to pay more than 12%, but employee has to pay maximum of 12%. But employee's payment will go only to PF. People online, did you get the point? Okay. Now let's see this chapter. People, 3 schemes we have to study 3 schemes. That's the end of the chapter. People, provident fund. People, employees provident fund scheme is administered by central board. It's governed by central board. Okay. Central board has the power to manage the funds. Okay. People, the question is, every employer is entitled and required to, it's mandatory for the employer to have EPF for the benefit of the employee. But law says there are some exceptions. Some employees are excluded. Who are the employees excluded, sir? Sir, say for example, you are an apprentice. EPF Act is not applicable for you. Meaning, employer need not cut 12% from employee. He need not pay 12% because you are an apprentice. Or if you are earning a high salary like 15,000, Then also, there's nothing called EPF contribution. So 15,000 not possible. Wages at a bonus, what was the limit? 21,000 bonus. Here is 15,000. Now, similarly, a person who's withdrawn his fund from a PF, no, if you have some emergency, you can withdraw the fund. If you have withdrawn such fund, then also you are not covered. People I have coming from previous employment left. That time I withdraw every money PF and I have enjoyed. Now, for new employment, you need not get the PF thing. Employer may choose not to give a PF. Now, PF is not applicable for exempted employees or excluded employees. Who are the excluded employees? Apprentice not covered. Persons drawing more than 15,000 not covered. Similarly, who has done this, who has burned his entire savings. He has withdrawn his all this PF amount. We won't consider them. Okay. People online, 3 points are done. People, study material, mark, it's not 10%, it's 12%. You see the contribution part of PF, there will be 10%, it's 12%. So now question is, how much is 12%? 12% of, remember, please understand, please mug up this before the exams. Wages, DA, retaining allowance and any cash value of consideration. Okay, it should be cash value of concession. Your study means it will be there. It should be cash value of food concessions. People, 3 points. 12, when I say 12%, it's not 1 lakh rupees into 12%. What is the basic pages? What is the DA? What is the retail allowance? And any cash value of food concessions. 4 elements. If you see the material, you have 4 items. That 4 items only into 12% should be deducted or contribute as the case may be. Okay. Okay, people. Okay. Now, people, only one question they can ask you is, what are the allowable advances and withdrawal from the PF account? Sir, I have a PF account which is rich. What are the amounts I can withdraw? Meaning, no repayment. Take it fully from the balance. So, I from year onwards, I have carried like 5 lakh rupees balance. Can I take the 5 lakh balance? If you are taking it fully, I call it as withdrawal. You are taking some part, which is called advance taken. Now, advances can be to be repaid or not to be repaid. This topic is regarding what are the withdrawals, which means total taken, as well as what are the advances. Okay. Now, people, from a PF, there are 2 withdrawals given, point number 8 and point number 2 probably. People, say for example, I was working. My PF account has a credit balance of 1 crore rupees. If I want, I can withdraw the money for purchasing a house. I took that from as a loan, I need not pay them. You can take, because it was earned by me. That can be used for buying a house. Or, for exam purpose only, 2 words are important. Or withdrawal for repayment of loan in special case. 2 things. 1, withdrawal for buying a house or withdrawal for repayment of loan. 2 things. It can be your withdrawal. So the section talks about what are the amounts you can withdraw as well as what are the advances you can make from the particular fund. Okay. Now, okay sir, I have withdrawn. Now, I have taken advance. What is advance? Taking a temporary loan. Should I repay? Yes. But the provision is talking about non-refundable advances. Sir, I have taken money. For what, sir? My life insurance. Like, say for example, I am paying, everywhere you are taking 8.33 as, 12% from my salary. You do one thing, sir. My insurance premium you pay. That can be asked as a advance. Okay. Sir, third point, wait. Sir, for my hospitalization, my major surgery, or if I am suffering from TB, cancer, I can take this as an advance. Or my family hospitalized, major surgery, treatment, I can take advances. or daughter son marriage, brother sister marriage, or education of my son or daughter, I can withdraw. I mean, I can take advance. Electricity supply cut, I can get money to get all those things done. Natural calamity happens, I can do that. I'm a physically handicapped person, I can buy a cycle. Those things I can withdraw. Like a withdraw means it's I can't have a non-refundable advance. So withdrawal is entirely taken, non-refundable advance also entirely taken. Meaning you need not repay. Both sides you need not repay. Withdrawal is total amount, advance is short amount. But both you need not repay. But if you come to third point, there are two parts. Non-refundable if it's a temporary closure of any factory. Refundable if it's a permanent closure, meaning more than 6 months. Meaning you are taking a money. They are saying, say for example, you got 2 months off because of some layoff, raw material shortage. They said you take rest for 2 months. That time I have to survive now. I can take withdrawal of like a temporary withdrawal. That also you can sustain, then you will come back to office. But you are taking more than 6 months payment. 6 months. You are like not even working. You are taking too much amount. Then that has to be repaid. You cannot take more. 2 months period you are running short of funds. You can take a temporary loan. You need not repay. Or you take a big loans. You have to repay. So only one point there is a refundable advance. So people put together, we have a large list. Okay, we have maybe 2 items of withdrawals, 10 items maybe of non-refundable advance, 1 item for refundable advance. Put together, that's our topic. People think that PFL I have credit, what are things I can do? I can withdraw or I can take as an advance like a loan. But some loans has to be repaid. Withdrawal need not be given back. Advances has to be repaid. Only some. Go through the list, see if it's comfortable. कुछ नहीं सारथी. Online people okay? See if it's okay. Okay. Fair idea. Now people, like final withdrawal. You can take a final withdrawal if it's a death, permanent disability, superannuation. What is superannuation? You are attaining a certain age, 58 years. You are going out. Retrenchment, they are asking you out, or you are going for a migration. You can take the entire money, like final withdrawal. Okay, final withdrawal can be done. Now, people pension scheme. Nothing, people. Previous version was family pension scheme of 1971. Law says people who are covered under that law automatically will covered under new scheme, employees pension scheme. Or if you are coming under PF, you will automatically come under pension also. Okay, sir. Key features employer only should contribute 8.33. Correct? Minimum service. You should have a 10-year service to claim a pension. Okay? Or superannuation, like 58 years you will get the thing. But if you are having less than 50 only, still you can get that provided this discounted rate you will get. Okay. So if you are working till 50, you will get the amount only after 58. You can either withdraw the benefit like a subsidized withdrawal, or you can continue till 58 and get the entire amount as pension. Pension is like monthly payment coming to you. Okay. Now types of pension, it can be superannuation pension when you complete 58 years, early pension, early withdrawal, disability pension, widow pension, children pension, orphan pension, or return of contribution. There are different types of pensions available. Easy, small concept. Similarly, Italy people, what is the point? The study method will have 1%. I am telling you it's 0.5% of what? DA, RA, cash value of salary, and basic wages. Should be paid by whom? Employer only. Okay, sir. Now. Okay, okay. Okay, people. Easy points only. If there are problems, you have an EPF appellate tribunal. So people, in the notes or the study method, you have 3 points. PF insurance. Read all those PF insurance points and check what are the available withdrawals or exemptions. Have a selective reading, that's all. EPF tribunal. Okay. Okay. People, in case of insolvency of your employer, okay, so meaning I have to pay many payments, I became insolvent. Law says if you are a regular servant, meaning you are covered under PF Act or not covered under PF, not covered under PF, but you have giving it voluntarily. The both scenarios, your employee should be safeguarded, meaning you are an employer, you got insolvent. Now they are coming to sell all your property, all your income should be dispersed, should be released. They are coming, they can't touch your PF amount payable to the employees, because this is all those amount related to PF will have a protection as far as the employer is concerned. So employer goes insolvent, a recovering officer is coming to recover, that should not be used for paying his percentage, that should be used for employees only. That should be safeguarded. Okay. People, say for example, there are 2 points. The transfer of account, there is heading in the study material. People, symbol. Sir, I was covered under PF Act. Now I am moving to an employment where PF is not there. Or I was not covered under PF Act, I am coming into a new employment is where PF is there. What should we do? Say for example, think like this. I am falling under EPF. I am regularly doing as per statutory requirement. Now I am coming to a place where statutory not available, but employer is providing. Or I am not falling under place, but voluntarily employer has doing that. Now I am coming to a place where mandatory EPF is applicable. Then based on employers and employee, they can shake hands and say that let me continue. So continuation can happen only after the joint effort of employer and employee. So new employer may agree with the employee to continue his continuous PF irrespective of the fact whether his previous employment was subject to PF or voluntarily subject to PF. It's based on purely thing. If not, he'll ask you to withdraw and go out. Or if you want, he can ask you to continue. That's up to the discretion of the new employer and the employee too. Okay. Cool. People read this 1 minute. That's the last part of the chapter. People small chapters, but important points marked so that you can read. So how many chapters done?
10.
10 done.
Yes,
Okay.
10.
So 10 chapters. Now one more chapter, we'll see small chapter. Apprentice, we'll leave. Okay. Apprentice, one chapter. So tomorrow it will be easy for us. People, 1 minute people, let's see if other chapters are covered. Factory sack. People, we are done with 10 now. 9, 10. So we have 8 chapters pending. Constant labor 1 chapter, factory sack, contract, child and adolescent. Okay. Minimum wages. So payment of wages act is pending to be added. Bonus, remuneration, industrial employment standing order, industrial employment standing, industrial relation, like just a dispute, sexual harassment, maternity benefit, gratuity, apprentice, labor laws exemptions, labor code. People and ESA and PF is covered. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Only 1 chapter is missing, no? Sure, Dane. Okay. So PF and ESI I forgot to add in the index, that's all. Gratuity, wages act I forgot. Okay. That's all. Okay. Okay. So now people, let's see what is Apprentice Act. Okay. People, Apprentice Act, last part for the day. People, why Apprentice Act is important? People, why Apprentice Act is important? People, two points. One, apprentices are people who are doing apprenticeship training in a factory or any establishment. Employer can pay less to apprentice. One thing. So Apprentice Act should be governed. Second point, for an apprentice also should get an equal opportunity to get the learning process correct. So Apprentice Act covers both things. One, an employer should not take an employee in the form of apprentice and pay him less and ask him to do work. And if I can let him train, he can be a super cool asset for my company, because I am the person who is giving him training, and I will give him a bond. Don't go to some other employment after like 2 years. So he won't go. So I can use it productively. That's why this Apprentice Act has a lot of emphasis on how rules has to be framed so that he will stick on to the employment with all those qualities that the employer has to offer. Okay? Now, people, Apprentice Act talks about means a person who is undergoing apprenticeship training under a contract of apprentice. Apprenticeship training means a training in an industry or establishment. You are undergoing a training. Now, people remember, there are two different trade which you have to remember. One, designated trade, people. Designated trade means a trade or occupation or anything people, there is a council called Central Apprenticeship Council. They will design something called as some trades. One of the such designed trades are called designated trade, meaning the government knows what is that trade, what is that particular job, designated by the or designed by the your Central Apprenticeship Council. Okay, sir. What else, sir? There is something called as optional trade. What is optional trade, sir? Different industries, an employer can design something called as trade without taking the approval of Central Apprenticeship Council. So without knowing the government purpose, you can design your own subject of trade called as optional trade. Or a person who is having graduation, he will be called as graduate apprentice, or a vocational apprentice. There is something called vocational apprentice. A technician or vocational apprentice.
Technician.
Technician or technician.
Technician, vocational.
Was yours, sir? Yeah. Technical.
Okay. People remember, I am doing a training after my 10th standard. I can be called as a vocational thing, like a stitching kind of thing you will learn along with your higher secondary education. I am a vocational apprentice. Or after degree, I will do something called as degree apprentice. Or that's a two thing. Then comes your normal designated, because government recognized apprentice, or optionally given by your employer. There can be 4 types of apprentice coming. Should I know? No. You should know the concept, because the exam point we have questions which has indirect connection. Okay. Now, people, from here the chapter starts. People online with me, I know it is too much for the day, but it will be easy for tomorrow. Tomorrow we'll be having a relaxed day. Small chapters are big, but number is small. Okay. People, first point, this chapter starts like this. Qualification for being an apprentice. They say a person shall not be required, qualified to be an apprentice, if less than 14 years. So if I am less than 14 years, I can't come near a factory. If I am 14 plus up to 18, I can come to a factory, but not for hazardous thing. So I cannot be an apprentice when I am less than 14 years. I cannot be an apprentice when I am 14 plus but less than 18, but doing a hazardous thing. And you should follow the educational and physical fitness as may prescribed by the law. So no person can become an apprentice if I am less than 14 years or more than 14 years without having in a hazardous thing, without having educational qualification or that physical fitness. Okay, done. Okay, sir. Now, contract of apprenticeship. Law is telling you, no person shall undertake an apprenticeship training unless you have entered in an agreement with your employer, or if you are a minor, your guardian has entered an agreement with the employer. Okay, sir. Whenever you have entered an agreement, from that day, your apprenticeship training has commenced. Okay. It may contain terms and conditions for each parties. Employer will pay this much apprenticeship thing. Apprenticeship should come to the, or you'll have 1 day off. Those things has to be given. Okay. People, until a portal is developed, but now we have a portal, www.apprenticeshipindia.government.in. We have a portal. Till that portal is given, you have to give the information regarding the apprentice to the central apprentice advisor. Now you straight away apply or make an application or put a thing in your portal. Okay. You have informed apprentice advisor that I am going to take him to the apprenticeship training. If he has some objection, apprentice advisor should give an objection within 15 days. Okay. If not, he will register the thing. Your apprenticeship starts now. Okay. So people come again. How? Okay. First point. Sir, what are the rules regarding apprenticeship training? One, employer has to enter an agreement with the apprentice or his legal representative, as the case may be, like guardian as the case may be. He should have all the contracts, all the terms and conditions. You have to give it to apprentice advisor. He should sign and give it back. If not, he will reject it in 15 days. Okay. Now, people, there are different types of apprentice. What is the period of, what is the tenure, what is the term? Who should fix? Say for example, points very important. If you are an apprentice who have passed all those tests or examinations conducted by National Council, let them prescribe. Okay, sir. No, sir. I am an apprentice who have qualified test. Test. Okay. Trade test and examination prescribed by any board or state council. Then I pass that, then board will decide what is my apprenticeship training. Otherwise, law will say, graduate or technician apprentice also, they will say. People remember. So points again, come again, they can ask you what is the minimum period of apprenticeship training. They are telling you, people remember, trade apprentice, trade apprentice, trade apprentice, graduate or technician apprentice. Technician or graduate apprentice, ask me prescribe. Trade apprentice, ask me prescribe. Trade apprentice decided by government test. Central government test, let them decide. State government test or examination, let them decide. What is the period of your or tenure of your apprenticeship training? Okay. Now, Now, people, this heading. What is heading in the study material? Cost ellam, recurring cost ellam. 1 point, that big heading. Recurring cost we study, no. Huh? Practical, people concentrate to the core. This is the most expected question from this chapter. Practical and basic training of apprentice. People, basic training is different, practical training is different. Basic training is nothing, but you have to get a basic thing before you go for the main training, practical training. People. Okay. Now we are talking about, whenever I say practical training, focus on this word. People, employer shall make suitable arrangement for in his workplace for the imparting a course of practical training. So we are talking about practical training. So employer should make a suitable arrangement for the apprentice to go for practical training. Clear? Okay, sir. Now, okay. Now, central apprenticeship or state apprenticeship, they can go to that particular factory, check whether the employee is given, the apprentice is given reasonable facilities to access the knowledge, as well as, let me test him. Come again. You employer should provide a training. How will I know the training is good enough or the working condition is good enough? Central apprenticeship or state apprenticeship can go inspect the particular employment and see if the apprentice is getting proper work and proper training. Okay, sir. Now, people, now, sir, I am a apprentice who have not undertaken training done by National Council or State Council. Then shall before admission should do a course of basic training with the employer. Come again. People, remember, the apprentice is here for working as a practical training. But before practical training, you should give basic training. People, those apprentices recognized by National Council would have given proper basic training by them. Those apprentices recognized by state would have given proper basic training from them. These people should have to go only practical training. But there can be normal trade apprentices who haven't gone for a basic training from the central or state. Those people, before starting the practical training, should have undertaken basic training from employer. Clear, people online? Clear? Okay. Now, people, apprentice, other than graduate technician, apprentice or technical, otherwise the syllabus, equipment of to be utilized for practical is okay. Other than those people, other than you are a trade occasional apprentice, the structure, training structure, what are the equipments, what are the syllabus should be decided by central government. Central government will decide what is the structure for your thing. People, dry but serious 5-mark question. Okay. Now come to last part, people. Recurring cost including stipend incurred with respect to. People, remember, easy important point. It's a recurring cost, meaning repeated cost, including stipend. It can be many costs. It can be stipend, it can be a drinking water facility, anything, including stipend. Given to whom? Apprentice with respect to basic training. So basic training means whom? Other than central and state people. Then this cost should be incurred by employer if you have 250 more. Employer and government will take equal share when you have 250 less. Less than 250. Yeah. People remember. People, basic training. Practical training. 2 trainings you have to go. People, I am a normal trade employee, meaning I am not governed under national or state. I have to mandatory go basic training because other people would have already got a basic training and test conducted by national or state. Now I am going a basic training. Okay, under my employer. My employer is having 250. My employer is having 250 or more. 250 or more employees under me, apprentice under me, then the entire cost meaning it can be stipend or any other cost shall be borne by the employer. Sir, I am having only 150 people, then the entire cost shall be divided equally between central government and employer. Basic cost, basic training. So what about practical training, sir? Practical training, tell me da. Excluding stipend.
Including
People, okay. People, recurring cost excluding cost of stipend. Excluding stipend, other cost shall be borne by employer. Cost of stipend shall be borne by central government and employer in equal shares. Okay. Now people, only for basic training, which employees will come? Normal trade employees will come. Their number of workers 250 plus. Total cost should be given by employer. Less than 250 equally. Here cost means for everyone because it's called practical training. Practical training means all the people, central government, state government recognized as well as normal trade employees should go. If that be the case, your recurring costs, meaning stipend and others, stipend should be borne by employer only irrespective of number of people. Other costs equally divided. Fair idea? People, take your time and understand the provisions regarding training of basic training as well as practical training. Very good question.
State council technical education அந்த trade apprenticeship இந்த ரெண்டு அவங்களுக்கு தான் இது பேசிக் ட்ரைனிங்கும் சரி இதுவும் சரி ப்ராக்டிக்கல் ட்ரைனிங்கும் சரி ரெண்டுமே வந்து ஃபுல்லாக எம்ப்ளாயர் மட்டும்தான் இது அறிவுக்கு மட்டும்தான் இது வந்து பேசிக் ட்ரைனிங் கிடையாது இது வெறும் ப்ராக்டிக்கல் ட்ரைனிங்
Online okay da?
ஸ்டைப்பண்ட் இல்லாமல் ரெண்டும் பேசிக் இன்டர்வியூவும் இந்த நேஷனல் கவுன்சில் போய் பண்ணுறாங்க ட்ரைனிங் எடுக்கிறாங்க இந்த நேஷனல்
Okay. Okay, people. Now people, obligation of employer and obligation of student, apprentice with respect to training. And another question. People, employer should give a proper training in accordance with the act. Okay. If he is not qualified to give a training, he should have proper team to educate the trainee. He is not have a qualified trainer, should hire people to do the apprenticeship training. You should have adequate instructional staffs, and you should have some instructors to help him. Such the obligation under the contract. So they can ask you a question on obligation of employer and apprentice under this act. 1. Employer should do a proper training, give a proper training. If he is not qualified, he should hire people to train, and you should have adequate structure as well as instructional staff. Similarly, he has to carry out obligations properly. Now, as an apprentice, what you should do? Learn trade properly, diligently, carefully. Attend practical and instructional classes daily. Carry out all lawful orders of the employer. Homework and all you write and come down. Why? Carry out all obligation under this law. Okay, easy. Now, weekly other points, other allied points. All of the point chapter is done. Weekly and other daily hours of apprentice shall be decided by your employer. No overtime. So people remember, no apprentice shall be allowed to work overtime except when apprentice advisor feels that it's best for his interest, that if he study extra, he'll get a much clarity, or he's working in an industry like he's training under ambulance. Now, circumstances will come here he has to work more. Then he is entitled for such leaves and holidays as per the probable standing order. Remember, apprentices are trainees and not your workers. Give them proper training. Okay. Should maintain records of the progress of the training, how the training is going. Unless if it's a portal, there's a portal, you have to keep it that in the portal, apprentice details. If there's a dispute between them, you have to give it to apprentice advisor to decide. If you have a dispute now, you have to give to apprentice advice. Now, once the training is done, you have to go for the test conducted by national agency or state agency. Proficiency test you have to go. Now, once the exam is done, you will get a certificate of proficiency. Okay. Now, employer shall have a policy whether he is going to recruit him after the training period is over. If not, you should have obligation. You have to go out only after serving 2 years. So if you are not going, or if your agreement says nothing, leave that as such. If the agreement says I have to give a training, or if the agreement says you have to go for training, if any party, employer is breaching, then there can be suitable damages should be given to both parties, as the case may be. If you are failing to provide employment or coming for employment after the contract. That's all, people, for the day. Okay. Done with 11 chapters. People, 11 chapters, sir?
Yes, that's right.
Okay. Now we have 7 chapters, sir?
Yes.
People, remember, when you go home, revise. Start ulta. All those chapters towards the end, you won't be having that energy to remember. So take a good sleep. Revise again from this part. Go back. Reverse order. Okay, people, thank you. We'll meet tomorrow. So, okay, people, We'll start. So, day 2 of the marathon, where we have to finish 7 laws, starting with Constitution, Factories Act, Contract Labor, then your Industrial Dispute, Gratuity, your Payment of Wages Act, and Labor Code. These are the 7 chapters to be done. Probably we can finish it as early as possible. Some chapters are big, but okay, manageable. So people, we started with why labor laws. Why labor laws? So labor laws comes under an item under concurrent list. Now, your first chapter, if you see the first chapter, very first chapter of your syllabus on labor laws, it starts with constitution and labor laws. Why this chapter? This chapter is a dry chapter where they can ask you a question on a theory basis. How constitution and labor laws are connected. So before you start the chapter, you should be knowing we are trying to decode what is the nexus between the Constitution of India and the labor laws. Okay, so in India there were very old laws from your colonial period. Yes, colonial period, sir. Thereafter, once the independence was sorted, we framed our constitution with respect with which year? Constitution 51 na 56 50 96 56 1950 la 1950 yeah, okay, 1950. And then constitution, the constitution came. Okay, sir, constitution. Thereafter various interpretations came. Okay, various interpretations came. Okay, sir, judgments, different committees, they came up with some other norms for laws regarding the labor. Thereafter, when it's a modern era where we have to consider every new business is coming, we thought let's have something called as standardized norms. Let's redraft the labor laws in such a manner that it will meet the current generation. Let's have labor code. So our concept, our total topic of labor laws revolve on these concepts. So let's go back to history. Let's go back to history, which is constitution. Now, okay. So in my note, I have given like this: a salary check shall not come at the cost of your dignity. Meaning, you are earning something should not be something which you are struggling without not like you are being harassed, you are being mentally traumatized. This thing should not happen. Your salary slip should be purely based on your quality of service you do. It should be a mutual kind of thing. You cannot have one-sided. Because you are getting a salary slip, you should not be like harassed, exploited. Okay. Now let's connect. What is the impact of labor welfare and Constitution of India? Okay. Okay, sir. People remember, chapter is very lengthy. Do a selective analysis of the chapter. Okay. People remember, I have given some introductions, not required. Constitution is that particular law of the land. That law says there should be law making. So they said, okay, let's have 3 wings: one legislature, one executive, and judiciary. Okay, sir. Now, do we really need these 2 wings for this chapter? No. We are talking about legislature, meaning law making authority. Okay, sir. So law making is divided into 3 lists. Union list, where parliament, meaning your central can make law, or come to a state list where state legislatures can make laws, or come to a concurrent list where both state and central can make a law. Now comes, okay, sir. So why are we talking all this? Because we should know which item is falling under which heading. Okay, sir. Sir, some defense animal will come under this thing, sir. Oh, defense will come in union list. Yes, sir. But motor vehicles act is for Tamil Nadu, sir. Oh, union list, state list. Yes, sir. But there are some items which fall under concurrent list where both central and state can make a law. One of such item is labor. Okay. Welcome to labor law. So now Constitution says labor is one item which falls under your concurrent list of the Constitution, meaning both central government and state can make a law. Okay, sir. Now, since this has come, this chapter revolves around three parts. Just to know introduction part, they are telling you that yes, constitution concurrent list talks. So whenever a question is been asked, very important that you have to write one sentence that Constitution of India, your concurrent list gives powers for both central and state to make laws, legislature, law making for labor laws. Okay, sir. One plain sentence is drafted. Okay, sir. Then, sir, now, so that's basic introduction of constitution. So why this is important? Because India after independence is a developing country, will be developing country forever probably, might become a developed country, not sure, but we will become a developed country, but not soon. But the framers, when they thought they will be, India is going to be a developed country soon, almost maybe 80 years, 70 years, 47, 1947 to 2024 is almost 80 kata. Still we are developing. Yes, you see development. Yes, I see development. Where, sir? No, sir. Okay, sir. Happens. But we are developing. Yes, we are on that particular race. We will be superpower. We will be a superpower. Superheroes. Superpower. Now we will. Now let's connect your fundamental rights part, directive principle state policy, and preamble with the chapter. So this now we are trying to connect where constitution gives power under your concurrent list for the central and state to make laws. Thereafter, there are three more elements to be checked. One, what the preamble of the constitution, preamble, the face of the constitution has, is there something to do with your labor laws? That's one line item. Now, there are fundamental rights available to citizens as well as people of India. Whether there's something connection with this fundamental rights given in constitution and labor laws, or part 3 where you have directive principle state policy, those directions or those standards, those principles which will guide the government to make laws for a better country. Whether directive principle state policy has something to do with your labor laws. So 3 parameters you have to check. That's the crux of this chapter. So they can ask you a question generally, or they can ask how do you connect labor laws and fundamental rights? How do you connect labor laws and directive principle state policy? Labor law and preamble is not a challenge, but I tried to decode. Now, introduction for this chapter. Labor laws falls under concurrent list, enabling both central and state government to legislate on labor and industrial matters. Introduction sentence for your any point under this chapter. Now, people, okay. Now, extra information though. Constitution of India. Okay. It says, we the people of India having solemnly resolved to constitute India into a sovereign, secular, democratic republic, socialist, secure all citizens justice, liberty, equality, fraternity. So people, we are here to secure our citizens justice. How, sir? Socially, economically, and politically. Okay. How do you ensure that economically people are getting justice? You have to give them ambit opportunities to work, so that should be a favorable environment for them to work, so that their political, economical, social needs have been met. Then equality of status and opportunity to promote among them all. So how do a particular constitution can enable you equality of status to give you a fair remuneration? It can happen. Probably I am trying to decode. Not sure. This is how you interpret. Now, they are assuring the dignity of the individual. Dignity of individual being one of the core item. That's why your Sexual Harassment Act is in picture. We have to respect the dignity of the individual. So now, over these things, I believe that your preamble also is preamble under the constitution is also trying to help frame or give policies to frame something, to standardize something which will be good for the laborers. This is how I connect. Important, sir? Not important, because you don't have that much impact in your study material. Just to introduce you to the subject. Now comes two questions. These two questions should be checked in your this particular exam with respect to constitution. What are these things? How should I connect fundamental rights and labor laws? How do I connect directive principles of state policy and labor laws? So to give you a different picture, I have given fundamental rights and directive principles of state policy. That to information purpose only. To understand, to get into the subject. I don't want you to study, go for exam, like difference. Sir has given a difference point. No. It's like people, very important point. This is the first part. Justiciable, non-justiciable. Fundamental rights is given in part 3 of the constitution. Directive principles of state policy is part 4. Part 3, fundamental rights is given to people. Okay. Directive principles are directions, so that given these are some overall outline given to government to make laws. Now people, just imagine someone is taking my fundamental rights away. Someone is trying to infringe or attack my fundamental rights. It is justiciable, meaning I can go approach a court. Meaning there you have your Article 32 writ petition, Article 32 writ petition, Article 226 also writ petition under Supreme Court for 32, High Court for 226, wherein whenever your fundamental rights are infringed, you can straight away approach the court. That's one positive sign which you have under fundamental rights, meaning it's justiciable. Okay, sir, super. Now, people, there is something called as directive principle of state policy. Straight away, they are saying non-justiciable. Meaning, people, constitution says a state, a country. State means country. You people have to frame policies such a manner that you help people. Okay, sir. Now, there are some fundamental duties. I mean, there are some directive principles of state policy which is given to the government. Government should frame policies accordingly. Now, question comes, sir. You are saying I have to try a welfare state and all. Where will I get funds from? The government is like, sir, I am already running in deficit budget. How do you get funds? Maybe. So that's why we can't put a pressure on government that this should happen. Government can just try only. They can't put. So whenever, if government is not doing something which will enforce your directive principle state policy, you cannot go approach the court and say, sir, I'm not getting justice. Because government is not having that economic power or that power to enforce that in full swing. They can try. They can keep trying. Okay. That's not justifiable. That's why they're still trying to come up with something which will be productive. Now let's see. There is fundamental rights which where you are getting infringed. You can go approach Supreme Court or High Court, as well as directive principle state policy, wherein state has been authorized to frame laws in such a manner that will help the country develop. Now let's focus on how these, what are the important fundamental rights? What are the important directive? We are not focusing on everything. Let's focus on a few items and what is its connection with labor laws. Okay, so remember the crux is same. Fundamental rights can be justiciable. You can approach a court, whereas directive principle state policies are directions given to state only, to the country only. You can't have that enforceability matter. Okay, now based on this, we have seen some laws. Let's see. Let's connect labor laws and constitution. People, remember, from here the chapter starts. Okay, with me, people online. Okay, let's see. People. First, people, remember one introduction. As I told you, fundamental rights, someone is violating, you can approach through writ petition, Supreme Court and High Court. Similarly, that's one point. Similarly, there is something called as special leave under 136, where, say for example, Supreme Court is having discretionary power, stating that some other court in India, some other lower court in India has tried something which is indirectly or directly affecting the fundamental right of a citizen. Then they have a power. Who? Supreme Court will have a discretionary power. Other than the writ petition, they will have a discretionary power to analyze what happened in that particular decree. Decree, sentence, order, nothing the JGL. Okay. They have a special leave power, like a special power to go see what happened in that scenario. They have a power. So to be frank, you have 3 items wherein fundamental rights have been protected. Either you approach your High Court under 226 writ petition, habeas corpus, mandamus, etc. Then or 32 under Supreme Court for protection of your rights, fundamental rights. Or there is one more item that Supreme Court has having a discretionary power by entertaining a special leave. People okay? Fair idea? Online people? Yes. Now let's see 2 case laws. Not impactful case laws, but we are trying to connect. One. There's one case law called Employees Union versus State of Rajasthan. Okay. Now people, as I told you, fundamental rights are available to you people. Me, you. Okay. Now there was an issue that, sir, you have a problem, you file a writ petition. You have a problem that your fundamental rights are affected, you file a writ petition. Now question comes, sir, can the trade union who's representing a lot of people file a case stating that we have a right to file? The other party said, no, how do you think you have a right? It's an individual right. Correct? Your fundamental rights is affected? No. Your Kutam fundamental rights is affected. Correct? The gang would fundamental rights is affected. Can the trade union file a case? Answer, they said yes. Yes. They said yes. Yes, they can do. One point which you have to remember. Understand. Okay? People read from the study material, very important, the case law. Even you a small intro of that case law. Similarly, one more case law to start. Okay. Someone, next question. Someone who is not directly interested can file a case in any scenarios, like people SP Gupta was President of India. Say for example, people, there's one person who's affected. This concept is regarding locus standing. Correct case law, Danda. That's a case law. Locus standing. Locus standing. Okay. People locus standing. Say for example, there is one issue. I am not able to file a case because my financial thing is not stable. Like already I have a lot of problems. I don't find myself comfortable filing a case. Can some random person in the society file a case? There also they proved that yes, even a random person in the society also can file. That's why you will say MC Mehta versus so and so. Some people are getting affected. Some random person who is not directly connected, still they can file a case. If I see a Bhopal gas tragedy, or I saw a pollution happening, but I am from Kerala, I am not directly connected. Still, as a responsible citizen, if others are not filing a case because of their financial thing, economic parameter, something, I can have a locus standi to file a case. Concepts, so 2 cases given a study method. Since I wanted to touch that thing, I don't think they can ask a question from that, because still I don't want to miss that. Not sure about how they are going to draft a question. Okay. So it's not an assurance kind of thing where you say they won't ask. Because it's Institute of Company Secretaries of India, our institute. Okay. Now people, now let's see the chapter. Okay, sir. So, sir, marathon, you have 20 minutes for only like introduction. Yes, this is a chapter. Now let's connect fundamental rights with your labor laws. Constitution of the labor law part, constitution, fundamental rights, and how labor laws are getting connected. Okay. People, there are few articles to be remembered. First is Article 14. Okay. Okay, sir. People, I want you to remember case laws as well. When a question has been asked, I want some case laws. All those previous cases I don't want. From here after, I need one case law to be remembered for all the uh, five fundamental rights we have. 5 topics. Correct? 5 topics. 5 topics, 5 case laws. I want you to remember. Okay, people. Point number 1. It's equality before law and equal protection of law. Equality before law. Okay. It says the state, what the state, the country shall not deny to any person equality before law or equal protection of law within the territory of India. You are within the territory of India, it won't. People, any person, I'll tell you why this is impactful. Any person, say for example, some places they say to citizens. Okay, now my question is, sir, I am a foreigner. I'm working in India. Okay, some issue happened. They said, hey, no, you are not even a citizen. But equality before law and equal protection of law is for any person. Any person. It can be a foreigner. It can be even a body corporate person in India, in the territory of India. So this can be there. So people, this equality before law is a negative concept. Okay, equality. It's like no one should be treated differently. Equality. Now equal protection of law. Law will treat everyone equally. Positive concept. Both things put together is your this thing. That's why you have different laws. Some places you have seen in a committee, it should be represented by equally 1/3 from employer, 1/3 from employee, and 1/3 from independent. So now equality has been ensured, equal participation has been ensured. One way you have to think. Okay, one way you have to connect. Okay, so I have seen somewhere in some other labor law where they have ensured an equality. This has happened because of one point, equality before law. Okay, sir. The case law, Air India versus Nargesh Mirza, where one air hostess was terminated because of pregnancy. You cannot terminate her job because of being pregnant. That cannot be an equality. So that was one case law which I want to remember for this your answer. So they can ask you a question that how do you connect, or whether fundamental rights has something to do with your labor laws. Then right, we have only 4 labor laws and 5 labor laws. 5 fundamental rights. Not every fundamental rights. So 5 headings you should know. What is the crux? 1 line crux and 1 case law to substantiate your answer. People with me online? Okay. Now 14. Then sir 15, no sir, 16. So 14 is equality before law. 16 is equality of opportunity with respect to public employment. Public employment. When I say public employment, it can be no for a private employer. Okay. Now people, first point, you have to remember these points. Very good question. Case law is this one. This is the case law. Meva Ram Kanojia versus AMs, where there was a discretion with respect to payment, discrimination. That's a different case law, but you remember the case law. Now let's see what is this chapter, this topic. Important. People, there shall be an equality of opportunity to whom, sir? To whom, sir? To whom? All citizens with respect to employment or opportunity to any office under the state. Okay, now comes people, remember, say for example, government is looking for a infrastructure project. Now I have given a contract to minister's son. It's okay, provided you have done a bidding process where everyone was bidded. You selected minister's son because he has submitted a good bid. Whether he has got secret information or not, I don't care. But whether he has done, so you should have given a equality of opportunity. Correct? If not, no. Now let's see. Say for example, I am a government company. I want a company secretary. I'm offering something. Without putting it in. I'm a government company, private company can give private groups. A government company without giving an official notification. What if I'm taking my neighbor? Other people can file a case stating that you have infringed Article 16. Okay, writ petition, Supreme Court, High Court. Now people are able to connect. Now this will become an issue because fundamental rights are justiciable, and you can always approach the court with respect to that. Make sense? People, yes, no connection working for you. Okay. Now, no. Similarly, no citizen shall, no person shall discriminate a person based on religion, race, caste, sex, descent, place of birth, residence, etc. People, hey, you are Hindu, you are Muslim, you are Christian. Okay, you are Dravida, you are Tibetan, you are Anglo-Indian. I don't care. Hey, Sarthi Iyer. Okay, okay, let it be. Only Sarthi Iyer. Okay, sorry. Now, sir, male, female, no discrimination. Okay, sir. Male, female, no discrimination. At the time of recruitment. At the time, people remember, remuneration illa. At the time of recruitment, no employer shall discriminate a person with respect to opposite sex. Correct? Okay. Descent. What is descent? What is descent? Huh? Correct. Your forefather was doing like cleaning in temples only. So you people always should do that work. You should not have a discrimination. Any person can be appointed. Place of birth. Yes, sir. You are from Avadi, Ambattur. You are rejected. Should not happen. Every people from like Ambattur is like this only, sir. Reject them. Should not happen. Now, people, these are two no's. No. These are three yes. Nothing in this article. Nothing in this article. Nothing in this article. Meaning, people, say for example, with respect to a requirement to a resident within the state, people, I want a particular land officer, I mean like a forest officer, to guide everyone going to guide everyone going to like forest officer who will guide people in the particular forest region of Mizoram. Now, whenever I am appointing a person, that person should be from Mizoram because he knows the. Yes, sir. I could feel a leopard walking. Yes, sir. It's raining in Himalayas. There should be someone who is knowing the land. There you can have a discrimination because the specific need says you should have the requirement. Yes, you may have a. Nothing in this article shall prevent. Parliament may make a law. Or, sir, for a purpose of upliftment of backward caste, can I have a difference? Yes. That's why you have a reservation in your thing. Oh, reserved for SC/ST because you wanted to uplift them. Don't say, oh, discrimination is discrimination. You said you can't have discrimination. You only are doing this discrimination. Don't say that. Okay. Now, people, there is one mosque. One mosque. They want one mosque under the thing. They want one person to be appointed as a mosque or a priest in a mosque. Okay. Now, Sarthi Iyer is up here. Sarthi Iyer. Okay, sir. Sir, they rejected mine, sir. Why da? I don't know, sir. I need equality of opportunity. I know everything. I know every pujas and all. Okay. I know. So they're like, hey, it can be different with respect to particular religion. So these three things you can have a difference. People, okay, online. Good. Okay. So now Article 14. Equality 1416. Yeah, equality of opportunity with no discrimination with respect to public employment. On case law, AMS versus Miva Ram Kanojia. Okay. Now, people, 191C talks about right to form associations. Now, people, we have freedom to form associations. Okay, sir. That's why we have club. We have residence associations. Okay, sir. Very good, sir. Now, sir, can we have a association within the labor law? Labor law. Yes, the trade unions within the organization, within the labor force, you are having union. Yes, sir. You can have. Okay. Okay, sir. Now, people, freedom to form association implies that freedom to form or not to form. Not mandated that every organization should have trade unions, or not mandated that I should join. I have freedom not to join also. You should not say that, oh, association is coming, I should be there. Association, let it be. I don't want to join. I belong to an opposite ideology. I don't want to join. That's why in a government company, you will see different party related trade unions. Correct? Yeah? I'm from the opposite party. I can go. Be a neutral person. Go with this also. Sir, I'll pay you 100 rupees, sir, for supporting your party. After election, sir, 5 years safe. Do that. Okay. Yeah. Sir, why, sir? Now, this is All India Bank Employees versus National Industry Tribunal. Okay. Now, people, one more point which I want to add. Very important to connect this chapter, this topic. Freedom to form association. Yes, sir, I have freedom to form association. But I don't tell that's an absolute right. Meaning, if I do that, if I give that power exclusively, then trade union will come with strikes every now and then. Strike. Every now and then they will come with a strike because they have a power. Now law says, yes, you have a power. But let's go with something called as a collective bargaining. Something called as collective bargaining. Okay, sir. So what to do, sir? Instead of going for a fight, under this chapter, today's topic, we have something called as industry dispute. Industry dispute, they say, whenever there's a problem, instead of jumping straight to a strike, let's settle it amicably. Let's have a adjudication within the okay, it's subject to a reasonable restriction. That's why you have Industrial Dispute Act. People, you remember in the case law, in the book you will have Industrial Dispute Act, wherein you have adjudication process. Instead of going for the rapid issue, strike, lockout, close the business. Why you will always suffer. Let's have an adjudication process, like a conciliation process, whether we can see it peacefully. Let's settle the issue. So that's one point which I want you to remember under this topic. Okay. Now, so 14, 16, 19. Correct? 91C. Now, Article 21, right to life. People, no person shall be deprived of his life or personal liberty except in accordance with the procedure established by law. Meaning, you cannot say no to someone's life or property except in the procedure laid down by the law. Meaning, I have done a fraud. I can be arrested, deprived my life and liberty. That happens because that's according to the procedure of law. Otherwise, no one should disturb my life or personal liberty. Now, life and personal liberty can be subject to interpretations. It can be anything. Say, for example, life and personal liberty. Life, sir, I should have a life. Life means something which is meaningful. Meaning, it's not like a 300 rupees where I can live. It should be 3,000 rupees so that I can feed my family also. Life. So, there are different points. Right to livelihood. Right to live with human dignity. I can get a sexual harassment kind of thing. I should give that. Right to medical care. Your ESI, EPF, health of labor, Factories Act, where we are focusing on health of labor, sexual harassment prevention, right to health, economic rights. That's why you are getting bonus, gratuity, etc. Now put together, we are trying to say that labor law will have an effect on not to right only. Much better version, right to life and right to liberty, not in right to make the life meaningful. Meaningful means I should get protection when it comes to a factory. That should be pollution free. That should be cool enough. I should get water enough. I should have a proper urinal. That's all these things should be my rights. Okay. One case law was, this is what I refer to case laws in the class law. This is one case law I want you to remember. Remember case law heading. One case law where one person traveling in the train. He fell down. He went to hospital, go to next hospital, under hospital he went. Thereafter, he went to a private hospital, incurring a huge medical expense. Now, it was the duty of the state to provide proper health facilities. You fail to provide hospitals or facilities, then you should only compensate him. So, you should respect the life of a human being. The life. Okay, people, easy. You're able to understand. Now, people, Article 23 and 24, right against exploitation. Probably the last article. Correct? Yeah? These are 5 articles which you have to focus. Okay. People, 23 talks about trafficking in human beings, beggar, and other forms of forced labor. Okay. So, beggar means compulsory work without any payment. Compulsory work without any payment. Similarly, your Article 24 talks about no child below the age of 14 years shall be employed into work in a factory or mine. People remember yesterday, child labor, child and adolescent, prohibition and regulation of act. No child shall be asked to work who is less than 14 years, except family business or artistic. There is no problem. That's allowed. So now Article 14 also regulate that. Circus. Circus. Yeah, correct. Yeah. Now, prohibits beggar. So 23 prohibits beggar. Beggar is nothing but you are working without payment. Now, to interpret that, I would say for example, you are paying for 100 rupees. Whether it's beggar, yes. Because that's why minimum wages act. 100 rupees is very minimal. The law is saying pay 6,000 minimum. If not, I will consider that as beggar only. You are forced to work for 100 rupees. That's a forced labor or beggar. Because of your unemployment, you have to do. Something is better than nothing. So 100 rupees, fine. 0 means, 100, at least I can get a sambar server. Very fine. So I said, okay. Now government is like, no, you should pay minimum wages. That's why through committee methods, notification methods, government is trying to bring something called as minimum wages. It can be different for different industries. Agriculture, different for within the state also difference. They are able to connect. Okay, people, that's the end of all the fundamental rights, 4 fundamental rights put together. So one case law, Sooraj versus state of Madhya Pradesh. Okay. 5 case laws and 5 topics. Correct? Yeah. Should be knowing how to write. There can be a question with this totally all the fundamental rights put together and keep it in short. All the bullet points put together and all the case laws. Very easy to score. Okay. And people remember, writing is not about filling pages. It's about having a cool handwriting, keeping it in bullet points, and underlining those things. So why underlining, sir? People, simple logic, the underlining is not telling that this is important. Underlining is telling that, sir, I know you are like correcting my paper. You are struggling correcting my paper. Just focus on this thing, sir. I respect your time. Think like that. So that you'll underline on those steps. So that I want him to focus on that thing. He'll focus on that thing. 1, 2, 3, 4, 5. Done. Irrespective of number of points. Okay. So focus on good, solid study material points. That's why I ask you to go with the study material. Try to focus on study material points. Okay. Now people, let's connect directive principal state policy, and labor laws. Now, what is directive principal state policy? Those directions done by state to ensure that the labor force is safe. Okay. People mug up. Mug up all those 6 points. 38, 1, 38, 2, 39, 41, 42, 43, and 43A. Okay. People. Now, first point, 32, 38, 1. State to strive. People remember, other chapters I don't want proper section numbers, but articles I want you to remember. Good for you. Other chapters, concept, if you know, it's okay. Some definitions I want you to almost recollect. Other things is fine. Okay. Now, people. State to promote welfare of people by securing and protecting as an effective social order in its justice, social, economic, and political shall inform all institutions of the national life. Nothing. People, justice, economical thing. People, that's why whenever there's a problem, you have an access to Industrial Dispute Act. You have a problem, you can go to labor courts. I'm ensuring justice. We go to a high court, it will take time, but we have set up tribunals so that easily you can settle the dispute. And economic goals. That's why minimum wages, those things have been drafted. One way. Now, people, Article 38.2 directs the state to strive to minimize inequalities in income. Okay, sir. How do I ensure that inequalities in income? Okay, that's why Equal Remuneration Act. Inequalities in income should not be entertained. Okay, sir. Thereafter, 38 and 38, 2 points. Okay. Also, sir, eliminate inequalities in status, facility, opportunities. At the time of recruitment, you cannot have inequality. Promotion, you should have inequality. Yes. Able to connect some other SZS topic. Yes, sir. Now, people, 39. Equal pay for equal work. Like some points. Previous point also equal pay for equal work. Now it's like state should direct its policy that ownership and like all citizens, irrespective of sex, equally have the right to adequate mutual livelihood. That's why Equal Remuneration Act again. The ownership and control of the material resources of the community are so distributed as to best observe the common good. Say, for example, material resources of the community, meaning employer has become rich, but that has become because of employee's contribution. Okay, sir, let's have something called as bonus. Share the prosperity. Bonus Act. So material resources should be distributed. How do I distribute? All those resources available shall be distributed among people so that those people will also be happy. Okay, sir. Try not to have a concentration of wealth in the some people. Let's have a monopoly, like a competition act, restriction of monopoly, ECAPL, where you say whenever there's a monopoly happening, let's restrict that monopoly. Correct? Yeah? Formation of cartels are regulated. Cartels, what is cartel? Da? Group of suppliers, other handling. Okay. Equal work for both men and women. People remember, it should be based on skill, complete the skill, responsibility, efforts. Good. Equal Remuneration Act. Good. People. Now, people, health, strength of workers and men, women, and tender of age are not abused. We have prohibited child labor. We have like a health strength. That's why we under factories we have different provisions for health of women. That's why I told you yesterday. Cotton openers, women can't go. We respect their health. Childhood and youth are protected against exploitation. No hazardous employment for adolescent. No work at all for child. Okay, clear. Now, people, 41. Okay. economic capacity and development to make effective provision to securing right of work, education, and public assistance in case of unemployment, old age, sickness, disablement. Unemployment, old age, sickness, disablement. People under ESI, PF and all, you are getting an employment injury. Yesterday we saw what is the purpose of ESI corporation. ESI corporation, health welfare norms plus rehabilitation. Correct? Rehabilitation or re-employment of people because of disablement, health issues. Now that has become because of social security provisions 41. Connection working? Yes, sir. Now 42. 42 requires the state to make provisions for securing just and human conditions. Okay. Work related, you should have a good facility, not like a pollution kind of facility, proper facility, and maternity relief. Now 43, living wages. As a minimum wages act has been enacted, payment of wages act, which we are yet to see on time, where they say you have to pay, make the payment within time. Suitable legislation securing participation of workers in management of industrial establishment. Whenever there's an establishment, there is a committee formed. Every committee will have equal participation of both men and women. So we have solid 7 directive principles state policy to be noted. Those 7 points, just mug up. So I want you to mug up all those 5 fundamental rights, 5 case laws, 7 directive principles state policy, and 1 case law if possible. Okay, so that your answer will look cool. Should look cool. You should know something. People okay? Kind of okay? You are able to manage this chapter, big chapter. Then okay. Okay. People, now let's see 2 topics. One is a Factories Act and one is contract labor. Okay. People, Factories Act, one of the biggest chapter. Factories Act. People, social welfare legislation. Remember, one of our directive principles state policy was ensuring health and welfare of the workers. So let's see how the constitution is regulating. No, your directive principles state policy has enacted. Because of directive principles state policy, there's something called as a Factories Act 1948 enacted to ensure that health and welfare. If this was not an item under directive principles state policy, how do you expect a employer to ensure health and welfare in a factory? They'll be exploited. They'll say, hey, you work there, everyone sit together and work. Restroom, you want restroom, you people, everyone stand in queue. 100 people stand, only one toilet. Now it's 20 for 1 person. Okay, so minimum that should be ensured. And this is how you ensure health and welfare is done. People, connection is there. Why we are going to see this chapter? Okay. People, here adult, adolescent, child. I don't want you to focus on that thing because you will end up confusing with the your child labor prohibition. Okay. So for the time being, just read. Focus on child definition or adolescent definition as per child labor prohibition. Okay. Now people, let's see the chapter. I want you to focus on different some definitions as well. First, people, competent person. So before knowing competent person, he should know something called as chief inspector. Under this law, there are 3 people coming, 3 parties. One is chief inspector, then occupier, then certifying surgeon. 3 people. 3 people. So our chapter will revolve around these 3 people and their powers or duties, obligations. 1. Then how the Factories Act is ensuring health, safety and welfare of our workers. That's all. You have to focus on only 2 aspects. What are these 3 people's role in Factories Act and how the law is regulating health, safety, and welfare being a item under directive principle of state policy. Clear? Okay. Sir, okay, sir. Sir, here we have explained the definition of child and adolescent. Sir, why do you think child and adolescent? Yesterday we saw that adolescent can also work. Where factory also he can work, but not in hazardous thing. Hazardous thing. Okay, sir. So I am 15 years, sir. I can work in factory, sir. Yes, sir. Hey, sir. Factory my health. Yes, da. Not in hazardous process. Okay, sir. How do you think that 15 years old? Hey, you don't look 15. You have a dadi and all. Okay, so that I can work. No. Let's do a analysis of Zuman where he looks aged only, but as of his age, Aadhaar card it's only 17 years. But he want to take care of the responsibility of his family. He want to take the rice packets like a Bahubali, or people are forcing him to take. So let's have that scenario. Let's have people to analyze whether he can be employed. Okay, sir. It's his factory, no. It's his family business. That's a different scenario. But now under this law, we have chief inspector. Okay, sir. The chief inspectors have to ensure that these people are working. No, these people should have the proper health. Okay, sir. How to ensure? Let's appoint, sir. I can't run for every factories. Let me appoint someone called competent person. Okay, sir. So under Factories Act, you people who the chief inspector, the ultimate authority, chief inspector may appoint competent persons, meaning who's competent to do what, sir? What they're having competence? It can be an individual or an association or an institution. Recognized by whom? Chief inspector. For what, sir? Carrying out test, examination, and inspection regarding to the factory. So in order to go to a factory, whether the factory premise is good enough, quality is good. One thing, whether to do the test proper, whether this, if I put this current will come or not, or whether if I go with the health welfare, whether the factory workers or health is good. To know, I can't travel all the way to all the factories in the state of Tamil Nadu. Let me appoint some individuals to run, as well as some institutions where they can undertake the scanning process. Let's have someone called competent person. Okay, sir. Now, the qualification experience of that person or facilities is at his disposal, meaning chief inspector can tell what is the quality of that person and what are the facilities that hospital should have. Similarly, if that's an institution, what is the qualification experience of the persons employed therein? To check now, the screening process happening in ABC Diagnosis Center. Okay, sir. Let me say, oh, factory workers are being scanned there. Let me say there should be at least 3 doctors. Oh, who are you? I am chief inspector. Oh, how can you say? Because it is at my disposal. Clear? Huh? Concept is clear, huh? People who online. This is fine. Yes, good. Now, people, sir, law says, try to recollect the yesterday we saw child cannot be working. Sir, then why we have different child this thing? Remember the order of the law. Factories Act first, then child labor prohibition. Now child labor prohibition happened. Now they are saying child cannot work, but who can work? Adolescent can work. Okay, sir, adolescent can work, sir. Where, sir? Other than hazardous, mine or explosive, inflammable thing. So hazardous things, you should know what is hazardous thing. Okay, sir. Sir, hazardous means any process or activity as per any industry given in first schedule. There can be different industries. One of the industry can be like, say, for example, people who are doing in coal or people who are doing asbestos sheet, something where you use a lot of chemicals. Now they are saying you can, as per your other law, which one? Child labor prohibition. Child labor, child and adolescent prohibition regulation. There they say you can't work in hazardous. So what is hazardous? They're saying any industry given as per first schedule, where unless you don't take a special care. Okay, what, sir? It can be raw material, it can be intermediate, it can be final product, byproduct, anything. If you don't take a product, if you don't take a special care, it can result in two things. One, materially, seriously impair the health of persons working therein, or it can pollute the environment. That's called hazardous process. Hazardous process. So what is hazardous process, sir? Hazardous process means any process as per schedule 1 related industries. Any industry which is given in first schedule. Oh, then it is relating to, sir, if I don't take a special care with respect to either manufacturing, like transporting, or if I'm doing raw material, finished product, anything, if I don't take a special care, it might spoil my health, asthma, or it can pollute the general environment. Gas tragedy, Bhopal gas tragedy, where people died. Okay, hazardous process. And now, okay, okay. People, they can ask you one question: what is factory? Only your definition. People, factory means premises including presence thereof, meaning the entire place, entire place, factory, premises, and presence thereof. From my fence, whatever be the area where, sir, there is a manufacturing process happening. Oh, manufacturing process happening. Yeah, yes, sir. How, sir? With the power of, with the aid of power. Oh, with the electricity you are working. Okay, sir. So without electricity also I am working. Okay. Now, in order to call that as a factory, if I am working with the power, with the electricity, there should be minimum 10 or more. Okay. But what if I am not working without, I am working without electricity, 20 or more? People, okay, sir. I have usually my workstation is like 10 people. I am working without power, 10 only. So not applicable. Only one day I hired 10 more people. Applicable, sir? Yes, sir. Because it says any day. Any day. Any day during the last 12 months, whether your company has 10 or 20, you come under the definition of factory. Okay. Now, law is asking you, sir, what is manufacturing process? Manufacturing process means many items: making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, okay, or pumping oil. I have given example that go through these examples for easy understanding. Okay, it can be generating power, it can be water, waste pumping, there can be composing of books, there can be constructing of ship, there can preserving of items in a cold storage. Anything can be called as manufacturing process. So in anywhere, if I am doing a manufacturing process, okay. Now people, my question is, I'm preserving a item in cold storage. Cold storage. I'm preserving item in cold storage. Uh, there are only 9 people. There are only 9 people. There are, yeah, 9 people. Oh no, let's assume there are 15 people. I'm working without power. Whether this is applicable? Without power applicable? How do you preserve that in cold storage without fridge? Power vename. That should be there. So think like that. Power. Power can be anything. Can be, if you see the power definition, it can be anything. It can be like a generator kind of power, any power. Any kind of power you are working, then yes, automatically falls. Stupid question. Thing to do with your fridge, storing chicken you store, you are working in a what Instamart, no connection. Just to understand the topic. Okay. Okay. Now people come to this topic. Let's see the participants. With respect to this chapter, I'm focusing only 3 parts. inspectors, certifying surgeons, and occupier. 3 people. Welfare officer, safety officer, one line item. One line item. Under welfare safety norms. Other part of the chapter. Yeah, lines. Given in not knowing. Read. Okay. People, let's see. Power of inspectors. People, power of inspector. What are the, so I said told you powers of inspector. First point, first question. Who is an inspector? Any person appointed under Factories Act. What he can do? Sir, first he can enter and inspect. Where, sir? Factory. Okay. He can examine. Yeah. You can examine the registers and record. People, this is short points. I don't want you to read this point. I want you to read the points from the study material. All the points put together. Choose any solid 6 points. Very important. For every topic. Study material points. Now, I have a power to enter and inspect. I have a power to examine, register and records. I have a power to examine the health of workers. That's why you appointed competent persons. Examine the machinery, whether the machine is going properly. This side going up, that side going up. If there is a violation, I can issue notices. If there is a hazardous thing, health, safety, material impairment happening, let me control that. Okay, these are the things which is given for the power of inspectors. Just go through those things given in the study material. In the study material, just have a glance. What are the powers? In regular class, we have discussed powers. Just go through that. People who are reading, for knowing it for the very first time, just see if the points are okay. Points are okay? Okay. People, now people, so before inspector, you have to understand 2 points. Every state shall appoint, state government to appoint inspectors. You can have more than 2 inspectors if the biggest area is very large. That's allowed. Now come to a certified surgeon. Certified surgeon is nothing but a medical practitioner certified by the government. Okay. To carry on medical examination, issue certificates. Okay. So now, people, what is his role? Tell me in your study material. First, certifying employment of young persons. Certifying and examination. Certifying and examination of young persons. Second point was to supervise. Medical supervision of 2 points. One, any manufacturing process which is likely to cause a problem, or there is a change in the manufacturing process. Previously, I was doing this power, I'm doing changes to this software. Because of that, there is an issue happening. Those 2 things I have to certify or do under medical supervision. You need a medical expertise. So, law empowered your inspectors to appoint someone called as certifying surgeon. Good. Certifying surgeon cannot be a related person of the occupier. People, 2 points on the certifying surgeon. Introduction, you have to put 2 sentences. Thereafter, roll from the study material. Just know the impactful points. These are the points, but good to present from study material. People, okay, the conceptual clarity you are getting. Points you can revise later, but concept is clear. People, welfare officer, safety officer will come under welfare safety measures. Let's park it there. Now, people, occupier. So before you know occupier, what is occupier? One sentence for occupier. Definition da. Occupier is a person who has ultimate control over the affairs of a factory. Okay. Occupier is a person having an ultimate control. So I want you to go to the definition and see what is occupier before your question has been asked. Now, what is occupier's duty? Simple da. Now people, occupier. Points. 1. See the duties of occupier and the study material da. Before he is taking the job as an occupier, he has to inform the inspector that I am going to take charge. 15 days before that particular taking a role. Then 30 days before the actual manufacturing process being carried out, again inform the authorities. Whenever you are appointing a new manager, within 7 days you inform them. One idea. 30 days. 180, we don't know, 30 days point. At least 30 days this thing before the manufacturing process being carried on. Now people, 7 days before the manager being appointed. Now occupier's duty. Ensure that the general duties only, ensure that the hazardous process are not carried on. Ensure that factory is doing well. Ensure that health welfare is done properly. Those things generally you have to make, but make sure you have solid 3 questions, 3 answers to write. Obligations of occupier under Factories Act, obligations of inspectors under Factories Act, obligations of certified surgeon under Factories Act. 3 points. With this, we have done with first part of this chapter. You should know the introduction. So to be on a safer side, you should know who is a competent person. What is a factory? What is hazardous process? Manufacturing process or idea. Then come to this topic where you have people remember why child adolescent is described, because to ensure that in a factory child and adolescent time slot is managed, but we don't have that in the syllabus. So fine. That's why adolescent will have a different time slot. Yesterday 7 p.m. 8 a.m. has been regulated via Child Labor Prohibition and Adolescent Regulation Act. So go with that law. Here we don't have that in our syllabus, so it's very fine. Now, under this chapter, we have 3 parameters. Okay. Chapter 3 on health. Correct? Chapter 3 on health. Correct? 3 chapter. Health is chapter 1. So this is second part of the chapter. The second part of the chapter. Part 4 for safety. Part 5 for welfare. 3 points. That's why people, I have asked you. Here one more point, safety officer. Here one more point, welfare officer. Put together is your chapter. Okay. Know why you are studying the chapter. Under a factory, it is the obligation of the law to frame that, because we saw that directive and state policy, one of the obligation of the state to ensure that health safety of the labor force is safe. So let's have a healthy measures. Let's plan some safety methods. Let's have some welfare activities. Okay. Now let's see what are the points. People, I will make you study. There are points. Health, how many points? Health, we have 10 points. Welfare, 8 points. Okay. Safety, you have 24. 24. Now, people, I will help you to mug up these 10 points. I'll help you to mug up these 8 points. These 24 points, I will help you to remember 10 points. Okay. Now, 10 points under health. People, you should be with me. Health. CDVD holders. Okay. Okay. People, health. Remember, you write in your study material. CD, VD, holders. CDVD holders. CDVD holders. Sir, why sir? CDVD holders. Now people go to all those topics, the CDVD holders and the health. C is cleanliness. D for disposal, V for ventilation, D for dust, S for humidity, O for overcrowding, L for lighting, D for drinking water, U for urinals, S for spittoons. Okay, people focus. Let me go with the topics. Before that, I should know what is the health measures. CD-VD holders. CD-VD holders. People online. CD-VD holders. Now people. Sir, this is regarding health. Okay, sir. Let me clean. Okay, sir. I'm cleaning. Done with the cleaning. Okay, sir. Then let me dispose the waste. Okay, sir. Dispose it. Okay, sir. Let me open the doors. Ventilation. Okay. Sir, if you open the ventilation, again what will happen, sir? Dust will come. CD, VD. Again dust, sir. Ayo, sir. Now, sir, humidity தாங்க முடியல, sir. Let's have an artificial humidification. Okay. Sir, factory, sir. Like it's cooped up, like overcrowded. Okay, you should put adequate light, sir. Light. People, there are over people. There should be light. You should provide them drinking water. Okay, sir. Drink. Sir, drink, sir. Sir, I want to go. Restroom, yes, sir. Urinals. Sir, our system, sir, urinals. Imagine transport urinals. You go, you drink 1 liter water. You go for half liter urinal. You come back for spitting for half liter. That will happen. Spittoons. Okay. People who have the habit of having bida. Let's have bida. Smoking is something. Oh, okay. Oh, okay. Suban Kesari da. Suban Kesari. Suban Kesari put an advertisement. Suban Kesari da. Suban Kesari da. That's ghee Kesari. Ghee Kesari da. That's Kesari. Rava Kesari da. And the Kesari. Suban good person. Kesari kitchen matunda. It's Suban Kesari. Okay. Suban Kesari. Suban Kesari. Now people, CD-VD holders. Tell me da. CD-VD holders. Online people think da. C for cleanliness. D for disposal. V for ventilation. D for dust. H for humidification, overcrowding, lighting, drinking water, urinal, spittoons. People online good. Okay. Now people, let's see how cleanliness is ensured. People remember, they can ask you a question on cleanliness. Okay, sir. How? People cleaning. These are the points I want you to remember. 4 points. Let's see. Sir, 4 important points. Sir, you have to sweep. Okay, sir. Ask that Akka. Let her come and sweep. Okay, sir. Eppa, sir. Daily, sir. Daily you should sweep. Yes, sir. You should come, sweep, accumulation data, everything should be removed daily by sweeping. Daily sweep. Okay, sir. Super. Okay, sir. Now, people, that's all, sir. You are sweeping daily, da. Sweeping daily. Okay, sir. But where is Abbas? Sir, Abbas, sir. Yes, sir. Once in every week, your floors should be cleaned by disinfectant. Sir, which cap, sir? Red or blue? As a case may be. Red, okay, red. You do. Red, da. See, red. But everything is in blue only. Okay, okay, sir. Done, okay. Now, people, done. Now, sir. Now what about, sir, other places, sir? Like walls, etc. Sir, if it's painted, okay, with the washable paint. Whether it's painted only, sir, but I can wash. Then once in every 5 years, you have to repaint. If it's painted and okay, sorry, people. Otherwise, I have missed. Otherwise than the washable. So it's a paint, but I can't wash. Then try to repaint within every 5 years. Sir, what if it's a paint, washable paint? Okay, da. Once in every 6 months, you wash. But add an extra coat every 3 years. Oh. Sir, other cases, sir. Other cases, let's keep it like this. Other cases, 14 months. Like whitewashing kind of thing. Everything is other things, it's like 14 months. Oh, okay, sir. Now cleanness is done. Now, sir, similar thing happens to your wooden or metallic framework of windows and doors also. If it's paintable, once in every 5 years do repainting. If not, clean, as the case may be. This is how you ensure that your particular factory premises is clean. Okay, sir. Then, sir, I have cleaned. Now points are easy. The cleaning means you have to dispose the waste and effluents. Okay, sir. You should have an effective arrangement for treatment of waste and effluents. People, I'm going fast. It's okay. You pause. Watch. Okay, sir. Now I cleaned. Then you should have an adequate ventilation for circulation, fresh air. Correct? You have cleaned everything. Open your windows that fresh air will circulate. Oh, super, sir. Now, sir, to reduce that excessive high temperature, sir, if there are hot parts in a machine, that should be properly insulated. Meaning, you should have a proper covering for, say, for there's a machine running. Other one part is like this. That will emit heat. Make sure you have a proper layering so that the heat will not be emitted. That's why I see people like similar like your frying pan, your handle with the care. Those handle will have plastic coating to ensure that insulating the hot parts, because plastic is a bad conductor of electricity. Physics people, good conductor means you will get shock kind of thing. Bad conductor means it's okay. People, physics da kuda yaar physics. Okay. People, now humidity means presence of moisture in the air. Ensure that when you want to add a humidification, it should be as per the standards. The topic is regarding artificial humidification. If you see the topic is regarding artificial humidification. Ensure that okay, sorry people. People, dust and fumes also. People, there's one more point. Dust and fumes. Dust and fumes. Like you should have a exhaust fan so that pollution will go out. Exhaust fan. That point should be added. Yes, sir. Done. Now humidity you can do as per your standard thing. Okay, sir. Then overcrowding, sir. Overcrowding, people, remember 14.2 cubic meters, 4.2 in meter. There are 2 points, people. I want you to listen very careful. Overcrowding. People, there's a factory. They can ask people to work, everyone put together. Overcrowding. The law says you cannot have an overcrowding. Say, for example, you have a calculation there. You remember the calculation given? Example. People, say, for example, your space is like example, class example, you remember that number? It's okay. People, say, for example, there is a there is something called you compute a particular your place is having this much length, this much height, this much breadth. Okay, you have to do a floor area computation, meaning 10 into 8 into 6. How much? 10 into 8 into 6. 480. 480 is your total area. Total area is 480. Divided by 14.2. Okay, 14.2. What will be the number? Say for it's like 16. If it comes to like 16, or it comes like 23. If that be the case, in your floor, in your particular place, only 23 people can be there. You can't have overcrowding. Not everyone should be like kept it together. That's why law says overcrowding. So total floor head into, you do a computation. You get the thing divided by 14.2. You will get whatever be the number, that much people should be there in that particular land, particular space. Clear people, conceptual clarity. Now people, it can be people, it can be length, height and breadth. Length, height and breadth. Length 10, height 8, breadth 6. But it can never be, this can be 10, this can be 10, this can be 6, but this can never be h. This can be only 4.2. You cannot add this file calculation. So by the whatever be the length, whatever be the height, whenever you are calculating your length of 40 into breadth of 40 into height of 20, no, height of 4.2 is a maximum thing. Clear? You cannot have more than 4.2 in height while you compute. Good. Okay, people. Now people, lighting, overcrowding though, overcrowding you have to put light. Okay sir, lighting should be like, I should not get a glare. Should be natural light, maximum possible natural light, natural artificial light, but it should not have a glare. It should not form a shadows. Glares are not allowed. Okay sir. Now people, drinking water. അത് 24 ഇത് അത് KGF ലാസ്റ്റ് പോയിന്റ് ഇതില് പോർട്ടബിൾ electric lights topic under your welfare. Now people, drinking water. Drinking water, two things. One, you should have a column. So drinking water, this side column should be there. Okay. Thereafter, whenever there are 250 or odd people employed, then during the hot weather you should have chilled water. Similarly, ensure that there is a 6-meter gap between your drinking water and urinals. You should have a safe distance. Drinking water, then you will go to urinal. I agree, but there should be 6-meter gap. It should be like very close. It should be clean. Hygiene should be ensured. 3 points under drinking water. Then comes latrines and urinals. Yes sir, super sir, it should be clean. One more point was like it should be properly clean. Ask Mr. Abbas to come here also to clean. Harpic advertisement, that should happen here also. People, the advertisements are good, no? Good advertisement to ensure that you feel that happiness, no? When you see the actor coming cleaning and you see a star, I mean they do a micro like a lens, you see only one small bacteria running. Happy, good. So that will never happen in a factory. Okay, should have that clean. Like it should be like they say your lateral urinals should have if you see that glazed tiles. Okay, you see the study it says glazed tiles, correct? Glazed tiles meaning you go to a washroom in a factory, you should see your face on the floor. Glazed, like you people go there, you do this thing, put a powder, come after. That much the quality. Think about a factory having glazed tile. Well, glazed tile will happen only if you are working in a mall. In a mall, you can see that thing. Glazed tiles. Now, spittoons, for people who loves having Subhan Kesari, you can have spittoons. People, okay, feel free to comment. Okay. Now people, let's move to welfare. Third part. Part of chapter 5. People, symbol points, go to every points, here we talk about uh, welfare. Welfare, it's part for part 5. People, part 5. So this also we'll try to mug up. People, welfare. Go with just have the points: the washing facility, drying and storing, sitting, first aid, canteen, shelter rooms, crutches. And then welfare officer. Welfare point officer is to be added. The last point should be welfare officer. Let's see. People, imagine a like a mom of a small child. Small child. See, like it's like a 10:30 a.m. in the morning. Okay, she's not working under maternity benefit. They're not working. How people they should work only. This not this worker. They should work. This is equally shared between Sarathi and his wife. Equal work. Da. You have to help her. Okay. Now people. Now let's imagine she's washing. Okay, sir. Washing is done. Then sir, dry. அப்புறம் மடக்கிஃபிகேஷன் in the shelf. Done. Washing facility, drying and storing. Okay, sir. Let me sit. Next point is regarding sitting. There should be sitting facilities available in the factory. Okay, I'm sitting. Oh, tired. So what happened? Something happened. I don't know why. Because of some washing machine problem. A small cut. Okay, let's do first aid. Now we will first aid. We have points like in a company where you have 150 people, you should have a first aid box. If you're having 500, you should have an ambulance facility itself. Okay. Now after first aid, she thought I'll go canteen. Okay, canteen. I went there having eating and all. Canteen should be done. Canteen facility more than. So if you are having 250 people, you should have a canteen facility. Okay, sir, canteen. After canteen, I realize, are you there? My daughter is crying. Child, I'll go back to see the crutches. Okay. Okay. After eating, you again rested. After eating, again you rested. Shelter rooms. Now, the shelter room is nothing in a factory where you have a place to. After eating, go to shelter room. Now your kid is crying, you go to a crutches. Meaning they say in every factory where there are 30 women employees, then you should have a crutch facility for more than 30, 31. 31. So you should have a crutches facility. Now people, but now I realize that I have to go back to work. Yo, sir, I have to do crutches, sir. My baby is crying, but I have to go back to work. Okay, hey, welfare officer, come here. Help me this. Okay, sir, welfare officer. Okay, now stories, people. We'll start with cleaning, washing, drying and storing, sitting, first aid, canteen, shelter, crutches, welfare officer. People clear? Good. Okay, good points. Now people, safety. Safety, people, very complicated 24 points. I want you to remember random 10 points if possible. They can ask you how the Factories Act is regulating safety of a workman. Let's see how this is going to be remembered. Okay. People will focus only on easy points. 10 points, easy points. Okay, people. Point number 1. People just fencing of machinery. People, machines can work. I told you one example where there's a mill. One lady was putting rice for grinding. Okay, she kept like this, leaning forward. Her hair, have a nice haircut, hair fell into that particular machine, grinder. Happened like horrible incident. Happened. So it's very important that such kind of machines should have proper fencing. Fencing of machinery. People okay? Now people, Act prohibits employment of young person on dangerous machines. You can't let a young person or without supervision go near a dangerous machine. Okay, sir. Casing of a new machinery. People, every screw, every nut, they might fall down through the machine. Will go down. Have a proper casing, proper covering of machinery. Okay, I'm taking easy points. Hoist and lift. But people remember from the study material. I want you to remember from the study material. Huh? Every? Okay. Which one? Hoist and lift. Okay. People, hoist and. Easy. Okay. Easy. These people are very new to the topic. Okay. People hoist and lift. Not the lifter. He this lifter. In your movies, you see lifter, KGF lifter. You are going down. That lifter, Kurvi. Maybe some other audience who don't understand Kurvi. Okay. Saradi. People like a big Vijay fans don't know Kurvi. Possible. Sir, I watch every movies. Motivational, sir. Because of Kurvi, I entered into football. Okay. People hoist and lifter. Lift means that lift working place. Hoist means like a crane kind of thing. That should be properly guarded and ensure that 6 months once you give a cross check whether the quality is good. Okay, sir. Lifting machine, ropes, chains, everything should be properly working. You have to check whether it's properly maintained. Once in every 12 months, you just a cross check. Those things should happen. Now, pressure plant. Some machines will have automatic pressure plant. Pressure. Ensure that the pressure is maintained as per the law. You cannot have more than that over pressuring and all. Now, people, floor, stairs, means of access. Like go into the floor. You have to go to the upstairs through a floor. Don't add cement packets in the floor. Don't block the way, causing a risky factor. He might slip down. One side you will put. There's a stair, no? You won't be putting this kind of thing. That side walls are. That fencing won't happen in stairs because the factory is under construction or factory is like a very small place. So what do? You block the way into this side. So this person has to walk this side only. What if he fell down? What if he falls down? That's a problem. Now, excessive weight. Don't put excessive weight on that person. Don't put that. Protection wise, I'm working in a this thing, the cutter machines, welding and all. You have cooling glass, Ray-Ban, provide Ray-Ban, Roy-Ban, provide Roy-Ban. Okay, sir. Dangerous fumes and gases. There can be some industry where fumes can come. Dangerous fumes and all. You should have proper ways to be safe. Now, okay. People, 2 more points. Cotton openers. Cotton openers. In a cotton openers, what is cotton opener? Like a cotton, there can be dust coming. Cotton industries. So, the woman and child is not allowed to go near cotton openers, but it can be through. It cannot be through. Say, at sometimes they can have that facility, cotton openers, because dust will come out. But feeding phase, what phase is that? Feed phase, feed phase, feed end. Okay, feed end. Okay, they can work in feed end, meaning, say for example, I put clothes. I put that your silk. After that only I'll get the final product, which is dust. So there is 2 ends. One end is called feeding end, where you put all those clothes. Now that's a product, no health issues you can put there. So a woman or child can work in feed end, not the dead end, like where the outcome is coming. You cannot work in that output area where the dust will come out, but you may work in feeder point, where you put clothes, which is not polluted. People okay? Okay. Some other points? Okay, portable electric lights. People, there can be places where you have a smoke, inflammable thing. Don't put a lighting which is more than 24 volts. So that excessive power, if it bursts, along with that, the atmosphere is already polluted because of hazardous chemicals. It will burst. Those things. Then fire protection. Fire, you have to have that. Then what else? Maintenance of okay. Maintenance of buildings. At times you have to go check whether buildings are good, quality is good. Appoint safety officers. People random. You should have 10 points to have a grip. That's all, people. That's all regarding this chapter. You have to read, but not a marathon kind of topic. Okay, people. Online, all good. Kind of okay. Okay. Let's take a break. We'll come back. We'll see. First, we'll start with contract labor. Then we'll start with industrial dispute, gratuity, wages, and all. You can do under control, people. Thank you. Okay, people. Let's focus on contract labors, small chapter. Then we'll start with industrial dispute. Very big, very solid chapter. Then payment of wages and gratuity. Then we'll cover the last chapter. Okay, people. Contract labor, very small chapter. Contract labor. People, why this law? People say, for example, I wanted workforce, but if I appoint normally, then I have to pay every compensation, every wages, the bonus, etc. But if I appoint to a contractor, those are not my workers. I need not pay the entire amount. I can just keep it simple, small. So in India, people started appointing contract laborers through a contractor without giving much thing, because obligations to have healthy, safety, everything was for my workers, for the contract workers. Now they said, okay, Bodunda, it's fine. Let's abolish contract labor, or we'll try to abolish to a greater extent, or if it's very important, we'll try to regulate. So max to max, we'll try to abolish only, sir. Or if it's very necessary that contract labor is necessary, we'll try to regulate, control them. So the act is regarding max to max abolishment of contract labor, and if possible, if there are scenarios where I'll try to regulate. Okay, people online. Now it applies to two people. One, establishment in which 20 or more workmen are employed, or to a contractor who employs 20 or more workmen. People, in the preceding financial, if you are a company, you are an employer, you have 20 people coming through a contractor, or it applies to a contractor who has 20 people in his godown. So 20 people working under me, or 20 people are employed through a contractor under me. For this is for employer, this is for contractor. So those two things we have contract labor law, contract act, contract labor. Okay, so regulation of this thing. Okay. Now people, contractor in relation to this establishment means who undertakes to produce a given result for the establishment other than the mere supply of goods or raw materials or something. Meaning, contractor as per this law is not a person where I supply goods through my people. I supply proper workforce to get the given result for the establishment. It's not limited to supplying goods through my people. It's proper way through which I will regulate. How I'll go appoint persons to ensure that the given result of the establishment has been achieved. Okay. The term includes subcontractors as well. Okay, sir. Principal employee, workman. Okay. Now, people, the topic talks about having an advisory board, Okay. The central government shall constitute a board to be called as Central Advisory Board. Central Advisory Board shall have chairperson, chief labor commissioner, such other members not exceeding 17 but not less than 11. Okay, from different industries. Okay, so these people are going to advise the government regarding how to regulate the contract labor. So in a national level or a central level, we have Central Advisory Board consisting of chairperson, chief labor commissioner, ex officio, and such members 17, not less than 11. Similarly, state, it's like chairperson is appointed by the state government, labor commissioner, not the chief labor commissioner. Similarly, it should be 11, but not less than 9. Not less than 9. People should be there to represent. Okay. Now, people, there are points. They can ask you this topic only. First step. What are the provisions regarding registration and licensing of contract labor, contract workers? Now, it comes like two parts. One, I am an employer. I am doing work through a contractor. I should get a registration. Oh, is it, sir? Yes. So similarly, the contractor, when he have workers, he should get a license. This chapter is regarding whenever I am an employer, I have 20 or more people working as contract laborers, or I am a contractor, I have 20 people under me. I should get a license. As an employer, I should get a registration. This chapter is regarding that. People online, crux of the chapter. Now people. Okay. Now people, appropriate government, state government or central government, they can have a registering officer. Okay, sir. It makes it mandatory for every principal employer to make an application to the registering office. Sir, I want to get the registration done. It's a duty of the principal employer. And if the conditions are not satisfied, the other person, the registering officer may revoke your license. Effect of non-registration. If you have not done that, then you shall not employ contract labor. Okay? Okay, sir. Now people, very important point. Probable question is this. What is the crux of this chapter? Regulating or trying to abolish. So let me say this particular industry, I have a doubt. Government feels that, okay, there are people working as contract laborers. Truly, do I need these people here? Truly the particular industry require contract labor, or it can be done by regular employees only? Let me regulate, let me abolish. This comes as a question to mostly to the government. So appropriate government, before taking a decision whether I am going to close this or put norms for regulating, either I am abolishing or this thing should be based on 4 parameters. This can be the question. 1. People, okay, you are doing a particular manufacturing process. You are doing some work through contractors. Okay, sir, whether that particular operation is incidental. Let's say incidental main. Let's see. Okay, incidental only. Okay. Whether it's of a perennial nature, like a repetition unda, frequency unda, that there's a frequency of that operation, or whether this can be done ordinarily through a regular workman. Okay, you are having contract labor. Your company is into something. You have appointed contract labor just to do some important aspects. Oh, why can't it be done by your normal employees only? Or whether you have sufficient number of all-time normal workmen. These parameters are the parameters which they have to keep in mind before they decide whether I am going to prohibit a regulator. So keep this in mind. Whenever a particular registration, someone is asking for a registration that he want to work for this thing, give the registration as per. Suddenly this particular person who the authorities feel that that industry, he's saying we want registration. Really, we have to allow them to work through contract labors or not? Let me decide. Or let me remove that provision wherein no, you have to employ only normal workers, not a contractor, because we are trying to, at the end of the day, we are trying to abolish. Now let's see. To do that, you should say whether that work done by contract labors is incidental or not. Okay, sir. Whether it's of a perennial nature or not. Okay. Or it is ordinarily can be done by a normal people, or the company is having sufficient number of normal workers. If that be the case, they'll keep parameters like this before they decide whether we are going to stop that particular industry with a contract labor or let me regulate. Okay, people, yes. Online. Now, people, we have seen appropriate government appointing someone called registering officer. Similarly, they have to appoint licensing officer for whom? For contractors license. So, appropriate government may appoint licensing officer. Okay, sir. No contractor. Okay. No people. No contractor to whom this act applies. Meaning, I have 20 people in my bucket. Shall undertake to execute any work through contract labor except under the license. That's why this chapter. So this chapter is very easy. The first applicability, then how the act is going to regulate, how the act is going to prohibit. So prohibition or regulation, they have to see whether the establishment has a registration or the contract is having a license. Both things. So they can check the parameters before they cancel the license or this thing. License is done. Now this is done that we have to see whether we are abolishing contract labor. Sir, no sir. Let me say I'm going to regulate only. Meaning like FEMA, Foreign Exchange Management Act, people remember? FEMA came through FERA. What is FEMA? What is FERA? FERA is saying no. FEMA is like managing. It's a liberal concept. So, similarly, let's have a prohibition or we can have a regulation. So, if I want to regulate, how to give the facilities to these people? So, remember, these are the ways in which law says if you are allowing contract labor to this business, these are the minimum facilities an employer should offer. Okay, what sir? Canteen for the use of contract workers. Now people, where there are more than 100, then there should be exclusive canteens. Tani canteen, tani mess. Okay, tani achi mess for your proper contract work. Oh no, okay, achi mess you give. Okay, amma, now you give it. Now people, restrooms should be provided. Okay, canteens, restroom. Now, drinking water, 3. Latrines, urinals, 4. Washing facilities, 5. So they can ask you a question, 6. Okay. People, next question. First question, how the law is governing or regulating this thing, or what are the facilities an employer should provide for a contract worker? What are the facilities? The canteen, restrooms, drinking water, urinals, washing facilities, and first aid. Okay, super. Now, responsibility of payment. The payment is basically the responsibility makes a contractor statutory responsible. So usually statutory, this should be done by contractor, but usually it won't happen. It is done through the employer, principal employer. He will pay the salary for the contract worker. Thereafter, he will debit the same from the amount payable to the contractor. Similar to Factories Act, we have inspecting staff. What to do? Same power. Enter at the time, go with inspect, examine thing, require any person, sees in documents, etc. These are the points for the same point. Remember, Factories Act inspector's duty, same applies to contract labor inspecting staff for the work. Same work. Similarly, you have to maintain a register. That's all. Very small chapter, very small concept. Okay, maintain a separate register. Now what has to be covered? Okay, people, okay, facilities and restrictions. That's all. Now, people, we have solid 4 chapters. 4 chapters. So if we start this is the main chapter which I want to focus. People, main focus factory side. Second main focus industrial dispute. Let's start with industrial dispute. Very complex chapter. One chapter. Thereafter, we'll try to see one more chapter, like maybe a wages act. We'll take one more break probably. We'll finish gratuity and we'll do that code wages, modern wages. That's all. Under control. People, industrial dispute act. Okay. Industrial dispute act, people, very important. People, every chapters put together. Why this law is important? Because of course there will be fights. Fights can be between employer, employee. Okay. Okay, good people. Employer, workman. Okay, to know the language of the act. Employer, workman. This is why the law is very important. So whenever there is an industrial dispute, we should settle it amicably. The law is giving you a different version of the provisions, that there is a dispute happening. Suddenly, employees might go to strike. Okay, so strike. Podunda, we are finishing the business. Or employer say, oh, well, let me lock. You people suffer. There can be lockouts coming from employer or strikes from employees. These two are not proper. These are not ensuring there is a collective bargaining. Because we have seen under constitution, ensuring that collective bargaining is happening. Now, trade union, they said, okay, we'll fight. No, before fight, let me have the situations settle amicably. Let's settle this through industrial dispute act. So whenever there's a problem, let's solve it through industrial dispute. The industrial dispute, how do I solve? Either I go with a proper adjudication, fight it, or it can be a mediation conciliation. Now, law is making it simple that whenever there's a fight, let's have first thing amicable thing, like a peaceful settlement, like a conciliation. You will have a peace of mind. Let's focus on brain work, mind work, before the lawyer comes and fights. Correct? Before the black people comes, they'll come fighting. Before that, let me be a company secretary, be a negotiation, do something, be a peaceful environment. That's the purpose of this chapter. Okay? Now, people, this chapter will have 3 segments. 1, what is industry? That will take next solid part. What is industry? Second part is regarding what is the tool available in the hands of employee, called as strike, employer, lockout, layoff, etc. Third part, whenever there's a fight, what should I do? 3 parts. Okay. Now, people, this chapter very, very, very crucial with respect to first case law. Study Matilda, people, there's a case law. There's a T estate, Dimkuchi T estate versus Dimkuchi T illada marudi. T estate. People, employees of a T estate versus the T estate. There's a case law. Let's see what is this case law. After this case law, central government, Supreme Court says that the purpose of this law, the objective of this law, can be this. The question can be on objectives of this act. It's a tool for promotion of measures for securing and preserving amity and good relation between employer and workman. Employer, workman, there should be securing and preserving amity and good relations. Okay, sir. Now, second point, sir. Whenever there is a problem, just investigate and settle the dispute between employer and employers, employers and workmen, workmen and workmen. Okay, sir. Then try to prevent illegal strike and lockouts. Whenever someone is being laid off, laid means because of some reasons they are sending out, proper relief should be given. Or last point, ensuring there is a collective bargaining. For all these 5 steps, let's design something called as Industrial Dispute Act. People go through the points, da. The 5 points are clear. Okay, da. Five points, people. Come your study Mithil, mark first page. Raja. Okay. Online, all good? Okay. Now, people. Sir, this act is regarding 2 parts. One is dispute. Oh, dispute is between blah 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 blah. Sir, then industry. Industrial dispute. Sir, then what is industry? There came a question. So, most probable second question. What is industry? Which is a very complicated definition. Okay. People, they said industry means business, trade, undertaking, manufacture, calling of employers, calling service, employment, handicraft, industry. It is everything. Now it became a problem where I should have everything covered under industrial dispute or not. Say for example, I am doing a charity, whether I should be covered. I am doing a hospital, service industry, whether I should cover that. Law says, let me redefine the particular industry using triple test. Very important case law, da. Case law, da. Important case law. I remember which not I mentioned. Okay, people, it's called Bangalore water supply case. It's called Bangalore water supply case. The Bangalore water supply and sewage case. Sewage board. Rajyappa. Okay. So this is a case where they said you should have a triple test. Okay. So what are the triple tests, sir? Whether there is a systematic activity. So in order to cross check whether there is an industry, you should have whether there is a systematic activity. Oh, systematic, proper activity. Whether there is a cooperation between employer and employee. Or third point, there is a distribution of goods or service to satisfy human wants or needs. Okay. Remember. Okay. This includes spiritual or celestial well-being also, meaning making Tirupati laddus, candles, okay, can also be covered. So 3 points, they asked about 3 tests, like triple test kind of thing. There is a systematic activity. So this is a theory question. What do you mean by industry? So industry is everything, but after this case law, Bangalore water supply case law, triple test has to be undertaken to know that whether it's a systematic activity, whether it's a cooperation between employer and employee, whether the production or distribution of goods and services to satisfy human wants or wishes is there. 3 points. Okay, sir. Now, people, whether the industry is profit oriented or not is irrelevant. Okay. It can be public sector, private sector, joint sector, everything. It can be irrelevant. Okay. It does not cease to be one because of the philanthropy animating the undertaking. People, 3 points. Sir, the question was, sir, I run a charity business. Okay, what do? I cook food, serve the people. Oh, whether it's an industry, no, it's not an industry. Now they said, no, it should be industry. Why, sir? You are doing canteen. You are doing charity only. For that charity, you are cooking. No, sir, I am hiring people to cook. Okay, your ultimate motto is philanthropic animating, philanthropy, like charity kind of thing. But profit illa, there's no profit. Still, I don't care because there are people working under you to help make the cook. Food is being prepared by these people. You are paying them, no. Even though your motive is no, but you are paying them for cooking. This act is covered. Ilana, who is there to protect them? Who is there to tell them this is a rights? One. Second point. Sir, I'm working in public sector, private sector, government sector. I don't care. Meaning, the government is doing a government hospitals. Also, there's a problem. Industrial dispute will attract. Clear? These are the points to be remembered. Okay. People online. Now, people then another question came. So another question was, sir, what if I am doing? I am a particular business. I have two sets. One is charity kind of thing. One is profitable kind of thing. Whether Industrial Dispute Act applies to me. Now they ask one more question. What is your dominant nature? So second interpretation comes to dominant nature. Oh, so where an undertaking having multiple departments, some of may which qualifies industries, some may not. Then nature of the dominant department should be your parameter. I have different departments doing different activities. See? And majority is this activity, which is like a industry, then industrial dispute attracts. Sir, then say for example, sir, sovereign functions strictly interpreted, like government will have two activities, one welfare, one sovereign. So government hospital, it is welfare. Government is running an army, it's sovereign. So sovereign thing, industrial dispute is not attracted, but welfare activity, hospitals done by government, it can still attract. Okay, sir, I do sovereign as well as other thing. Okay, whether you can severe, yes, I can separate. Then separable part is under industrial dispute. Sovereign part need not be under industrial dispute. Sir, or specifically law can by legislation exempt categories. 4 points to know whether you have a continuous service. Why is, I mean, continuous service? Dominant nature. Why dominant nature is important? Because there can be companies which are doing different activities. So based on dominant nature, we will see whether this is applicable or not. People okay? Okay. Quick recap. Now people, remember, one more point is added to the definition of industry, which is yet to be notified. Yet to be notified. So as per this amendment, so industry, continuous service, I mean, dominant nature, third point, but an amendment. They say there again there's a systematic activity. Okay, sir. Employer, workman. Okay, sir. Supply or distribution of goods for satisfying wants. Okay, same point, sir. One more point has been added, saying that the profit motive or capital investment is not necessary. Whether or not you have a profit motive, whether or you have invested capital into that industry, I don't care. That need not be that factory. Say for example, I got a factory. I never put an investment. Still that can be an industry. Or I'm starting an industry. Workforce is there, but I don't have a profit motive, philanthropy motive. Still, I'll be covered as industry. Specifically, they are included dock workers and sales promotion people. 2 points là, because of an amendment they can ask you industry as per the amendment, but it is yet to be notified. It includes dock workers as well as sales promotion, but does not include, very important. Sir, hospital and dispensary, sir. Sir, you only told, sir, hospital industry is covered. Yes, I am covered because this is yet to be notified. Okay. Now, law says agriculture operation, hospital, dispensaries, scientific education thing, charitable philanthropic thing, khadi industries, sovereign functions, domestic services, professional practice like a CA with less than 10. These people are not covered under the definition of new definition of industry, yet to be notified. Okay, people. Two part people. We started with industry dispute. What is the purpose of this act as per the case law? Then second part is regarding what is an industry. Put together we have different parameters and the amendment part. What is amendment has to do with the particular thing. Amendment is yet to be notified. Online, 3 parts of the first topic called as industry. Okay. Good. Okay. Now people, now comes industry dispute, sir. What is industry dispute? It is dispute or difference between employers and employers, employers and workmen, or workman and workman. People, why it's important? Just to know that it's not employees the word used, it's workman. Workman. Okay. Now done. Now people say, okay, sir, there is a fight. What will happen, sir, if there is a fight? What will people do? Second step, second part of the chapter. Okay, sir, what is second step, sir? There is a dispute in a industry. Suddenly people will go to a, difference of opinion. I don't care. Let me go for a strike. There's a strike in the tool of, as a tool of workmen. Okay. So, it's a cessation of work by people. So employees are taking a cessation of work. I call it as strike. So immediately on a industrial dispute, people will go to a strike. Okay. Now, Act talks about different types of strikes. So one line on strike. Strike is a tool in the hands of employees. So what are the types of strikes? People, it can be stay in, sit down, pen down. Like I said, hey, Aru, why you are not paying me? Odu. Pen down. I'm not going to work. Pen down. Poda. They'll say poda. Get out. They're like, no sir. I'll work. Okay, I'll work. But I'll work slow. Go slow. Sarathi. Marathon is very important. Okay. The marathon for 5 days. Go slow. Go slow is not a strike. It's a serious misconduct. Okay. Now people. ArivuPro asked me to take a marathon. I'm like, okay, sir. But suddenly I said, no. Like, why? I'm not paying you. Yes, sir. Then, sir, you know, ABC Academy, that particular person started to take a lecture, marathon. Suddenly the employer says, get out, stupid fellow. Okay, so, sir, sympathy, sir. What? Sir, he is also like me only. Okay. Who am I? You are my employer. Their employer? Someone else. So, no, sir, I have sympathy towards them. A stupid fellow, sympathetic strike. Or, people, I won't eat. I'll do fasting. Intermittent fasting. At the workplace or at the place of employer, I call it as hunger strike. People, 4 types of strike. Remember, go slow is serious misconduct. Strike and strike types of strike. Kuda. Oh, okay. Work to rule. Okay, work to rule is nothing but people remember. I said whatever is been assigned to me, I'll do. I can't take an extra work. So that's why it is not a strike. Not a strike. Because you give me one like what my agreement is like, you make one churidar, I'll pay 1,000 rupees in one day. You're saying, hey, today you have to make 2 churidars. And then I'll pay you. Now what I am doing? No, I'm doing only one churidar. But I'm working now. If I say no churidar, then that's, or if I'm not doing one churidar fully, it's kind of going slow. Not a strike when I'm doing one. That's not a strike. Work to rule. Okay, people. Now people, okay. Oh, you people can strike. Okay. See. Law code. Now law code becomes a tool in the hands of employer. He can stop, suspend the work. Law code. Okay, okay, sir. Done. Rule. They can ask you comparative analysis between strike and lockout. Tools in the hands of employer and employer respectively. Now people, lay off and lockout. Difference. People, before that, what is layoff? Layoff means failure or refusal of or inability of the employer to give employment. Sir, previous thing also was from the employer only, sir. There it was suspension because of a action. Here it's because of my inability. Why, sir? Enough called a shortage of raw material or already existing stock in machinery breakdown. Okay, natural calamity or any other thing. Okay, any other reason, it can be called as layoff. Okay, layoff. Okay, sir. Now people, retrenchment, meaning you are asking a person to go out other than a disciplinary action. It can be voluntary retirement done or attaining age of superannuation, nothing but 58 years, non-renewal of contract of employment or continued ill health. Why this point is important? At the time of this also, we might get a compensation. That's why these points are important. Now, people, there's something called a settlement. Remember, people, what was this chapter all about? Industry dispute. Dispute means what? You will go to a normal court, like a labor court. You will fight it over. Before that, it's good to have an amicable settlement. We call it as settlement. Like when you do a conciliation thing and like an agreement whereby you will come into terms. Okay, sir. It's okay, sir. How will you go? How will you do? You tell them psychologically move that people, only one incident, because of this one single incident, you are going to fight against your employer. He is the only person who gave you work. Psychologically, you will approach so that they won't end into a proper fight. If you go with a proper fight, it's going to be the end of the economic benefits, or it will spoil the entire working condition. So instead of that, let's have a amicable settlement called as conciliation. Okay. Now people. Now people, we have two parts of the chapter. Two more parts. One, authorities under the act and their duties. Similar thing regarding your public utility service. 2 points, 2 complex points. Now people, let's start with the authorities under the law. People, very important to know the concepts. Okay. People, let's see what happens when it comes to a dispute. Very important, very important. I want you to have a careful understanding of this summary. People, there is a dispute. Okay, sir. Dispute happened. Now let's decode what are the authorities under this chapter. Oh, sir, whenever there is a dispute, obviously it should be solved. Then how to solve, sir? Better to have a works committee within your organization. Okay, sir. They should have combination of employer, employee and all, so that before the issue gets started, like agarbatti is burning, you try to settle amicably through a works committee within the organization. Step number 1 on first authority. Sir, if it's not working, next step is better to have a amicable settlement. Peace. Let's have either a conciliator, okay, or let's have a few people of conciliators. We call them Board of Conciliation. Board of Conciliation. What are their role? To try to amicably settle the issue. Okay, sir. Now, people, if I want more information, I can do an inquiry courts, where the purpose is not for amicable settlement, not for fighting also, just to collect information. Inquiry. Now we are seeing that after inquiry, we came to know that this problem will not be settled through conciliation. No peace. You can go with the proper adjudication, meaning like a proper court kind of thing. Okay, sir. Supreme Court, High Court, sir, nothing. In here, we have 3 courts based on 3 schedules. No. Okay, let me see. First thing is labor tribunal, labor courts tribunal. Second point is industrial tribunal. Third point is national. People, when there is a issue relating to schedule 1, schedule 2, it's a labor court, labor tribunal. It's something related to 2 or 3. Correct? 2 or 3. You can approach industrial tribunal. Some issues which is having a national flair, very big issue, you can approach national. So the particular system of industrial dispute is, I have to say which industry, what constitutes an industrial dispute. Third point, if an industrial dispute happen, what should be the procedure? We first, within the organization works committee, or we hire people from outside to have an amicable settlement like a conciliation, do an inquiry and help them to file a proper complaint as per adjudication. That too within the organization, within the law. You don't need to go to some other law. Here we are giving under the law powers given to labor courts, industrial courts, as well as national courts like tribunals. What is tribunal? Exclusively for this particular fact. People, okay? Introduction is good. No. Simple point. First point, conciliation and works committee. Nothing. If the company is having 100 or more workmen, you should have a works committee. Promote amity and good relation between employer and workers. Like employer and employee should be equal, so that there is a committee. People remember one of the important directive principles state policy, ensuring that 43, where workers and workers participation in management. Now you have a works committee where you have workers and employers sitting together to solve the issue. Okay, sir. Okay, sir. Sir, what if it's not working? Let's have conciliation officer. Oh, one person, sir, or more than one people called as board of conciliation. Simple. They'll have a neutral mediation. Correct? Correct? They'll try to settle this issue amicably. It's a board of conciliation. It should be chairman and 2 or 4 members. Like a mediation where they will sit and decide on the subject matter. Let's settle it amicably. Solve it amicably. Okay, sir. Now, people, I want more information about the issue. I can appoint a court kind of thing, a court of inquiry to inquire into matters related to industrial dispute. Okay. Okay, sir. It's a fact-finding body, not a dispute settling authority. Correct? They are there to know the facts of the issue, not the dispute settling body. Okay? Now, people, sir, if this is not working, what I can do? You can have labor tribunal, industrial tribunal, as well as national tribunals. Okay, sir. Something under your first thing, meaning schedule 2 related activities, offenses. Then you can have one person to decide the subject matter, one presiding officer, who shall be high court judge or district court judge or judicial office. Those people, they can have sit and settle the dispute regarding items covered under schedule 2, usually retrenchment, illegality of strike, lockout, etc. These are the issues which will come under that his control. No, sir, items are coming under your two things like your schedule number 2 and 3. Items under schedule number 2 and 3. Then we can appoint someone called as industrial tribunals. They will also have the powers to settle the dispute. For them, same powers, same people like your Chief Justice, Supreme Court, High Court, those points will be common replicator. Now, whenever the issue is regarding something which is of national importance, okay, or between, so there's a national impactful, or two states are involved, correct? Two states are involved. Then let's have the reference given to national tribunal. Let them decide the case. Okay, fine. People okay? The parties under the regulation. General counsel. You will hire those people for the particular problem. Nice. These people are there in the market. You hire them, hire the team. Therefore, because they are judges only, no. They are here to solve different issues, different employers, different employee dispute. Customer is the only thing which is happening within the organization. Employer participate. Other thing is everything go judge only, no. You can't appoint a judge in your company. Hey, judge, come here. How are you? Wait, judge comedy. Judge na leda. Wait. People. Okay. Again, two more points. One is regarding regulation of strike and lockout. Another thing is called voluntary arbitration. I want you to understand. People, one solid point. One solid point. People remember to know the basics of that part. In the study material, you have to read the 5 points. I'll give you the crux of this topic. People, if there is a dispute, you know, you have two ways out. One, let's settle it amicably through a conciliation. Correct? An out of court settlement. People concentrate out of court settlement where you have either a conciliator or a board of conciliation. Correct? Now, if it's not working, you can go to a court kind of thing. Tribunals are there. 3 tribunals. Correct? Now, if I go to a tribunal, it will take time. If I go to a conciliation, it is easy. But conciliation, the verdict, settlement order need not be a final thing. Meaning, I need not comply. It's just a like a emotional way of approaching things. Now, law says, if this is also not working, this is also not working, what can I do? Let's have something called as out of court settlement, which is like a conciliation called as arbitration. Oh, okay. Then, but the order is final. Okay. So let's have something called as arbitration. That comes the concept of arbitration. So, if I feel that conciliation won't work or tribunal will take time, there's a provision under 10A of the law which says you may voluntarily go with the arbitration. So how do you go? You go with following 5 steps. Correct? 1, it should be in writing. You should appoint an even number. Then one person will be appointed by them, like an odd number. You need not comply with arbitration law. Arbitration law, exactly, you need not comply, but you have to do the following proceedings. That's how you do with arbitration. People, I'm giving a clarity on why arbitration point is given. Know what are the provisions. There are 5 points. I want you to take time and read from the study material. 5 points. Institute material. Okay. Heading is voluntary referring to arbitration. Reference of dispute to arbitration. Just go through the points. The online people, very first time people, just, did you understand the basics? Why provision, and what are the steps? Yes, people. Okay, points are good. People online, good people. Now, people, last part of this chapter. Okay, sir. This chapter talks about something called as public utility. People, go back to your definition. See what is public utility. Public utility. Go back to the definition part. See what is public utility. What is public utility? There can be some industries given. What are the industries? Which one? Railway, rail or airway, correct? Then port, okay, dock, port or dock kind of thing. Then postal, postal. Then something which work as a safety of the establishment, like a some department in a atomic plant, safety department within the organization. Then power, okay, power, light kind of thing. Then comes your sewage, sanitation. People, let's assume these are the departments or these are the industries which are going to strike. So, or like employee is going, a workman is going for a strike, or employer is going for lockout. It cannot be immediate, because if I do that, allow that, it's going to hit the entire country. Because what if these people are going, which one? Railway, sudden strike. What will happen? Life will get spoiled. Think people like Sarthi, who starts from 4 o'clock. Okay. Google map will be like walking 5 days. Those things should not happen. So let's have a planned way of executing a strike for this industry. So how law is regulating these industries? People say, there are 4 points. This way also 4 points. One is regarding strike, another is regarding lockout. Day of a lockout. Study material. People, they say, sir, whenever you are doing a strike, you have to inform, but you are a public utility. You have to inform them at least 6 weeks before the proposed date of strike. Okay, sir, employer is giving a strike, lockout. 6 weeks before that, you should inform the same. Oh, then again, there is something called as 14 days. 14 days. Tell me what is 14 days. People, I am giving a 6 days, 6 weeks before. Sir, I am going to go for strike da, or day, I am going for lockout. Okay. After 6 weeks, let's sit and solve the issue. 6 weeks, they are not responding. They are not reacting positively. Then inform. Hey, I gave you 6 weeks. I'll give extra 14 days. Thereafter, nothing. Last chance, I'm going for the fight. So before you start a fight in a public utility, you are an employer or employee? Employer team. strike from employee or a lockout from employer, you have to give a 6 weeks notice before the proposed date of strike. Thereafter, again 14 days you have to give. So your strike should literally happen after 8 weeks of date. 8 weeks. Then other 2 points. What are the other 2 points, Ra? Okay. People, again, what a fourth point? Okay. So during the pendency of an issue, you can't do. If the conciliation is done happening, because you are trying to solve it amicably, that time don't do a thing. Fourth point, it should be asked for the date. I think that's regarding the date point. Should be okay. They say you are going for a strike for 3 days. Strike should be for 3 days. You say 6 weeks. You are saying 6 weeks before that we are going for strike on Monday and Tuesday. Then it should be Monday and Tuesday only. That should be there. Similarly, if the conciliation process is happening straight away, you can go for a strike. Okay. People online. What notice you say the which day you are going to do strike? Because clear on 5 days strike, that should be 5 days strike. Third point. Fourth one, you're once you give a notice, they say okay, let's settle amicably. Conciliation pose. In between the conciliation, don't force a strike. Keep it simple. Like you are settling now. Amicable settling. Now let's see. Why do you want to you have decided let's go with the amicable settlement. He's deciding. Let's see. Why do you want to go strike in between as well as 7 days after that? Illa. Conciliation after 7 days give time whether they are following. So they are doing let's say they say okay, agreed people. What if next 7 days they are doing either 7 days to comply with this proceedings? After 7 days they are not comply with the conciliation, then again you have freedom to go with strike. Yes. Pudu notice. Other based on when conciliation is happening. If 6 weeks you are given application of that time conciliation happening. Now and the notice, already this notice will be covered with that notice. If not, normal conciliation, then you go with the people okay online. Okay. Now people, one more point. You cannot do a normal scenario. You cannot do a strike in the following scenarios. Epo 1. People during the conciliation and 7 days after the conciliation. Correct? No points. Basic points regarding strike. General points of strike. What are the general points of strike? People, there is a heading general prohibitions regarding strike. Yes or no? Okay. What other points? Okay. People, general prohibition. People, I cannot do a strike when, sir, during the conciliation. Hey, you only said, well, let's go with amicable settlement. During the conciliation or 7 days after the conciliation, don't go for a strike. You have worked for a conciliation. It's working good. Ask them, give them 7 more breathing space before you start a fight. No, conciliation is not working. Then, if the problem is there undergoing in a labor court, tribunal or national tribunal, you can't go. And 2 months also you can't go. You went to a problem, court gave you a verdict. You cannot go for a strike in next 2 months of that verdict or during the issue or during an arbitration as well as 2 months from the date of arbitration, or while a settlement is in force. So people, technically they are telling you, sir, I can't go for a strike, normal strike. When, sir, there was a problem and we ended up with a conciliation. Okay. Conciliation is going. And 7 days after the conciliation, you can't go for a strike. No, sir, I went to a court only. Okay. When the time going in the court, as well as 2 months from the court order, you can't go for a strike. No, sir, I went to arbitration only, sir, or 10A arbitration. Going time arbitration plus 2 months, 2 months of the arbitration up also you can go for strike. Sir, no, sir. There is a order in place. During the order also you cannot go for a strike. Proper order is in place. You are happy, you don't have a debate. Proper order is given by the court. That time you can never go for court. Never go for a strike. People put together, these are the following parameters which to be checked under Industrial Dispute Act. Fair idea, people. Overall coverage. Now, people, 3 more chapters. Wages, gratuity, and code on wages. We need probably half an hour after the break. That's all. But now we'll start Wages Act. We'll take a break. We'll do that 2 chapter, gratuity and code on wages. Little window. Proper Tamil சொல்லுமா? ஏன் இனிய மக்களே, உங்க எம்ப்ளாயர் கொண்டாட போறேன். People, layoff is my inability to give. Meaning, I don't have resources. Power is not there. Natural calamity, raw material kano. Because of that, I'm going for a locking. This is layoff, laying off. Lockout is like, I have work. You will also can work. But because of your overconfidence, you announce a strike, no. Revenge da. Let me lock. You don't work. You don't work. Because of issues. I am saying no. It's called lockout. No issues. But it's like I'm incapable of giving a work. I call it as layoff. For lockout, there's no remedy. But layoff, you will get compensation because it's been laid off by employer. Now, lockout, if it's justifiable, then you will get back the amount. If not, nothing. Because you people are doing so much problems, I'm locking out. No compensation. If I'm locking out, tomorrow it's justified, and also you're not there. Like because of your fight. Tomorrow I am doing a lockout, then you have to pay compensation. They have always compensation. Strike based on legality. If it's legal, yes. If not, no. That's why we are trying to avoid the strike. Go to a conciliation. Wages கிடைக்கும். You'll be getting wages if the strike is justified. That's why you have a heading on justifiability of strike in the topic. You don't need that, just that bare understanding that if the strike is justifiable, you will get payment for that strike period. Okay, people, all good. Yesterday's topic, the last topic, because I failed to copy. Very small chapter, the Payment of Wages Act. We have decided the minimum wages. Let's see whether the employer is paying on time or not. There can be scenarios where wages has been fixed. But how are we ensuring that wages are being paid or not? So let's see what is Wages Act, Payment of Wages Act. Okay. People, the law talks about having a clear picture for the mode of making a payment, specified time of making payment, and responsibility of paying wages. So this chapter is having 3 points. Wages. Who should pay? When to pay? And what are the deductions allowed from the wages? So it is a law to protect that your salary is 1 lakh rupees, but he is deducting so and so expenses. Why? You agreed for 10,000 rupees, you are getting only 3,000. Why? So allowable expenses. So you are getting payment on time. You are getting a payment on time, and you are getting that on a proper mode, like a electronic mode, currency coin, the current Gandhiji coins, as well as what are the entitled, what are the eligible deductions which the employer can do from your salary. People okay? Online? Crux of the chapter? Okay. People, let's see this chapter. Okay. Small chapter, a very small chapter. Are they? Okay. Okay. First point, the responsibility of wages is with the employer. Okay. Now, people. So, first point was regarding employer to make a payment. Second point is regarding time. Should be paid. Sir, what time? What time, sir? They said if your number of employees are less than 1,000, should be paid within 7th of the next month. The number is more than 1,000 within 10th of the next month. Sir, because of some dismissal, discharge, resignation, it should be paid within 2 working days in case of dismissal. 2 working days, people. You have to make a payment. First point, timely payment. So law is helping you with the timely payment. Okay, sir. Now, the mode of payment, sir, it can be coins, currency, check, or blank transfer. Payment of kind is generally prohibited except with the approval. Okay. Record keeping. You should keep the registers, wage registers, deductions registers, muster rolls, etc. What are the deductions from the payment? What are the employee slips and all should be maintained by the employer. Okay. 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 In case of closure of the establishment, then like within 2 days, you have to make a payment. Okay. Then say for example, you are working in a normal factory and your work will end on 15th day. Like first month of quarter, second month, 15th you are finishing. Then payment should be made within 7 days. 7 days of such completion of work. These are the points regarding timely payment. Timely payment of work. Work day. See, your wage can be like daily wages, weekly, like 2 week, fortnightly, monthly also. It can never be more than a month. Whatever be the time frame you give, daily I'm paying, it's okay. So you work for 6 months, it's okay. Pay 6 installments. Why? Your wage period cannot be more than month. Okay. People okay? No. People, 2 points. That's all. 2 points. We are done with the chapter. Okay. People, 2 points now. One. What are the permissible deductions from the wages? All these deductions. Then exclusively the points regarding fines. What are the points permissible under the law? Thereafter, what are the fines? Okay, some other topic. Important core topic. Oh. Which one? Should be made within so and so. Okay. 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 People, what are the items which I can normally deduct from your payment? People, tell me. Fines can be done. Okay, sir. Fines can be done. Fines can be deducted. If the person has done a damage, then I can deduct that amount. Okay. Third, house accommodation, other related expenses can be deducted. Okay. PF kind of thing you can deduct. Income tax can be like TDS can be deducted. Then, if it's from your salary you are paying something to cooperative societies, that can be deducted. Then, loans like advances can be deducted. Insurance policies can be deducted. Subscription to securities, stock options, those things can be deducted. These can be deducted. These are authorized deduction from the salary. Wages. Okay, good. From the wages, you can deduct all these things. Now, people, simple point. This is a question. What are the allowable deductions from the wages? Okay. Page number, that page, you have to say that box. There's a box where you have points. Now, people, with respect to fines, we have separate points. Very, very crucial points. Okay. First point. With respect to fines, they can ask you what can be the deductions, what are the conditions for deductions with respect to fine. Okay, sir, fines. Let's see. Point number 1. It cannot be, so first thing is you have to apply, you give a notice to the appropriate authorities and get the list of fines. These are the list of fines. Ensure that the notice will properly displayed in the premises so that people will know what are the fines. So you have to draft this thing, give to authority that these are the fines. They'll approve, then display that in your notice board. Now, you cannot charge a person less than 15 years fine. No fine. Now, fine cannot be more than 3%. Very important point. 3% of wage period. For any wage periods, this month is your wage period, your fine cannot be more than 3% of the salary, wages. 1,000 rupees, it can never be 30 rupees. Correct? It cannot be more than 30 rupees. Then you can recover the fine in a maximum period of 90 days. But it can never be in installment. Installment fine recovery is not possible. Like this is like he's saying, sir, no sir, this month I have more commitments because of Diwali and all. Okay, I'll deduct it from tomorrow's salary, next month's salary. Maximum 90 days I have to recover. Now, other points? Fines. Okay, you should have a register where you write the fines and deductible amounts. Then, ensure that there's an opportunity of being heard given to the person before your fine has been charged. Then that's all. Fine shall be deemed to be imposed on the date in which it has been day of the error. Fine is deemed to be imposed on the date for which the error has occurred. I'm charging a fine on 85th day. That doesn't mean that the issue has happened on 85th day. It should have happened 85 days ago. The effective date of effective date of fine is actual incident date, not the date of fine. Correct? Fine can be recorded any days now. But after this month, I'm deducting. That doesn't mean that the issue happened on day 1, day 30. It should have happened on day 1. People online, good. Wages Act, that's all. Some authorities are there, just read and go. Points like some appropriate government kind of thing, those things, small things, just read and go. Okay. People, that's all. We are done with 16 chapters. We have 2 more chapters. One is a gratuity, solid 15 minutes gratuity. Thereafter, another 15 minutes for your first chapter. 15 chapter. That's the last chapter. 15 chapter. Okay, people. We'll take a break. We'll come back. People, tell me that you're okay, comfortable, quick revision. Kind of okay. Okay, good. So people, last part of the marathon, 2 small units, gratuity and labor code. Okay. People, gratuity is a lump sum monetary benefit given by the employer to the employee as a token of appreciation. Like, you have worked with me. You have been part and parcel of my journey. I'll give you something when you retire. It's a retirement benefit given by the employer to the employee called as gratuity. Okay. Now let's focus on something called as gratuity and what are the points to be noted under this act, Gratuity Act. Okay, sir. People, point says a person other than apprentice, okay, will be entitled to gratuity. Okay, gratuity is not applicable for an apprentice. Now, people, okay, simple point, very small topic, very small topic. Okay, now, people, okay. Gratuity shall be payable to an employee on the termination of an employment after he has rendered continuous service of not less than 5 years. So you should have 5 years of continuous service to have gratuity. Okay, sir. Now, people, it can be on superannuation, meaning attaining a certain age, or retirement or resignation, death or disablement, or etc. But 5 years continuous service is not applicable with respect to death or disablement. We can expect him to work for 5 years. That's okay. 50th, mostly 50th. Okay, people, gratuity, it's a lump sum payment payable by the employer to the employee at the time of continuous service of 5 years, like a superannuation, retirement, death, disablement, etc. Fair idea, people online? Fair picture? Okay. Now, people, so how much gratuity is being payable? First point is regarding how much I'll get. It says gratuity is calculated on the basis of continuous service. Let's see what is continuous service. Very important, very crucial part. For every completed year of service or in part in excess of 6 months at the rate of 15 days wages of last drawn, people maximum gratuity is 20 lakhs. Meaning they are telling you what is your last drawn salary, last salary. Okay, into 15 divided by 26 into number of completed years of service or part in excess of 6 months. Meaning I have worked for 7 years and 8 months. I'll get a gratuity for 8 years because part in excess of 6 months carried forward. Less than 6 is just 7. Okay, so that's gratuity. Why 15 by 26? Like 26 out of 26 days, excluding 4 Sundays, you have worked for 15 days. Likewise, the computation. Okay. Now, people, they are telling you calculate if you have done a continuous service. Now, most challenging part of this chapter, continuous service. Okay, sir. People, very important. Very, 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 very important. People, remember, an employee shall be to be in continuous service. Meaning, sir, when will I say that I have a continuous service of 5 years? They say, I am in continuous service, meaning I am in an uninterrupted service. Oh, uninterrupted service. Including interruptions, if any. Including interruptions because of sickness. So, people points. People, law says you should have continuous service, correct? Yeah? Continuous service. In order to be eligible for a gratuity, you should have a continuous service. Continuous service means, sir, means uninterrupted service. Okay, sir. It should not be disturbed. Okay, uninterrupted. So, uninterrupted, sir. Okay. So, what is uninterrupted? Meaning, you should be coming full, sir, full 100% attendance, sir. No. People, we are allowing some allowed days of off. Meaning, you are not working for these days. Still, you will be termed as continuous service. Meaning, example, sir, because of sickness, I took a leave. Okay, it's okay. Sick leaves are allowed. Monthly one sick leave. Still, you are called as continuous service only. Then, sir, because of accident, I took 2 weeks leave. Okay, if it was not an accident, you would have come to the office. I consider that as working as a continuous service only, uninterrupted service only. Then, okay, duty without leave. Then, layoffs, legal strikes, like justifiable strikes. Then, lockouts. So, these things are happening. Meaning, say for example, I have worked for only so and so days. Hey, why no, so less number of working days? You are not in continuous service? Yes, sir, I am in continuous service. Hey, then how low working days? Hey, because of these reasons, you took leave. We call it as it's okay. Still, you are in continuous service. Okay, sir. Okay, sir. So, with these items, we know he is presumed to be in continuous service. Sir, what if because of not other than these reasons, I had to take unnecessary leaves? Meaning some justifiable reason, but I took a maternity leave, which is not covered here. So, you now law says whether you should have a continuous service or not is depend on how many works you've done. Work. So, we said in case of unusual scenarios, let's go with the deemed continuous service, deemed provisions. Deemed to be in continuous service. Okay, sir. So continuous service is nothing but, sir, I should be working throughout. It can be usually normal breaks as explained later. But I have taken other than that leaves, some other leaves. Oh, then you are not in continuous service, not eligible for gratuity. Oh, sir, please, sir. Okay, wait. Law says let's have something called as continuous service in a deemed way. Law is telling you can be called as still doing a continuous service provided based on the parameters. How, sir? Sir, I am working in a place where I have taken extra leaves also. Okay. How many, sir? Sir, I took leave like this. I have, how many days you were present? Sir, for a period of 12-month schedule, like a 12-month schedule. Okay, sir. 12-month schedule, sir. I have worked. How many days, sir? If the establishment demands people to work for 6 days a week, or 6 days a week, or mines, in the last 12 months, if I work for 240 days, I am presumed to be in continuous service. Huh? 6 days. 6 days and mines. Sir, I am working in a place where it's like 5 days work. Then I should be working for minimum days of 190 days. Then it is presumed to be I am working in a continuous service. Sir, I worked for 6 years and so and so months. Ayyo, so and so months you won't get gratuity for 7 years. Sir, I worked for many days, sir. Oh, you didn't work for the whole year. No, sir, I worked for almost 6 months. Almost 6 months, how? Okay. If it's less than 12 months period, like a 6 months schedule, when you want to compute, whether you see whether he has completed 120 days in that 6 months period or 95 days in that continuous service, then law presume that you have worked for continuous service. Meaning, you are having continuous service means 5 years. It can be 4.5, provided 6.5, 6 more than 6 months. Now, to have that, you should know whether I am in continuous service or not. So I took unnecessary leaves. Okay. You worked for whole year? Yes, sir. You took unnecessary leaves? Yes, sir. Okay. You are on payroll for 12 months, but you took unnecessary leaves other than the normal continuous uninterrupted leave. Okay. How many days did you work actually? Sir, almost 240 days I work. Oh, no problem. You are still in continuous work. Sir, but I work in a place where it's only 5 days working. How do you expect me to complete for 240 days? It's okay. At least 190 days you have completed. Sir. My office is less 4 days a week. Okay. 190 days you completed? Yes. You are presumed to be in continuous service. No, sir. 5.5 months only I worked. Oh, okay. That's 6 months period. How many days you work? 120 days. Oh, okay. Now it's like almost 6 months you have done. More than 6 months you have done. You'll be eligible for 6 years. 5.5 is covered 6. No, sir. I am working in particular place which is like a 4 days work only. Okay. Last 6 months period. How many days you worked? Sir, almost 95 days I work. Okay. You are presumed to be in continuous service. Okay. Complicated part is continuous service. Sir, or sir, if I am working in a seasonal factory. Okay. How will I know that where I am eligible? How many work days it was? Sir, I work in a tea factory, sir. Only June, July and August it will work. Okay. Okay. That year, particular area, 2024. How many working days were there? Sir, June, July, August, sir. Total 93 days working. Okay. How many days did you work? Sir, I worked for almost 60%. You are not entitled because in the total working schedule period, you should have worked for minimum 75% when it comes to a seasonal establishment. Then you are presumed to be in continuous service, meaning you will be entitled for gratuity. Okay. So this part is the most challenging part in this chapter. Okay. It will take time, da. Okay. So second point, other than seasonal workers. What is seasonal workers, sir? Seasonal worker, we call it as like it's okay. He should have actually worked for 75% of the total number of working days. So other than seasonal worker, how will I know that deemed to be a working for 1 year period or 6 months period? 1 year period you should have worked for 240 days. If it's a mine or 6 months, 6 days a week work policy, or 190 days in case of less than 6 days work policy. If I am working in 6 months period for computation, I should be working for 120 days or 95 days as the case may be. People online. Okay. Continuous service. Okay. Okay, people. Now, people. Now, let's see the procedure aspects. First point, forfeiture of gratuity. People, because of your willful omission, negligence, causing a damage to the property, I can withhold your gratuity. Similar to bonus. Okay. The person has done riotous or disorder behavior. There also your gratuity can be terminated or withhold. Now, when should I get gratuity? Sir, you think you are able to get, you feel that you need a gratuity, you are entitled to gratuity. Once you know you are retiring, from there, 30 days you have to make an application to the company employer stating that I am eligible for gratuity. Parallelly, if the person dies, nominee can also do that application. That doesn't mean that employer should not have an obligation. Employer should also plan. Once the person is going to retire, you plan accordingly that you are going to pay him gratuity. As soon as this gratuity becomes payable, employer, whether the employer has made an application, nominee has made an application, he will determine the amount of gratuity and give a notice to the person to whom the gratuity is payable, as well as controlling authority that there's a person who is retiring now, I have to pay him. Employer shall arrange to pay the gratuity within 30 days of the amount maturing. Okay, sir. If I'm not paying on time, you have to pay 10% per annum as interest. Interest. If there is a dispute regarding, then let the controlling authority decide whether whom I should pay. Let the controlling authority decide to whom I should make the payment. Okay, sir. Protection of gratuity. People say, for example, very important. Employer has done some fraud. These people, no, court people came. They said, let's take all your property. They took every money. Now, in the employer's cash account, there was some amount stating that 25,000 payable to so and so employees as gratuity. No matter what, the authorities cannot take that amount. Meaning, gratuity amount is always subject to protection. It will be always protected because there's a purpose for which that amount is being kept by the employer for giving employee. That amount should be always protected. Okay. PF also the same thing because statutory obligations are obligations. That's why that will have a protection over other thing. That's all. They have separate rules. That statutory payments is first. Government dues and this PF. This is government dues, PF payment and gratuity. This thing should be done. Law is saying no. Other thing is your contract with the creditor. This is law saying. Law should be given first priority. People okay? Some other points? Gratuity? Some other complicated headings? No. Okay. People online, okay. Gratuity is okay, good. People, last chapter, labor code. People, very easy da. You got only 4 questions. There are 4 codes subsumed under this, different laws combined under different codes. Every codes they can ask you what is code and why such codes. What are the key parameters, key impacts of the such codes. People, ask the. Authorities can claim bonus. எடுக்க முடியுமா? முடியாது. அது anything முடியாது. Bonus, gratuity, any lumps. Okay. திருப்பி யோசி. I became insolvent. Okay. I became insolvent. I employee became insolvent. No money. So I need to pay creditors. எனக்கு வர வேண்டிய காசு இருக்கு from the employer. That can be made application. That's it. Anything, any statutory obligation, anything can be done, recovered. Because இல்ல அது PF ல வந்தது. PF ல தான் வரும்னு நினைக்கிறேன். போனஸ் வராது. PF ல ESI ல தான் வந்திருக்கும். PF or ESI only. வாங்கிக்கலாம். Because being a statute right, I have earned that recovering officer certificate. You apply to a court, they'll give a recovery officer. Recovery officer will get the paper. Insolvency means ஆமா prove பண்ணனும். அப்போ you like whatever amounts are with you, that should be first utilized. ஆமா. So that for that you will go to court. Court will ask them whether this is a normal payment. Get the payment and claim that amount. No. எடுத்துக்கலாம். Now people, labor code. Why labor code? So important to understand, but easy question. People, we have seen that n number of laws which happened from pre-independence, post-independence, 1914, 1923 and all. Now law says, let's have a, how do you think like these people are worker, Uber, Swiggy and all is governed. There should be some laws. So let's have into a modernization. There became very complications, like many labor, many places wages are classified different headings. Apprentice is covered, not covered, many questions. Let's have a uniformity. So what they did, after this particular thing called your GST, there was one norm. What is the norm da? सबका साथ, सबका विकास, सबका विश्वास. सबका साथ, सबका विश्वास, सबका विश्वास. So that was thing. Let's have a GST combined together, having everything put together GST. Similarly, let's have wages also combined under different category. They came with 4 headings. There are 4 headings: code on wages, industrial relations, social security, occupational safety. 4 things happened. Okay. People online, you are able to see. No connection problem, no. Online. Okay. So people, code on wages. People, wages for us people. We have combined different laws under different heads. Now let's see. Yeah, sabka sath, sabka vikas, sabka vishwas. We have. I have given you some features da why simplification, consolidation, standardization, labor coverage and all. We want what are the new labor codes and what are the acts submerged on that. People code on wages similar to your existing topic. Wages Act, Minimum Wages Act, Bonus Act, Remuneration came under one category which is called code on wages. If they ask what are the provisions regarding code on wages, just give that the following four wages are being consumed or subsumed under your code on wages. One introduction sentence. Then, sir, what about industrial relation? You have Industrial Employee Standing Order, Industrial Dispute, Trade Unions Act. Okay, industrial relations. Relation maintain kaga you have dispute, standing order as well as trade union. Sir, what is social security, sir? You have PF, ESA, etc. Okay. Thereafter, for occupational safety, you have Factories Act, Mines Act, Plantation Act, Contract Labor. So pick or 5 laws from or 5 or 4 laws from each topic to get an introduction, proper introduction. Okay. People, these things come under second heading, no? Just see it. Employment exchange, compulsory notification, maternity benefit, building and other workers, cine workers. These things comes under your this category, no? Occupational safety. Huh? Social only. Okay. Employees compensation also. Social. Okay. So this is unnecessary column. Okay, people. Now let's see code on social security. Okay. So pension, gratuity, PF and all. I've given you some points, selective points for the material to read. Okay. So how is code on security, social security being governed? Organized as well as unorganized sector, we are giving pension. Okay, sir. ESI benefits are extended to all sectors, including gig and platform workers. Gig means like new modern things like your Swiggy and all. Fixed term employees eligible for gratuity with no service. There's no minimum service requirement for your gratuity. Even plantation works are covered under ESI. Unorganized sectors, you have an online platform for registration. Maternity benefit with extra crutch and nursing breaks. Employers with having 20 workers must report any vacancies online. These are the points. So you can choose from your existing concept, you have to choose random 8 points probably to know what are your interest should be like, why such law? What are the laws subsumed? What are the main features of this code? Similarly, you have 4 codes, meaning you have to learn 32 points. 8 into 4. They can ask you a question on that. You have to remember that. Now, people, sir, what about occupational safety, health, and working conditions? Okay, meaning kind of a factory act kind of thing. Okay, sir. People, mandatorily you have to give appointment letters to people so that it will act as a proof. Okay, sir. People, you are working in a factory, health. Ensure that there is a free annual health checkups. Maternity leave of 26 weeks and crutch facility in establishment with 50 workers. Okay. People, you have continuously worked for 240 days. Then previously, you have worked for 40 days. Under factory check, they say for every 20 days you will get 1 day off. Now you need not work for 240 days. Just work for 180 days. For every 20 days you will get 1 day off, like paid leave kind of thing. Sir, interstate migrant workers protection has given. One nation, one ration card. People like this. Say for example, people, very important point. One nation, one ration card. Say for example, I come from Kerala. My family is in Kerala. Say for example, one family you get 4 kg rice. For example, 3 kg those people can avail from Kerala. 1 kg I can avail from Tamil Nadu. One nation, one ration card policy extended to migrant workers as well. We are extending that policies for them, kind of policies. Now, code on wages, the minimum wages for both organized and unorganized sector, equal pay for male and female workers, wages must be paid on time. Same, every laws put together under one code. Similar, minimum wages should be reviewed in every 5 years. Same point. People, previously it was minimum wages. Minimum wages is fixed for the entire state, entire country. But say for example, my state and Assam is not the same. Let's keep a floor price also for every state. So minimum wages fixed by the government is 600 rupees. My state floor price is 700. Assam's floor price is 300. Here Assam you should pay minimum 600 rupees. For me you should pay 700 because your minimum wages cannot be less than floor price. Minimum wages cannot be less than floor price. Unorganized sector will also have to get a legal claim for wages. Inspector come facilitators. Inspectors under Factories Act. Instead of having just inspect, they will have a guiding program also. Okay. Now people, industrial relation. Okay. They have defined the worker. Anyone earning up to 18,000 was considered. Previously it was somewhere else 15,000, 1,800. Now it's 18,000. Redefined the employee. Faster dispute resolution. People, we have in the regular class we have seen so and so points from the study material. You can, if that points are free, you can take that also. Order is easy for you. Pick that 8 points. There's a grievance committee. You have strike and lockout. They have separate rules. Job loss support. Like people are losing job. There's some 15 days wages are being credited to their bank account. Appeals for union registration. If you are denying, trade unions wanted to enter into your company. He said no. If they want, they can appeal. Appeal process is given to that. Standing order requirement. 300 workers. Previously, 100. 100 workers, no. Standing orders. 100. Now it's 300. These are the, not everything will be apt to go with the study method, I would say. Remember points 8 into 4, 32 points. Solid. And what are the laws subsumed? If it's 3 laws subsumed, 4 laws, mug up. If it's 10 laws subsumed, just pick or 5 random laws which are subsumed. Go with an exam approach, straight away clear this paper. People, this subject is 40 marks. You can easily score 32, 34. Provided you read from the study material properly, know what is covered, how to approach, why this concept is there. Okay, people, online. That's all, people. It will be fine. Exam will be fine, people. Make sure you motivate yourself. Motivation, self-motivation is very important. Other than company law, probably it will be direct questions only. in this paper. Very direct question. You are setting up business is very direct question. The labor law part especially. So feel free to write. It's not about writing too much. In a company, I would say writing practice is very important. Here, it's not about writing practice. You should know what are the points. Mug up, mug up, mug up. Understand which is easy, mug up. Very important. Keep motivated. Let it be 40 days available. Let it be 20 days available. It's okay. Keep pushing yourself. Only you can do. And remember, people, it's okay to be slow. Unless and until you say, I quit. Okay, it's okay to be dead slow. Happens. And remember, not every day will be the same. You get demotivated at times, it's okay. Always remember why you started this journey. Keep going, it's okay. Why? I mean, why you started? No. Okay. Okay, people, online, you have something else to share? Okay, people, again, all the best. Regular class people, it's okay. No, sir. How many screenshots we are going to take? No, sir. One last time, people. We're done with company law. We're done with securities law. And we are done with the labor laws. And we are done with the revision of labor laws. Okay? Okay, da. This is CS Sooraj signing off. All the best. Come with flying colors. After the results, do let me know that you have cleared. Okay? Everything will be positive. Everything will be happy towards the end. Okay? Trust the process. Keep going. Okay, people. See ya. Thank you.